There's a reason in California that people try to avoid it, and I will talk about some of the ways, even if it hasn't been, affirmatively attempted to be avoided by the deceased person by creating a living trust or using other ways of having assets be distributed at death without probate. There's still ways to get out of the probate area if possible. It saves the clients a significant amount of time and likely a significant amount of legal fees. You, as an attorney, would still get paid. It's a little different of a system. So let's talk about formal versus informal proceedings. The formal proceeding is a probate administration, and that in California, even though it's sort of not necessarily heavily court supervised, you're going to need at least 2 hearings to get through a probate. You need to open the probate, you need to close the probate, and in between, you need to do a bunch of other things that are going to be perhaps submitted to the court, getting the assets of the probate appraised by a court-appointed probate referee, dealing with any claims that come in from creditors, and sort of dealing with beneficiaries and doing certain forms that have to be done if you want to sell certain assets, especially real estate. If you can avoid that, it's better for the client. Client gets their funds sooner. So you want to try to look at the informal proceedings. These are largely in the California Probate Code, around the 13,000s, 13,100 and on. And starting with that most basic one is what's called the 13,100 affidavit. If somebody comes to your office and says, my parents just died and they had a house, but that was in joint tenancy with me. So that, if it's joint tenancy, it's right of survivorship. So let's say mom owned the house and daughter comes in and says, my mom died, I think I need to do a probate. And you look and you see, well, the house is in joint tenancy. That does not require probate. That passes entirely to the daughter on the death of the mother. You have to record an affidavit of death of joint tenant, but no court needed. Then you look at the other asset, and let's say there's only one other asset, which is a bank account of $150,000. And it's in mom's name, and there is no beneficiary designation. So it's not what you call a POD or a plan death account, or sometimes called an ITF account in trust for, or what they called in law school, I think, a Totten trust. So you can't just go to the bank and say, look at the account document, I'm daughter, can you please pay it to me because mom died and here's the death certificate. It's not that exact because there's no beneficiary designation. But what California law says is if you're under $188,000 and there's no probate proceeding pending, third parties are allowed to pay the beneficiary without a probate. So if your daughter can say truthfully that she's the only heir, she's the sole successor to mom's assets, the only assets that are outside of any joint tenancy is under $188,000, and assuming that bank accepts the document, you can create for a 13-101 affidavit. She has to wait 40 days to get the property. She has to have a death certificate. The affidavit has to be notarized. But this is a way of not troubling the client with a small estate that's going to, at some point, each estate has the same amount of work, whether it's a $200,000 estate or a $2 million estate. With a $2 million estate, the fees are better spent because more assets are gathered. A $200,000 estate is not as economical. And so the California law said, we'll give you up to $188,000 to do this small estate affidavit. The challenge is to get the third party who has money to give it to you. Sometimes banks don't understand it. They think sometimes the value is lower. This has recently changed. It was $166,000. Now it's $188,000. And again, if you're going to do this, if you're going to do this kind of work, you're going to need a written fee agreement saying, I'm going to help you, resolve the affairs of your mother short of a probate. And when you do this 13-100 affidavit, you may want to ask the bank, well, do you have a form because invariably when I use my form, the bank says, oh, that form's no good, and their form has an extra comma in it or something. So that's informal proceeding number one. And remember, it's very restricted because the affiant, or in this case, the daughter, has to state under penalty of perjury that there's not more out there than $188,000. And oftentimes I get people call me and say, well, there's like 3 or 4 bank accounts, and there's Bank of America, Wells Fargo, and Chase, and each one's under 150, but together there's a lot more. To try that, in that case, you would have your client not be telling the whole truth. Bank of America wouldn't know that there are more assets at Wells Fargo and Chase, but the document you're signing, or you're having your client sign, is saying the cap, the ceiling, is $188,000. So again, not going to work in all cases. There is a small real estate affidavit procedure, or it's a court claim procedure that's very rarely used. It has to be real estate valued at under $100,000, and that's under $100,000 gross, not net. I remember my friend tried this because he represented a decedent's mother came in, and the house was, worth $600,000, but had a mortgage of close to $550,000. So he went and tried to do this small real estate claim procedure. He got it appraised, and the court rejected it because they said, no, the equity doesn't matter, that it's only worth $60,000. It's the gross value. So with real estate, there is a $100,000 procedure again in the 13,000 of the probate code. It's very rare. It's usually used if clients often will have vacant land that somehow is not part of the trust, if they have a living trust, or if they have all their other assets in joint tenancy, beneficiary designations, you would collect it by that. You can't do a 13-100 affidavit with real estate because there's no third party holding the land. You have to get an order from the court transferring title from the deceased person to the heir or heirs, or whoever gets it under the will if there is a will. So those are the sort of, 2 informal proceedings that you have for individuals who are not spouses: small estate affidavit and a small real property sort of mini probate filing. But even the mini probate filing for real property is involved. You have to get the property appraised by a probate referee first, and then submit an order. And that order that you get distributes the property out to the heirs. So I have one now where, let's just say the heirs don't get along so much. So I did a full probate, even though this was just $100,000, just shy of $100,000 parcel of real property. And the judge said, why didn't you do this as a small, under 100,000? I said, the problem is, Your Honor, that just feeds it to the 4 heirs, and they're not on the best terms. So they appointed their kind of business person manager to be the administrator. He's going to sell it, and they'll take the proceeds. So even the informal proceeding in that case only works to do a formal distribution, and then the heirs, if they want to, have to sell it, which may be more difficult than just having an administrator sell the property. The one real way to beat probate is if you're representing a surviving spouse. And California Probate Code, in around 13,500, gives a surviving spouse ways to take the inherited assets that she receives from a spouse without probate. Now, remember, if a surviving spouse comes into the office and they show you the deed, and the deed is in joint tenancy, or the deed is in community property with right of survivorship, those are both kind of the same thing, and neither of them requires any probate to get the asset to the surviving spouse. It is simply an affidavit recorded with the county along with an original death certificate, and now your surviving spouse has complete title without probate. So that's joint tenancy and community property right of survivorship. If the asset is in community property, and let's go on branch number 1, the decedent died without any will or any estate plan, what everybody calls intestate, meaning in Latin without a will. If the property is community property and there's no right of survivorship, there is a provision in the California Probate Code. It's 13640. And I've only been able to use it a few times. Well, what it says is if a spouse, if there's 40 days have passed since the death of the decedent, and the surviving spouse is willing to say, I'm the sole heir, it's all community property, it passes to me, she can record that with a death certificate, and the community property passes without probate, even though there's no right of survivorship. The problem with that is your really audience there is a title company. And what usually happens is the surviving spouse comes to you, in this case, has come to me and said, my husband died, I want to sell the property. And I looked at it and it says in community property, said, listen, I'm going to be on my best behavior and be really nice. I'm going to act really phony right now. Let's call the title company who you're going to deal with or through your real estate broker and ask them, will they accept this affidavit to give you, surviving spouse, clean title to sell the house? And if the title person says yes and confirms it in writing, then I prepare that affidavit. Have to wait 40 days from the death of the decedent, but that avoids any need for any court time or any procedure. Just basically the same as an affidavit for survivorship. It's very rare that happens. Usually, if clients have their assets in community property, they usually have a will or a trust or something that takes care of it. Generally a trust, and you can get it into the trust by means of what they call a headstead proceeding, saying, oh, they just didn't transfer into the trust, but look, it's listed as an asset of the trust on a schedule to the trust. The more sort of formal, or the most formal of the informal proceedings is something called a spousal property petition. And this is in 13650, and this is a really important thing to know about. What 13650 says is that the surviving spouse can elect to claim her share of the decedent's assets without probate, but it only applies to what the surviving spouse receives by way of intestate distribution. So if husband had community property, and for whatever reason that affidavit procedure doesn't work, and the deceased spouse died intestate, 100% of the community property belongs to the surviving spouse. The 50% she owned during lifetime, and the 50% that comes from the husband by the intestate distribution. She can go into court and say, and it's a judicial counsel form, DE 111, and you list certain basic jurisdictional facts, where the husband lived, when did he die. There are certain factual allegations you have to make regarding community property. Notice has to be given to any children or other heirs of the decedent. So if this is a second marriage and the children are going to be upset to see that everything's going to the surviving spouse because it was held in community property, they're going to get notice and they may try to do something to object to that distribution. But that petition is filed, and the goal is, and what you would get is, you would have a court order stating that all the assets of the decedent as listed in the spousal property petition are deemed to have passed and are ordered passed to the surviving spouse. And you get that order, you record it for real estate. If it's not real estate, if it's a bank account, you take it to the bank, and it now belongs to the surviving spouse. If there is the bank account, you take it to the bank, and it now belongs to the surviving spouse. If there is separate property, so for whatever reason, the spouses held separate property, depending on how many children the decedent had, goes either 1/3 or 1/2 to the surviving spouse. So let's say deceased spouse dies intestate, and there's real estate, there's bank accounts, and the family says, well, I guess we have to do probate. And the surviving spouse says, I really, want my share now. Is there any way to get it faster? She can go in and do a spousal property petition and take her share out of the probate world. The kids can get their stuff through probate and they have to wait. But she, as the surviving spouse, has this special procedure to get the assets faster and without probate. A spousal property petition is one and you're done. You don't need to do an inventory. You just file the petition and you get your order. One thing to be mindful of, and there's a special code section in the 13650s, because you're not doing a probate administration, your fees are not calculated, we'll get into this today, as part of any probate-based assets on which you earn a commission. So that's in the code section. I think it's 13640, or maybe 135. I think it's 13540. It's in the that section. It's called the affidavit procedure, and it mentions 40 days. And like I said, many people don't know about it. I was tipped off to it a few years back by a title officer who said, you don't need to do a spousal property petition. I sort of doubted that person, and they were right. So there is a way to do it, but it's short, a big shortcut, even to the shortcut of a spousal property petition. Again, the spousal property petition is not a probate. So your fees as an attorney are pursuant to a private agreement. So if you do $1 million house as a spousal property petition, and you might be really kind of excited because you look at the probate fees in probate code section 10810, and on $1 million estate, you are entitled by law, regardless of what work you do or not, to $23,000. You may say, oh, great, I'm going to get making $23,000 for one court appearance and a petition. That's not how it goes. You cannot come into court and say, I want $23,000. There's no fee base because there's no inventoried assets. Rather, it's the subject of your private agreement. So most people will do this for a fixed fee because it's kind of like you don't know what's going to happen. The court may have questions, and the surviving spouse may not be willing to do it hourly, or you just prefer to just say, you know what, I'll take the risk if I have to and do it for a fixed fee. But you've got to get that in writing in a private agreement. You can come back to court if they won't pay you, and the court can award you what is reasonable compensation. But in the first instance, you want to have a written agreement, because if you don't, you have to go to court, and the court determines what's reasonable. So if you're going to do a spousal property petition, think in your mind, I've heard people charging anywhere from $5,000 to $10,000 to do a spousal property petition. It depends on how many properties there are and what other work there is. The other part of the spousal property petition, which is the most fun, is not only can the surviving spouse ask for assets to pass to her surviving spouse, but can ask for a confirmation of community property status. So let's say, and this happens quite a bit, I think I've done probably 5 of these in the last 5 years, where the husband and wife want to buy a property. It's during the marriage, and one of the spouse's credit is not good or non-existent. And so the real estate agent, whose most important job is to close the sale and earn the commission, lets them know that, you know what, the property is going to have to be owned just by wife. And she's going to take title as wife as her sole and separate property. And husband, you're going to have to execute a quitclaim deed saying, I have no interest in this property. And the reason for that whole process is so bank can lend to wife alone without husband's lousy credit. And sure enough, the real estate agent will say, because the spouse who is doing the quitclaim is saying, hey, this is a little unfair. We're married here. What happened to community property? the real estate agent will assure you, oh, don't worry, after escrow closes, you can fix this, it's real easy. I'll even help you do it. Escrow closes, the broker gets the commission, and nobody does anything. And now when the decedent dies, it's separate property. And if that decedent has no will, well, the surviving spouse, at best, if the deceased spouse has any issue or even any sort of collateral relatives, is to get 50% of the family house. So that means that the deceased spouse dies, husband only owns 50% of the house, the other heirs, which might be wife's children from a prior marriage, own 50%, they're going to force a sale and he's out. In the spousal property petition section, you can ask, and on the petition itself, you can ask for a confirmation of the character of the property. And California case law is rich in determining that what is listed as separate property, so long as it's acquired during a marriage, it's actually community property. There's a very good case from 2021 called the State of Wall that goes through all the different presumptions, because when the deceased spouse dies, well, if it says it's separate property, that's the title presumption. That's Evidence Code 662. And that means it's separate property. How can it be community property? Well, there's another provision of the family code, that's 760, that says all property acquired during marriage is presumed to be community property. So now you have title presumption on one hand, community property presumption on the other hand. In, I believe it was 2020 or 2021, the California Supreme Court said in a case called Brace, they said, you know what, when it comes to community property and all that, we're going by title. You can't use the presumption to overcome title. Comes this case of State of Wall and says, yeah, but there's one other presumption, which is Family Code 721, which says when husband and wives transact business together and take title during a marriage, if it's taken as anything but community property, there is a presumption of undue influence, and that the person who had to give up a community property a community property right was taken advantage of. So I've been successful, often had to settle against objections by children from a prior marriage, but getting the house confirmed as community property, meaning that even though it says separate property, it's community, and it all passes to my client, the surviving spouse. So the spousal property petition even can be used as an informal way of litigating rights in a decedent's estate. So you want to become very familiar with spousal property petitions, because it's a good shortcut, and it's, I tell you, it's a lot easier than a probate. Okay, there's a lot less forms. It's a petition, an order, and you're over. And clients are thrilled about it because they hear probate and they start, conspiracy theories abound. And if you can get them out faster, and even better, if you can get a surviving spouse to succeed to the entire asset because it's community property and it's intestate, you'll be the hero, because most likely that's what was intended. This is a second marriage, but of some very long length. There's no connection with the children from her first marriage, and it was only in separate property because of the convenience of getting a loan on the house. In terms of sample letters of authority, in California, all letters of authority are on a judicial counsel form. It's an all-purpose kind of one form. It's either letters of administration, letters testamentary, letters of special administration, or letters of administration with will annexed. Let's go over those four different ones. In the most basic event, if a decedent has no will and dies intestate, your client is called the administrator, and the court issues what's called letters of administration. It's issued by the clerk, at least in Los Angeles County now, which is amazing that it's gone so modern, so fast. I think COVID had a lot to do with this. These can be docu-signed, PDF signed, and submitted directly online. So you have your probate hearing, the court appoints your client as administrator, your client signs letters, and you e-file them and you get them back stamped. You can buy a certified copy if you need certified copies. Often banks or title companies will have them. but you no longer need to, and I don't think you even can bring a wet signature into the clerk to get them issued. It's all done electronically. So that's administration. If the deceased person had a will, but let's say they ran out of a named executor. So a will names, my son is executor, and let's say the son died before dad, and then some family friend is alternate executor, and that family friend says, you know what, I don't want to get into all this family fights too much. So then one of the children comes in and says, I want to administer the estate. That child is not named in the will as an executor. That child is called an administrator with will annexed, or sometimes administrator CTA. I'm not sure what CTA stands for, but that's the sort of next level, distant from a pure intestate situation. If you have a will, but you don't have an executor named the will to act. Finally, the higher one is letters testamentary. That goes to a named executor in the will. There is, I don't know of any difference between letters of administration, will annexed, and testamentary in terms of the powers of what's called a personal representative. That person can act. Nobody asks, well, where you name the will? Nobody cares. Once you have your letters, they don't question how you got there. So those are the three types. Then there's something called letters of special administration. Probate can take a long time to even get started. So in LA, if you file a probate petition today, September 20th, you're not even getting a hearing until October 21st, till 31 or a little bit more days out. And sometimes, depending on what department you get assigned to, much more. In the meantime, there may need to be a business run. There may need to be rents collected. There may be cars out there that need to be, taken away from where they are. And so you can ask for, on an ex parte basis, letters of special administration for your client to be appointed special administrator. And that special administrator will have only certain powers. It's usually not the full powers of the personal representative. They're usually power to collect rents, power to marshal assets, can't make any distribution. They can pay bills. So it's like an interim step to manage the estate in the interim. And those are called letters of special administration. And then what's kind of a pain about those is, and I have one now, kind of why I hate probate, where I had a case where the daughter, came to me. I did the petition for probate, and we realized that there were going to be some problems with the father's wife, and there were other problems with the father's first wife, and my client needed authority, and I filed it. And then in advance of the first hearing, so I filed the next parte petition for letters of special administration. I got it back approved. Before the first hearing, we all kind of sat around this very table and kind of had an agreement in writing, and everybody changed their mind. So at the first hearing, the court said, well, do you have a deal or not? I said, unfortunately, we do not. So the court said, okay, we're not going to appoint anybody today. We're going to continue this so everybody can file objections to the first petition for letters of administration. We're going to extend the letters of special administration until the next hearing. So you don't get cut off by continuances. And you want to, when that happens, you want to file new letters that the court will say, because the judicial counsel form says it expires on. So if these letters expire today on September 20th, and the court continues the hearing until December, you want to file new letters that say, these letters will expire on December 20th, 2023. In terms of your first meeting with, the personal representative and the family, I don't think this is taught in law school. And I kind of had to learn it, the hard way. People are grieving. You are all about business and getting things done. And there are deadlines to meet in probate. I mean, you have to file, if somebody has a petition, a will, they have to file that for probate within 30 days. So the grieving process is not over in the first 30 days, but you have work to do. And if you don't do the work because the client is grieving, someone's going to blame you. So yes, in the first meeting, you have to take it slow. And, you just have to be kind of sort of a grief counselor in a way. And, I've had clients who've had lost people in their 40s and lost, parents over 100 years old, and they're both kind of in grief. And I said, oh my gosh, over 100, your parents, that's amazing. I mean, I had one now, the guy remembers growing up in the Depression. He was born in 1922. He died just in April. And people are, I was heartbroken because he was a great guy, but he was 101 years old. You have to sort of be, take a step back from being sort of a clinical taskmaster of probate and, kind of give them time to breathe. And I don't know how to sort of get in between the place where at some point you have to move the estate forward, but you also have to be kind of, sympathetic. At some point, sometimes I just say, you know what, we're not going to decide anything today. You'll come back in a week. Let's just talk about what you need to do for grieving. Is there still funeral arrangements, anything like that? We're not going to make any decisions today. The one decision you need to make, though, at the outset is determination of heirs. When you file a probate, you have to give notice to everybody mentioned in the will if there's a will. So even if somebody's mentioned as a third alternate executor, they're listed in the probate petition, and they have to get the notice by mail of the hearing. This is usually done through the newspaper who publishes the notice of administration of the estate, and any heirs. So this means if a child was cut out, you have to find out who that child is and send them notice. Otherwise, your petition is not going to get anywhere because the court's going to say, what happened to this child? Because most wills especially will say, I have 4 children, and the will might just say, I leave nothing to child number 4. Well, child number 4 has to get notice of the petition for probate. What's more difficult is when somebody dies intestate and their affairs are kind of like, not really put together. When you file that probate petition, you need to find out who their heirs are. And if they don't have a spouse and there's no issue, you're starting to go up like a family tree, kind of crazy. I had one now where I kind of, didn't think about it, but I took over for another lawyer, and he had found 2 heirs on the mother's side. This was the father's side. This was the man died, no wife, no children, had an aunt and another cousin on the paternal side. I took it over after the petition was filed and approved just to sell the real property. And I didn't realize and didn't think, well, did anybody look for heirs on the maternal side of the family? And sure enough, as we were going to close the probate, an heir hunter showed up and said, hey, you never gave notice to these people in Canada. And my client said, I don't believe that they were for real. And we hired a private eye, and they were for real. And we had to close the estate. My clients, who was the heirs, they received a significant less amount of money. They were supposed to each get 50%. They each only got 33%. That can make a big difference along the way. When you're talking about $1 million, that's $150,000 left. And they kind of got, the rug pulled out from them. Your job is at the beginning to get that family tree right. You may have to hire a private investigator. I have a case now where the man left everything to 7 charities. He was married, had no children with the wife. He was an only child. His parents are deceased. And my client is his kind of girlfriend. She's getting nothing from the estate. She doesn't want to be paid for her work as executor. And she's telling me there's nobody. I said, we have to find. So I've hired a private eye. He's supposed to get back to me this week to find somebody. Or I have to at least do due diligence and say we looked as hard as we could. I remember one time about 15 years ago, there was an estate where the man died. He was divorced, no children. He was adopted. And he was the only adopted child of his family. And the family had nobody. And we hired a private investigator. This was 15 years ago before the internet. So you really couldn't find people as easily. And I said to the court, you know what? There's just no heirs. And the estate's passing to my friend who was named as the executor and charity. And the judge said, okay, you've done your due diligence. I'm going to determine that notice was sufficient. But you have to make that effort to get that determination of who the heirs are. That's on you. They're not going to know. Client is going to say, oh yeah, I have a list from you. And then if you're involved in a probate where there's multiple generations, you're going to have to attach a family tree to the petition. So you're not going to be able to say, oh, well, there's, first cousin and then two second cousins. You're going to have to explain to the court how that is. I remember I had a state a while ago where gentleman died and, no children, but he had, I think it was like 12 or 14 first cousins and first cousins once removed. And, just to give notice in that case, it was like 20 envelopes. So it is what it is. You have to give notice to the heirs and you have to determine who they are. Now you can kind of make some progress on your own if you have these, private databases, but I think sometimes you just have to go to a private investigator. They have their ways, which I don't want to know how they get their information. I just know that they can get it. In terms of written fee agreements, I always get a fee agreement with probate clients. Technically, I guess you don't need one because you have a right by statute to your fees. Probate Code 10810 sets forth two types of fees in probate. There's what's called statutory fee, which is for your routine work, and that's based on a schedule. And it's $23,000 for the first million. It's $4,000 for the first 100,000, $3,000 for the next 100,000, and 2% up to $1 million, and then it's 1% thereafter up to 10. It's not that significant in a way. If you do a $25 million probate, you might think, oh wow, this is enough for 10 years for me. But the statutory fee is only $188,000 on a $25 million probate. On a $1 million probate, it's $23,000. So basically, you'd rather have 25 $1 million probates than one $25 million probate. You'd make a lot more money than the statutory fee. Separate and apart and over and above your statutory fee, if you render extraordinary services, sales of real property, assisting to run a business, litigation, tax work, you can ask for extraordinary compensation based on an hourly rate. Now it's tricky because what the court says is, well, wait, this is a $3 million estate. Your statutory fee is $43,000. You're asking for $40,000 in extraordinary time. How is it that the statute wasn't enough to pay you? And so I keep track of all my time, and I am able to show the court saying, look, my statutory fee was fully used by my time doing inventories, giving notices, completing the regular petitions, and all my extraordinary time based on time records are for work on the litigation, dealing with escrow, dealing with the broker, all that thing. That's something that might be worthwhile to have in a written fee agreement and say, listen, you're hiring me as counsel of record for the estate and the administrator or executor. For my hourly rate is $400. I will be bound to accept the statutory fee only for ordinary work. For extraordinary work, I'm allowed to petition the court for my $400 an hour. Anybody can object. And what's most important to understand in probate is you cannot be paid without a court order. And a lot of times there's a temptation and the clients want to pay you. I was in court the other day and a $600,000 estate closed, and the heirs needed the money. There was not a lot of money coming out of the escrow because the property was encumbered. So the escrow statement showed, to the heirs, $75,000 each because there was a little more than $150,000 in equity, and to the lawyer, $13,000 in statutory fees. So the attorney collected it before going to court and praying for it as part of the petition with a court order authorizing it. And the judge just absolutely tore into the gentleman. The guy said, look, I put it in my trust account. I'm not going to see it until the end. And the heirs just needed their money because they were, running out of money. And so I did all this without a court order. And the judge says, good, because you're never going to see your fees. Now the judge kind of toned down and let the guy make amends. And I remember at the last hearing, he said, you know what, I want you to give $1,000 of your fee to charity because you really did something wrong here, but you were very good about it. And the attorney right there wrote a check out. I forget to what charity, but literally he wrote a check there. So you have this written fee agreement. That's a good idea to have, but you cannot collect fees in probate until final, either preliminary distribution with an order for fees, or usually everybody waits till the final distribution to get fees. Separately, you can ask for fees in advance of the closing. So having a written fee agreement is a good idea, but you kind of look at it in front of your wall, because until you get a court order, you're not getting paid. But it's a good idea to have that, especially for your extraordinary fees, to set your hourly rate in advance so people know what's coming. So I get a fee agreement. I know a lot of probate lawyers do not. Locating information using online and government resources. You kind of have to be a bit of a sleuth. It's kind of fun. First of all, and what you can do after this speech, if you want to make some quick money, is you go to the California Controller's website. If you just put in your search engine, California unclaimed assets. California must have like billions of dollars. I still have some, like I think like $50 to $100 in dividends. I'm just too lazy to collect from something I got from like when I was a kid. Somebody gave me some Bank of America stock. You may be surprised that your decedent has significant unclaimed assets. I've collected assets of over $50,000. If they're small, it's real easy. You just type in and online you get a check. If it's more than a certain amount of money, there's a form you have to give, driver's license, death certificates, a lot of information collected. There are services out there that charge, they're called finders, that charge 10% to do this. It's really kind of use a non-diplomatic word, a ripoff, because it's maybe an hour or two to fill out the work. So if you're talking about somebody who has a $25,000 asset out there, for somebody to charge $2,500 for an hour to fill out a form is a little bit expensive. So that's one thing. Second of all, you should have some way of determining how the client owns real property. I have a service, it's called datatree.com, where I can look up an address and I can pull what's called the vesting deed and see who owns the property, the last document recorded on a title, and you can go back and get prior deeds to see how it got there, because a lot of times your client who you think owns the real estate actually does not. There are local records in Los Angeles County and other counties at the county assessor. And what the county assessor is, they're keeping track of all recorded documents. And if you see a recorded document that maybe didn't come up in a title search, you want to know what happened there. And that county assessor may have noticed a discrepancy that nobody else noticed. Other government resources, you can, upon somebody's death and your client is appointed the personal representative, you can write to the IRS and obtain the decedent's past tax returns. That will tell you what kind of assets the decedent owned, where the bank accounts were, because the bank accounts report interest to the IRS on 1099, and that's then put on the tax return. In terms of other government resources, you're going to have to, when you're appointed, when your personal representative appointed, you have to write a notice of administration letter to the California Franchise Tax Board. And if your client was a Medi-Cal or Medicaid benefits recipient, you have to write them a letter. You can actually get, the personal administrator can find out if there is a Medi-Cal claim, meaning the decedent received benefits from Medi-Cal. Medi-Cal keeps score. And if there are probate assets, Medi-Cal has a lien against those probate assets. You can get a tally of what the client owes to date from Medi-Cal, going, from the beginning of time till now. You can also, kind of look through, obviously, the decedent stuff. That's not online or government resources, but a lot of times clients will tell me, oh, there's some other things, but you don't need to see them. I think I do. And they'll bring me stuff and I'll look, and there are shares of stock that I have found. A lot of people, it's not a very easy company to deal with. Shouldn't say anything incorrect, but there's something called CompuServe, where for a long time, people would buy, rather than going to a brokerage and buying stock through a Schwab or a Merrill Lynch, they'd buy the stocks of the company, and the company that kept track of all this, where you stored your shares, was something called CompuServe. And CompuServe was like kind of antiquated. They've come full circle. They're very modern now, and they're easy to get a hold of. But you wouldn't know about the CompuServe shares because the only way to know is either a statement from CompuServe, or in the old days, people would actually have their share certificates and hold them. The other thing that is a major pet peeve bordering on neuroses is safe deposit boxes. And I think that they're just the worst idea. First of all, you're not supposed to keep cash there. A lot of times I will go to a safe deposit box and we'll find $20,000 or $30,000 in cash. Because I'm sometimes serving as a neutral administrator, and I just, have to sit there for about 20 minutes with my head in my face saying, oh my God, because when you find that type of amount of cash, if it's more than $10,000, your client needs to deposit it into an estate account. And because it's more than $10,000, they have to file a currency report with the bank. I don't know what the IRS does with that currency report, but I know that my name is on at least 3 where I have found cash in safe deposit boxes of more than $10,000. And I just, I'm befuddled by it because it doesn't earn interest. And I don't know, whenever I see these movies about bank robberies, I assume they can get into safe deposit boxes. Maybe they can't because they have to drill into it. So you want to find out if there are any safe deposit boxes. Again, so you have to do this kind of sleuth. When you find the bank statements and you get your letters, you need to tell your client, hey, can you ask the banker, was there a safe deposit box tied to their account? If they are receiving Social Security, you have to notify the Social Security Administration to turn that off. There may be benefits available to the spouse, but if you try to collect them afterwards or you get it, you have to return the check. Usually the mortuary notifies the Social Security Administration and turns those benefits off immediately. Really what you need to do is once your client is appointed, you basically need to make a balance sheet for the estate, because one of the things that talk about today is filing the inventory. This is like the one document that even in the least court supervised estate, even if you're going to have what's called a waiver of account and nobody wants to know what the executor did, it's a trusted son or daughter and they're the lead person, they're not being asked to do an accounting, they must file an inventory, and that inventory is important for a lot of reasons. First of all, it is your fee base as an attorney. So if you have a probate and you say, oh, we'll just inventory the house. I said, we don't want to deal with the cash or too much information to get you all the stocks in the account. Well, no, because if it doesn't go on the inventory, you can't get paid based on it. Separately, if it's not inventoried, it can't be made the topic of a petition for final distribution. So very early on in the administration, and if I'm doing a first meeting and the person is up to it, I kind of go and try to make an asset sheet for myself. So I remember, what are we going to have to do? Which banks, which businesses does the client have an interest in? LLCs, partnerships, brokerage accounts, and real property. And assemble that and keep that handy by your side, because that's going to be how you're going to get to do a probate inventory. And again, whatever you can do to find this information. I know that I have a Westlaw and Lexis. There is sort of a public record search. Whenever I've tried to use it, it doesn't work. It says, are you using this for any legal purpose? I said, I'm not going to disclose that. And I'm not sure if it costs extra or whatever, but at some point you kind of have to know that you got everything, because it can be difficult after a probate closes to try to collect additional asset. It is possible, because when you do a final probate order for distribution, you state these are the assets being distributed, this bank account, this real property, and there's a clause at the end that says any after discovered property goes according to the terms of this order pursuant to the will, equal shares of the kids or charities and the kids or whatever. But then you have to get your client reappointed. The letters have to be reinstated to collect those assets. So you really want to try to, assemble all your assets. There are oftentimes, assets that are found in the middle of a probate. I mean, the worst case is when you're doing an estate tax return, if the estate is big enough, and you file what's called a Form 706, and then during the probate, the client says to you, "Oh, I forgot to mention, but mom had this bank account and she kind of kept it separate from all of us, but it's $500,000. And so if you haven't closed the probate yet, well, that's okay. You can simply do a supplemental inventory to add it to the probate estate. But you now filed an estate tax return, and your client has said under penalty of perjury, these are all the assets. You're going to need to file a supplemental 706 listing that asset. And because so many 706s are audited, that never looks good. So this job of gathering all the assets and making sure everything is there is important to probate, because you want to have everything inventoried correctly. So when you finish the probate, you've taken care of everything. But it's super important if you're doing any estate tax return work to go through and find everything. Ask the accountant, ask the gardener, anybody to be sure all the other assets, because you want to get it all in there. And the first question, if you do an estate tax audit, the IRS asks you, are there any other assets out there that you didn't report? And so if you think you're going to be clever saying, well, you know what, we won't supplement the estate tax return. And maybe, the audit lottery is favorable, people think, and we won't be audited. The fact is, estate tax returns that pay tax, not what's called a portability on a first death return, those are audited like 1 in 3. So those are not good odds to have to answer the question when the IRS comes to you and says, are there any additional assets? And you say, oh yeah, there's a $500,000 bank account. Now the IRS agent who's auditing the estate is not going to be necessarily the friendliest person, because they see this all too often where people try to conceal assets. And they are very professional, the IRS agents who do Form 706s, but they have a job, and it is to collect revenue. And if they sense that there's some kind of lack of disclosure, you're starting off in the wrong foot. Many of them are very friendly. I've done business or done estates with many of them before, and they're very patient, and they're reasonable. But the worst thing is to omit assets, either from a probate or certainly from a Form 706. In terms of dealing with multiple states, this is something you can try to avoid, because it's never a straight answer of what happens. The book answer is, if your client dies in California, okay, but for whatever reason they were renting in California, they didn't own any real property here, and they own real property in New York and Texas, you have to open the probate here. That's the primary state. And that California, under Civil Code Section 946, California controls everything but real property in another state. So even if the bank account is in Michigan, because that's where they're from, but they moved here and the decedent had his permanent residence here and he dies here, you can get California letters and you can go to the Michigan bank and say, transfer these assets in the name of the decedent to the California estate of the administrator. And those assets are bound by California law, because it's called in Latin mobilia sequitur personam, movable goods follow the person. So even though the client may have assets that are not real estate in multiple states, the state of residence governs. If there's real property, that rule does not apply. But what you have to do first is you have to open your California probate, get your probate personal representative appointed in California, and then take those letters, find an attorney in the other state, and do what's called an ancillary probate in that state. So now in New York, your client is appointed executor in New York as the administrator of an ancillary estate. She can sell the property in New York and then transfer the funds, close the probate in New York, and transfer the funds into California. but you're gonna need two probates. Now, I've seen it done where people are able to go to the foreign state and without having a California probate open for the state of residence, do it only in the state where the real property is located. If you can do it, you know, okay, I'm not gonna say anything, but by the book, it seems like you need to have a primary probate in the state of residence. The other way around is you may get a call from somebody saying, hey, I have an Arizona decedent. They owned a home in California. What do I do? Now you are going to represent the ancillary administrator in California. And we tell the person in Arizona saying, look, unless I get away with it here in California, you need to get your client appointed in Arizona as personal representative, get me an exemplified copy of their letters, and then I can petition in California for ancillary letters. But I don't think, at least by the book, because of the way the probate form works, is you have to allege that either to get probate in California, either the person died here and then you have jurisdiction, regardless of where they had assets, or died a resident of another state with real property here. And if you don't have a resident here, the court should ask, saying, wait, how are you being appointed administrator here? Where's the person in Arizona who has primary responsibility for the estate? So dealing with multiple states is tricky. It makes probate much more time consuming. Dealing with ancillary state here is, I guess, not a great way to fame and fortune, because you don't really get much responsibility as an attorney. You're dealing with a single asset. I do, one every couple of years, and it's, a little bit painful because I'm dealing with the lawyer in Washington or in Texas. I'm being told what to do, which I don't like being told what to do. And just for a single asset, and then you're really done. It's really truly a one-off assignment. Sometimes you'll do a probate and you'll do such a good job for the person, they'll come back to you. And if you do the estate plan, they'll do the estate plan with you. But my ancillary clients that I've done ancillary probate before, sometimes I don't even meet them. Thank God for Zoom, I wouldn't know what they even look like. And you never see any more work from them because they're not coming to California for any reason other than maybe the weather. If there's no other, I have about a minute to go. Any questions on this topic? Okay, I'm not hearing any questions. So let's sort of, now we're through the the door. Now we're into the world of probate. The first thing you need to do is really become somewhat of an expert on the laws of intestacy for two reasons. One, not so important, and one more important. First is you really need to know who a decedent's heirs are. And the decedent's beneficiaries under a will can be different than their heirs. And their heirs need to get noticed. So, woman dies, no spouse, no children, and just, nieces and nephews. And she leaves her assets to friends and charities, no family members. And you might think, okay, all I have to do is give notice to the people named in the will, because that's what the form says. And the heirs, well, that's the friends and relatives and all that. That's the same thing as heirs, beneficiaries or heirs. Well, that's not the case. Heirs are certain blood relatives according to the California laws of intestacy, which start in Probate Code section 6400. You're going to need to find out who the heirs are, and you're going to have to remember some terrible terms from trust and estates like prosterpes and right of representation. And you're going to have to know how the laws of intestacy go. Basically, they go first to spouse, then down to issue. Sometimes it's spouse and issue at the same time. If there's no spouse or issue, it does not go across yet, it goes up. So oftentimes you'll have that, hey, you'll have a parent inherit assets from a kid. I don't think a parent is looking forward to it, but that goes up first. If parents are deceased, then it goes across. By the way, half sisters and half brothers take in the same manner as full brothers. If the sibling is deceased but leaves issue, those nephews and nieces take in the share of the siblings. Now, they may get less than the sibling. If there are 5 siblings, those are the only only relatives of the deceased. So each sibling in that case would get 1/5 or 20% of the estate. If a sibling is deceased but has 4 children. So the decedent had 4 nephews and nieces through that sibling. Those 4 each take an equal share of the 20, so now they get 5%. So now you have an estate with 4 people getting 20% and 4 other people getting 5% each to add up to 20%. If you have a wife with children, so I have one now where it's a wife and the decedent had 5 children from a prior marriage. The wife receives 1/3, that's 33%. The children each get 1/5 of 2/3. You have to remember to do the math. We multiply 1/5 times 2/3. I use a calculator, but they are these kind of funky percentages that each kid get. In my case, I think it's like 12% or something like that. And you want to have that even listed, even in your kind of probate petition. I usually write an attachment and say, the decedent died intestate, here are the heirs, and here are their percentages. If you have, you know, a big family, I remember my friend had an estate that I got involved in because somebody called me and said, you know what, he's taking a really long time, and we want you to represent us as beneficiaries. If I know him, there must be a reason. He's a very good lawyer. So I call him and he says to me, he says, Neil, are we off the record? I said, yes. This case has 51 heirs. It's a family from a foreign country, and there are 51 heirs. Your clients have, I guess, some of you clients only get like 18%. They'll get their money. I'm trying to get addresses and things from it. Give me some. Out my 51 relatives. So that's kind of a nightmare case that you might not want to take. You need to know those laws of intestacy to make proper notice of the initial petition, because you don't get that clean at first. First of all, the probate court's may catch it and say, wait, you didn't give notice to that part of the family tree. Why? Oh, I couldn't get addresses. Well, try again. We're not going to give you an order for appointment until you go through and get proper notice. Second of all, if you don't give notice and they come out later, which they will, like I told you in the case about an hour ago, because there are heir hunters, your initial order is not even good, actually. They can object. That's what's called extrinsic fraud. That's keeping somebody from the proceedings. So that's number one. You have to know your intestate succession, even if there's a will, because they have to get notice and they have standing to contest the trust. So if you have a case where the will cuts out a child, you're going to give notice to that child of the probate administration, and that child's likely to hire a lawyer to contest the will. So you have to give notice. Second of all, if you have an intestate estate, you want to know kind of the weird ins and outs of California intestacy. So, for example, this happens a lot. If a child dies and the parent seeks to take from the child, the parent cannot take from the child if any one of 3 things happens. First of all, if the parental rights were terminated by the court. So a lot of times, you know, parents abuse children, or parents commit felonies and cannot be parents because they're incarcerated, and the court terminates their parental rights. They cannot inherit. They could be the natural mother, natural father. They cannot inherit by intestacy through the child. Second of all, if they have not acknowledged the child, but they never had any part in the child's life, they just, you know, were there at the beginning and that's it, they do not inherit. And finally, if they've abandoned the child for more than 7 years, and not provided support. So a parent has to provide some support. I was involved in a famous case where the son died. He was a celebrity at the time, and his only relative that we could find was his mother. The mother told us, oh yeah, the father, who I remember being the father, we're not married, is dead. And so we didn't give notice. And sure enough, about a year into the probate, this guy shows up and says, I'm his father. And we were like stunned. And the client says, no, I do remember that guy. We had a relationship well before the son was born. It can't be. So we were gearing up to do a genetic testing. I remember I did a motion to do genetic testing, and we were going to take a deposition because my boss, who knew the laws of intestacy very well, said, you know what? Even if he's the natural father, he had to have provided support. And this guy didn't buy the son even a bag of potato chips. So we'll just take his deposition, and if I get him to admit that he had no meaningful relationship, he can't pay. Meanwhile, I'm working on my genetic testing motion, and the father walks into the room, and my boss says to me, "I guess you can forget about your genetic testing motion." It was the exact image of the decedent. It was like we almost got afraid that the decedent was still alive. So in that case, what happened was that we went to trial based on we didn't even see genetic testing. We conceded that he was the father, but he didn't support the child or acknowledge him. He cannot inherit. We won a trial. They took an appeal, and we settled on appeal, gave the father a significant amount of money to end the whole issue. So you want to go through your 6400s and find out when stepchildren. That's a major problem in California, where a lot of times you'll get a call from somebody saying, "Oh, my mother died, and I want to administer the estate," and you'll find out the mother was only a stepmother, and stepchildren, basically, for them to inherit, it's very difficult. Because if there's a will, then it's easy. If you can name your stepchild, you can name anybody as a beneficiary. But if it's an intestate estate and there's a stepchild, the court has to find that there was a legal barrier to adoption. So a stepchild really has not significant enough relationship in the eyes of the law to inherit from its step-parent. There has to be a showing that there was a legal barrier to adoption. And I don't think there is, because once while a stepchild is a minor, you can't adopt because you've got to get permission from the biological parent. So the biological parent is still alive. You don't adopt. That stepchild, who's age 16, let's say, when mom dies, that stepchild will likely qualify. That stepchild will probably not be calling you to be an attorney, because that 16-year-old cannot be the client. You'll get a call from a 30-year-old stepchild, and you'll have to say, what was the legal barrier to adoption? Why didn't the step-parent adopt you? They did not need to ask the biological parent for an adult adoption. The only thing you need for an adult adoption is, I think you do need the consent of the child's spouse. If the child is unmarried, there's no spouse. So once you get into intestacy, there's a lot of, kind of exceptions that you might not be aware of. I will tell you that intestate estates are generally, I think, easier to administer than estates with will. You kind of can't, for lack of a better word, as I think about it, you really can't screw anything up. If there's a will, you can forget about a clause, or a clause doesn't make sense and you kind of interpret it the wrong way. I had an estate where there were, I can't remember, it was something like the will had like 40 or 50 gifts. And literally the page turned over and I forgot to make one. It was like $15,000. And I got a call from somebody saying, "Hey, what happened to me?" I said, "Oh my God, I just need to get glasses." Thankfully, the estate kept a reserve of $50,000 and we could cut a check. That with intestacy, it's not going to happen, because that's just defined by what happened. In fact, if you want to, vary from that. So I had a case during the middle of COVID where a gentleman died. He had one child who was for real. That was my client. He had another child who may have been adopted out by somebody else, never really understood. And so I said, "You know what, why don't we settle, instead of it going 50-50, because I think you have problems with proof, we'll settle 60-40. Fine. We go to the initial thing. The sister of the decedent shows up and says, "Neither of these two kids is his. I am the sole heir as the sister." And I said, "Oh my God, I'm gonna quit." And so we had to make a deal with the sister, and we gave her like $50,000. At the end of the probate, I couldn't pray for a normal distribution according to the intestate percentages. You have to be aware of a probate code section called 11700. And basically 11700 is sort of a catch-all provision where it says, if you want to do something different than the will or the intestacy, you got to allege facts that say why this person, this sister, who's technically not an heir, is getting $50,000. You're doing it to buy her off. Why you're going 60-40 instead of 50-50, because there's issues of proof and the parties have reached a settlement. In my case, where the heirs came in afterwards from the maternal side, I made a deal with the attorney saying, listen, if I get you the money within 60 days, if I file a petition, will you take less? And the heirs in Canada said, fine. So I busted my, chops to get the petition done on time, along with a stipulation and settlement, changing the percentages from 33, 33, 16, and 16 to like, I think 40, 40, 10, and 10, because we got it done so fast and they didn't have to prove who they were. So in intestacy, you've got to know those rules because they cannot be varied. And if you want to pay settlements or do something else, you really have to ask the court to have the power to do so for your personal representative at the end. Although I like I said, intestated estates are easy. I don't know, if you have more than 10 or 15 heirs, it's difficult because you got to track people down. When you make the final check, you may have to get tax information from them. You need to get a receipt. So maybe intestacy, but only up to a certain amount of heirs, unless you have an outstanding office staff to do all the record keeping. I guess because of sort of administrative mashup, we did not get to do a administrative checklist, but you basically can go online and find it. Basically, your big deadlines are in the probate code. You want to file your inventory. I believe it's 60 days after letters. You need to give notices to the California Franchise Tax Board and Medi-Cal if the decedent was receiving Medi-Cal, telling them there's a decedent estate and whether the decedent owes any money to the Franchise Tax Board or was a Medicaid recipient. You want to give notice to creditors as soon as letters are issued to get them to collapse their time limit to nothing more than 4 months from letters. If you know about creditors, you don't give them notice. Generally, creditors have 4 months from the date letters issued to file a claim. But if they don't get notice, they sometimes can say, well, I didn't hear about it and I want to file a late claim even after the 4 months expire. If you send them a notice of administration, they cannot get a late claim because the most they get is up to the 4 months, unless you give them the notice late within the 4 months, and they get another 60 days. But you can collapse that statute. I generally don't give notice to every creditor I know, because I'm kind of of the hope that they will miss the deadline and they won't be able to do the petition to file a late claim, or it's just too much work because it's a small debt, it's a couple $1,000s. I have one now where Verizon just showed up with an $800 bill, and I'm going to write them a letter saying your claim is late. And if they respond saying, oh, we're going to file a petition to file a late creditor's claim for $800, I mean, that's probably not going to happen. So if you go online, you can sort of get checklists. In terms of the estate, you have to keep your estate going, and you have to try to close it within a year. LA County is now giving you 18 months, but they set, when you get appointed, the county set a date to file a petition for status report or final distribution, and an order to show cause hearing date about four weeks later to explain to the judge why you can't fill out a simple status report or close the estate. So those dates need to be on your calendar, because a lot of times estates drag on. There's litigation, and you'll just, you'll miss an order to show cause. And the courts in LA are very patient about it. But if you miss more than one, I've seen them issue sanctions against attorneys. I've certainly seen them threaten to remove administrators. So you want to, that date is usually printed on your letters or is in the minute order. And that date is absolutely holy. And the easiest way to sort of beat that deadline is most local counties have a form status report. And literally you can file a status report in about 5 minutes. And it gives you about 4 or 5 lines to explain why can't the estate be closed. And I've used every reason in the book, client is ill, missing records, and of course it's fine, take another 6 months or a year. As long as nobody objects. If you are dragging your feet and there are heirs or beneficiaries out there waiting for their money, you're gonna have a problem. But if it's just, you're handling a probate and it's taking a long time, to get the property sold, the family understands, or the executor was ill. Probate sometimes cannot get done within a year. If there's an estate tax return, you really can't close the estate until the estate tax return is filed. But you want to be sure that that OSC date, the order to show cause date, and to file a status report or file a petition by, is really there on your calendar. Very important, because it's the one thing that can get you in really deep trouble. Your client, personal representative, can lose her right to statutory compensation if they do not follow these deadlines. The one thing that the client can lose everything, and they're going to blame you for not filling that out. So if you have to, I've seen many times, I'm not going to say I've done it, but maybe I've done it a couple times where I'll hit the deadline for a final distribution. I'll say, oh, you know what, I'll get it done. And I'll beat the order to show cause. And the deadline to file a final was August 20th, and the order to show cause was today. And sure enough, a couple days before, I'll say, oh my gosh, I'm not going to be able to get the petition for final distribution done. I need to get the accounting done. And I'll file a last minute status report. And, I've seen people, I've done myself, go to the court and say, oh, I'm here for the order to show cause. Look, Your Honor, just 2 days ago, I filed a status report. And the judge says, okay, fine, order to show cause off calendar. Look here, your status report hearing is in 3 months, and we'll talk to you then. That is much better than missing a hearing. It's even a little better than just showing up at the order to show cause date and saying, Your Honor, we didn't do this, didn't do that. Because the judge said, really, can you just file the status report and not waste the court's time telling me your reasons? So that's the one deadline to really put in red letters on your calendar. There are other requirements. If there is real property, the county requires a statement of a change of ownership statement filed within 150 days of the date of death. If the decedent owned interest in entities that own real property, there's a Board of Equalization form that has to be filed within 120 days of death. So when you take over a probate, there's a significant amount of sort of things that you have to do by reflex. And if you work better with checklists, you can probably, find one if you need one. I apologize that didn't make it in the materials, but I do have my sort of master checklist that you can contact me for. Like I said, I kind of like doing intestate estates because wills, I have one now where I think I'm going to help my friend out, but I'm sort of maybe let him suffer on his own. People write holographic wills, or even not holographic wills, but they type them themselves. And, in this case, we have a case where he said, I want this person to get a good down payment for a house. I don't know. We haven't yet found a case interpreting what a good down payment is on a house. And so you're going to be hired to either prosecute that and say, well, a good down payment in a house, that's obviously a house in Beverly Hills with a 20% down payment. That's a gift of $2 million. Or maybe the administrator, you're going to say, no. My client hated your client. I don't know why you're still in there. But the administrator can say, you know what? You get a nice starter house for $500,000, and a good down payment is 20, 25%. That's a gift of $150,000 at most. You kind of need to stay on top of the opinions. Obviously, if you have, Westlaw or Lexis, you can do research from this. The main thing that has made life difficult, or more difficult or more complicated, is there's a California Supreme Court case called the State of Duke from 2015. And what it says, if there is any ambiguity in the will, either there is a term that itself is ambiguous, or there's a hole in the document where somebody didn't take into account a contingency. What the estate of Duke had was a man did a will and said, if my wife survives me, okay, everything goes to my wife. If we die at the same time, it goes to charity. He didn't say what happened if he survives his wife. So the will says, if my wife survives me, all to wife. If we both die at the same time, all to charity. The will didn't say, well, what happens if I survive my wife? And so he did. He survived his wife. And the nephews came in and said he died intestate. If a will has a hole in it, it doesn't say what happens, then the will fails as to that issue. The executor is still appointed, whatever other gifts were made is fine, but the residue fails. So the nephews came in and said, it's our money. The charities came in and said, look, he never wanted his money to go to his family. It was either to his wife or to us charity. And they fought it all the way to the California Supreme Court. And the California Supreme Court made kind of new law because it said, look, what previously was held is you couldn't use what's called extrinsic evidence and what the settlor intended and what they talked about to fill a hole in the document. If, there was a term of art in the will that was, it felt ambiguous, like it said, I leave $100,000 to my good friends at the bridge club. Well, you can figure out who were the good friends maybe that played bridge with him a lot of times, that actually knew him. That is ambiguous as to who that is, and you can get extrinsic evidence, meaning who did he hang out with, but you can't use extrinsic evidence of what the testator intended to fill in the hole. Well, the state of Duke said no, everything goes. Basically, we want to know settlor intent is the most important thing in interpreting an ambiguous provision or even a missing provision in the will. And they said, bring it all in. We want to hear about the decedent's charitable giving practice, etc. And so I don't even know what happened to the case, but I don't think the nephews got their money because there was going to be a trial over whether the evidence was strong enough to show that you could determine what the settlor intended, or the testator intended, was to leave his money to charity if he survives his wife. So that's, first of all, so in interpreting a provision, don't go out on a limb, try to figure out what the testator did. In terms of art found in wills, there's a lot of them. In the back edge of the probate code, around the 21,100, there are rules of interpretation. It starts out with, it says the most important thing in terms of interpretation is what did the settlor intend? But you don't know what the settlor intended. The settlor sat in the lawyer's office, filled the will out, or drafted it by herself. She doesn't say, well, this is what I intended. You have to take the language somehow at face value and figure out what it means. And so there are all these rules of interpretation. So for example, let's say you leave money to A, and A dies before the decedent. Well, do A's kids get it in place of A? That depends whether the trust says, the will might just say, at the end saying, okay, gifts to A, B, C, and the trust might say, any gifts that last shall go to the residue. Well, that gift to A lapsed because he didn't survive. If there's no strong residuary clause, it might go to the kids. There are certain gifts that are called specific gifts. So your client may have come to you and say, look, I got this house from the decedent. And you call up the attorney for the estate and say, hey, when does my client get that house? And you say, oh, sorry, the decedent sold that house 2 months before he died. That gift of a house is called a specific gift. And when specific property that is the subject of a specific gift is not there at the decedent's death, the gift is called a redemption. It basically, it fails. Now, the court tries in a million different ways to not have this happen. But at the end of the day, if there's a specific gift, and it's not there, that beneficiary doesn't take. I'm looking at a case now where the person said, I leave my, I guess it was a car called a Hudson. I leave my Hudson to my good friend. Well, he had sold the Hudson, but he bought another one. After he did the will, and before he died, the court said, yeah, that beneficiary gets the second Hudson, even though it wasn't the one that that I want to talk about. There's a case where the person left $2,000 to some people at the Bank of America branch in Santa Monica. Well, the decedent had moved the money to a different branch. The court said, yeah, we're still going to give the $2,000 to the kid. So again, whenever you have a will and if it's drafted by an attorney, fingers crossed, it should be pretty clear and not be up to interpretation. But this stuff is kind of fun. A lot of times, clients write arrows and diagrams and use language that just makes no sense. And you might represent a neutral administrator who says, look, I have to argue one way or the other. and you ask for an interpretation from the court, again, this is not a decision you want to make on your own. You want to make this as part of that 11,700 petition saying, look, he said, I give all my shares of stock that are in my office, and he had shares of stock that were in his home that the bedroom he kind of used as his office. Well, do those shares of stock go to those people, or is only the shares of stock he had in the actual office? So you'll do your 11,700 and say, listen, let's be realistic here. And all the shares of stock he held go to these specific beneficiaries. Now, other people may come in who are affected by that and will object. And you might just say, well, I'm pulling out. I'm not doing any further work on behalf of this one interpretation over the other because they now have their own lawyers. And you can do that. But in the first instance, you as administrator have to put it out there and then let the side take over. So again, you really want to know the law. I have a case now that's just an absolute, nightmare. I mean, we're going to go to a mediation because we cannot possibly litigate this over all the stuff that was done here. The woman had a will, and then and I didn't even know this until after she died, but there's a handwritten document where she marked up the will and left things to other people and crossed people out. And the provisions in her new document don't add up to 100%. So I told everybody, I said, listen, I wrote a letter saying, look, this is how I think it works. And there's an additional complication because going back to the example that I used where somebody comes to you and says, oh, this decedent left me a house. And you call the estate attorney and say, where's that house? And the estate attorney says, oh, it was sold. And the reason it was sold is the decedent was under a conservatorship. She was really ill and she needed money for her care, so we sold that house. Well, there's a separate provision in the 21-1000 that says if the reason that property is not there at death is because a conservator sold it, well, then the beneficiary takes the cash that the person got from the sale because the decedent didn't sell it willingly. Had the decedent been asked, they said, well, yeah, I'm going to sell the property, but I probably should put in the will that that beneficiary receives the net proceeds from escrow or $200,000 instead of the house that they were supposed to get. So that's the whole thing. And in this case, that happened because my client was the conservator, sold it, and under the will that I had, it didn't matter because it all went into what was called the residue. The new quote-unquote handwritten will says that this property goes to one of the daughters and not the other. So I said, look, I'm going to need to file a petition. And so I wrote a long letter to them. I said, let's go to mediation. We're going to go to a mediation and sit with the judge because to litigate this in probate will probably take 3 to 5 years in terms of evidence and deposition. So when this happens and when there's ambiguity, first of all, keep track of your time because this is the kind of litigation that is extraordinary compensation. But you're going to have to research it. And unfortunately, a lot of these cases are really old. Probate goes back a long time. And whenever you see a case, and whenever I see a case I have to read in probate, like before 1970, I have to do it not during working hours and just sit there and draw out the facts and write, okay, this is John and he got this and figure out because just reading the case and, while answering the phone, just can't do it. So you really have to, if you're going to get involved, you kind of need to become, kind of a sort of a nerd for these cases to know them because literally the recent cases on them are so kind of, Byzantine in terms of what the judge finds to rely on. Most of these cases are not published by the courts of appeal. There are a lot of unpublished probate cases involving interpretation. And for whatever reason, I guess the court of appeals just thinks these are not really important cases. They're really only pertinent to the actual case where some, guy decided to do a will in his, day runner, and it really doesn't have much application outside. So I would encourage you not only to read the published cases you'll find it like a practice guide, but if you're in Westlaw, you can forward cite to other more recent cases that might not be published, you can't cite to them, but the legal reasoning in them is for the taking. So I've certainly used unpublished cases to argue legal theories that other people have came up with to deal with interpretation. So it's sort of like a field of like it should be a separate arm in the probate court saying we do regular probate and there's one or two judges that handle only deal with crazy provisions. And that's all they do. And they're the experts because sometimes you look at cases and you're saying, I know this judge. Why would he make this decision? It's so obviously wrong. And the Court of Appeals reverses, him saying, wow, why would, and you just don't, human beings are judges and judges are human beings and they make mistakes. And for you as the attorney, it's not up to you. If, you are either fighting for an interpretation for a beneficiary and then, file your papers and argue your case, or you might be a neutral and don't go on a limb and say, you know what, I decided as attorney that this person gets nothing because the handwriting makes sense to me. You don't want to do that. You'll be found to be biased, put it before the court as a petition under 11-700 to determine the right to distribution of a certain asset. And, it's, like I said, what makes probate, for lack of a better word, kind of fun is to go through wills like this and, determine what they mean. Holographic will cases are the most famous ones. A holographic will is where somebody writes a will, basically, essentially, all in their own handwriting, signs it and dates it. It's clear that it's supposed to be a testamentary instrument, but it says will. What's nice about holographic wills is when you get a holographic will and you're going to be the estate, the personal representative is where I'm not really sure how an opponent of a holographic will can state that it was made with undue influence or lack of capacity. If somebody does a will in their own, house with nobody else there, that will usually survive. So that's a good, sometimes a state to take because you're not going to be canceled out by somebody saying the will is no good. If it's a will that was done, on a website with some friend there who's telling you what to sign, well, that's prone to undue influence. The problem with holographic wills is people make up stuff. And you have to be the one to try to figure out what they meant. And it could be, change of $100,000. In this case that we have, which is basically a holographic will where he said, I want a good down payment. I know the executive attorney wants to give us like $20,000 and we're trying to get way more, but I don't know what a good down payment is. And I don't think there's any case or statute that defines that. It just has to be kind of what you can sort of say that the executor or the testator intended. Final short topic is what are called disclaimers. This is kind of a rare item. I've only done them, I think, count them maybe on one hand how often I've done them, but they can become useful for a lot of reasons. A disclaimer is a document that says, I don't want it. And when a client does a disclaimer, one of the magical things that is done is it is not a gift to the person who takes it next. So I had an estate recently where the son died and he died in testate. No children, no spouse. So the money all went to his mother. His mother was, totally, she was never the same over losing him. It was under rather terrible circumstances how he died. And she didn't want the money and she didn't need the money because her estate was like $20 or $30 million and getting $1 million or $2 million from her son was only going to make her have more tax problems. The people that hired me said, make sure that the mom does a disclaimer. And the benefit of the disclaimer was it didn't go to her estate and it goes to the decedent's brothers, her 2 children. And it's not deemed to be a gift, even though that's what it really is. There's no question about it. What she's saying is, I'm taking the fall. I don't want the money. It goes to my 2 other children. And that should be a gift. And for gift and estate tax purposes, gifts use up exemption. And so, but by having a valid disclaimer, they don't. To be a valid disclaimer for tax purposes, it has to be done within 9 months of the date of the decedent's death. That's a very hard deadline, and it has to be filed in the probate. So you can't just say, well, I'll do it, I'll get it signed, and I'll wait, and I'll file at the end. No, you want to file it within the 9 months. You want to file it as soon as it's signed, that very day, so you don't forget about it. So first of all, if you're going to do disclaimer planning, you've got to get it signed. It does not have to be notarized. You want to get it filed with the court before 9 months. And the disclaimer cannot say where it goes. So if a mother says, well, fine, I don't want the money, but I only want it to go to my one son and not the other one, that doesn't work. That's not a disclaimer. It has to it has to be distributed to the next taker. So sometimes you'll see, if you see a will, it'll say, I leave assets to my son. If he dies before me or he disclaims, it goes as follows. And it might not go equally to the son's children. And that might have been by design by the son and the father. They look at, leave me my share, but you know what? If I don't want it, I don't want it going. We don't want it going to my one son. We only want it going to my 2 daughters. But make sure the document says, in the event of a disclaimer, it goes like this. And then it goes like that. But the disclaimant cannot say where it goes. The only way for the disclaimant, who's the person making the disclaimer, to do that is to take the asset in and then make gifts subsequently to the recipient. Well, that's not a pure disclaimer. That ends up being a gift, and that has a problem using up the estate tax exemption. If you have wealthy clients, disclaimers work to pass assets to the lower generation, not ruining their taxable estate. So I have a wealthy client, and her mother died, and I said, you are signing a disclaimer. We are not getting you any more assets because I don't have the time to do any more planning for you. I'm working hard enough to get your assets, avoid estate taxes. Another $1 million is not going to be worth it. So she's disclaimed, and the trustee or the executor in that case is making distributions to the daughters. The executor still does not understand why. Why am I not writing a check to Janet? And I say, don't write a check to Janet. It's very important, by the way, if you're doing a disclaimer, the disclaimant cannot have received any benefits. So sometimes someone will call me and say, oh, I got I got a $500,000 inheritance. I really wanted to go to my children. What do I do now? I said, it's too late. You can't make a disclaimer. You took possession of the fund. You now have to make a $500,000 gift and file a gift tax return, etc. If you're going to do disclaimers, there's a number of requirements. You really have to start with Internal Revenue Code section 2518, which says how to make a valid disclaimer, and then California law complies with it. So it's a federal tax concept that you have to do because you're really only going to do disclaimers if it's tax motivated. It's really rare that somebody who needs money or even somewhat needs the money would disclaim it, and not want it. I mean, it sometimes happens where somebody says, you know what, I just don't want the money, and I don't want it. I had a case many years ago where a man shot himself, and he had a life insurance policy, and for whatever reason, before he shot himself, he took his wife off as beneficiary and left his children on as his beneficiary. And the problem is that the money went to the children, there would be an estate tax. There was a significant, it was like a $5 million life insurance policy, and if it went to the children, there was going to be $1 million in the estate tax. So I said, what we need to have the children disclaim. The problem is, one of the children was age 15. We had to have the court appoint a guardian ad litem to make the disclaimer. Then the funds went to the wife because she was put as secondary beneficiary, and funds passing to a wife are not subject to estate tax. There's an estate tax marital deduction. So disclaimers are kind of like, I refer to them as post-mortem estate planning, but the estate plan doesn't make sense because people are getting money who shouldn't, or for some reason, a surviving spouse didn't get money, and you need to get money because you need to get money to the surviving spouse because that's the only way to beat the estate tax. You're going to want to use disclaimers, and you want to start with our Internal Revenue Code section 2518 and make sure to do it tax-wise correct, even if it's not a tax issue, because once you follow those rules, it will be accepted for California probate purposes. California probate leaves you, it's possible to do a late disclaimer, but avoid it. Do the disclaimer within 9 months. Finally, I wanted to turn back to the estate administration checklist. One of the things to be aware of in California now, which wasn't the case 2 years ago, is there is essentially a only very limited parent-child real property exclusion. So it used to be that parent died, and if you were doing the probate and they only had a family home, it could be a family home, I don't want to say a rundown part of town or a great part of town, that property passed to the children and there was no reassessment. You know how California property tax works. When the client buys the property for $100,000, who knows how long ago. And every year, the most that can be increased, the assessed value, is 2%. So over the course of a lifetime, your client's new assessed value may be $300,000. 2% over 30, 40, 50 years really starts to go up. But that $100,000 house bought in the 80s may be worth $2 million. Well, when the client dies and there's a change in ownership, when there's a death, that $300,000 assessed property, which is about a $4,000 tax bill, becomes a $2 million assessed property, about a $23,000 annual tax bill. And with the primary residence, it was an unlimited exclusion for the child. The child could get it, the child could take it, put it on Airbnb, whatever you want, and have the benefit of this low $300,000 assessed value, paying, not even 10% of the taxes that somebody pays who just bought the house next door. As of February 16, 2021, that change, that exemption only applies if the child, and it really has to be all the children, use the property as their family home and the parent uses a family home. So you can no longer, the rental property doesn't apply to, and you can no longer convert a family home into rental property, with the result that even if you have a family home, it's only the first $1 million that escapes it. You have to file those change of ownership statements right away, because the county is going to reassess the property, and they take a long time. They take up to a year to send you the bill, and you really can't close the probate until you get that bill, because it's a big bill. It can be, if you don't sell the house quickly or the house is being kept, it can be a $10,000 bill within the space of a year on $1 million reassessment. So that's a new deadline that kind of never was taken too seriously, and say, oh, well, I'm selling the property. The county will figure it out when it's told. You want to acquaint yourself with the change of ownership statement, death of real property owner, and get that form filled out right away. And with that, I'm done with my two topics. Thank you very much.
We'll continue our program with our next speaker. We have Crandell Van Connis, and I will turn it over to Crandell.
Thank you, Shanae. Good morning, everyone. My name is Crandell Van Connis. I'm going to be presenting on two topics today. The first one that we're covering now is the inventory and appraisal, which is going to cover how to gather assets and report them properly in the inventory. So let's get started. That's me. There's my contact information. Feel free to call or email me after the presentation if any questions have arisen that we haven't covered, or you don't feel comfortable asking them in the group. I'm happy to cover anything after we've already finished. There's a little bit about my firm. You can go onto our website, find out about it. I've been doing this for over 30 years now, which is just really a nice way of saying that I'm getting a little bit old. It also means that I've seen a lot and a lot of really interesting and fun things in probate. But you would be amazed the average amount of times in any given month that something comes up in our office that we've never dealt with. That's the fun part of probate. And the previous speaker, I really liked his analogy that probate is a train that moves. You make stops along the way. You might not like everywhere you're going all the time, but people get on, people get off. Your train might get stuck in a station once in a while, but there's always a way to keep it moving along. And that's part of what appeals to me about probate. I really do like this area of practice. It has a sense of deliberation to it. There's a logic to it. It's a linear kind of way of a linear sort of area of practice that just really makes sense to me. So if you're new to this area, I think you'll find the same thing. If you've been doing it a while, hopefully you feel the same way about it I do. So let's get started. Why do we marshal the assets? There's the marshal. He's there to make sure you do your job. I did actually have a client at one point when I used that term who was asking, is the sheriff really going to come? Do they have to look at stuff? And no, they don't. Marshaling just is the process of kind of wrapping your arms around the assets of the estate. Why do we do it? Well, we do it, first of all, because probate code says we have to. The personal representative has a mandatory duty and shall take possession of the assets, all of the property of the estate that's going to be administered. So you have to do it, and there's a number of reasons that it's important to do that. First of all, you will use it as the foundational base for a few things that happen in the probate. First of all, reporting to the beneficiaries at some point what's in the estate, how much is it worth, what are they going to get. That can't be discounted, obviously, and that's going to be the starting point also for the accounting that you're going to have to do at the end of your probate. And we'll talk about that later on in the day. That's another one of my topics. It's your starting point for the accounting. It is also the foundation for your fee base for statutory fees, which I'm sure a couple of speakers will touch on throughout the day today. It's the basis for how you calculate your fees. So it's very important as well. It's also the starting point for any kind of determination you need to make about whether or not estate tax is going to be an issue in your estate. Are you going to have to file a return? If you do have to file a return, are taxes going to have to be paid? You can rely on your probate inventory values for your 706 valuation. It is also a good starting point and provides a guidepost along the way to make sure that your estate is bonded properly. We'll talk about that a little bit more, or at least I'll touch on that in my comments. And it's a really good way to give your client a roadmap to provide them with information and tools they need to address particular kinds of assets. Every asset or class of asset in your estate has its own particularities in terms of what you need to do to keep it safe, keep it insured, how to deal with it. So as you're gathering each of those assets, that's going to kind of spin off its own set of questions for you to consider. So let's get into some of the specific assets. These are, I'm going to try to cover a lot of the most common things, ordinary things that are going to come up in the estate that a lot of probates contain. We'll touch on a few unusual ones as well. So real property. Hopefully your estate has some real property and hopefully it's worth something. The previous speaker did spend some time talking about non-probate assets, talked about our petition for real property of small value. That threshold is increasing now. It was stuck for a long time at 100,000. It's been adjusted up. It's now on a scale where every few years the value of a small estate increases. So in years to come, there might be some estates consisting solely of real property that don't have to be probated, but for the most part, if a decedent dies and their estate contains real property and it's not in some jointly held fashion or in a trust, it's going to be in a probate. So step one, determine the title, which is pretty easy to do. Virtually every title company these days has some kind of online tool you can use to look at vesting deeds and see how title is held to real property. And that might tell you right there that you don't need to probate depending on how the title is held. You usually don't have to go down to the recorder's office anymore. In fact, these days they don't like you to, so you should be able to find all that online. Other information that's important to determine when you start looking into real property that's in the estate is if there's any lien or encumbrance on the property. Did the decedent have some debt, a judgment that got reduced and was recorded? Is there anything else that pops up in the chain of title that might be a problem for you? You're going to find that out when you pull a property profile from the title company. It should also prompt you to have a conversation with your client about what you need to do to keep that property secure. You need to make sure the property itself is secure. If it's in any kind of condition where you need to make sure it's secure, make sure the doors can lock, make sure the windows can close, make sure it's safe from an insurance standpoint, is it properly insured? Are there any hazards there that your client needs to be aware of? How's the property being used? It might have been tenant occupied property, in which case it's going to prompt you to have a discussion with your client about the terms of that lease. Can you find a lease? Are the tenants there legally? Are they there on a lease with a term that expired? Are they refusing to leave? So all of these things you're going to have a conversation with your client about when you have a discussion about the real property. In terms of marshaling the real property and kind of wrapping your arms around it as part of the estate, there's really not a lot you can do because somebody can't pick up and run off with a house. We will sometimes record a certified copy of letters so that if when the time comes to sell, the agent, the title company will know that the asset is part of the probate. We don't always do that. It's kind of a case by case basis. A lot of those things, if they're routine matters, can be held through or handled rather through the escrow process. So a lot of times it's just sort of a belt and suspenders approach if you want to record your letters, but you don't typically have to. Other easy assets, generally easy to deal with, are money held in bank accounts, checking accounts, savings accounts, and like assets. I say they're easy in terms of being able to walk into the bank and present your letters and gather your information that you need to inventory those accounts. It has, however, gotten increasingly difficult to deal with all kinds of financial institutions. And one of the best instructions you can give your client when you're telling them how to go to the bank and collect those monies of the decedent, I tell them to bring their certified letters, bring a death certificate, bring their ID, and bring a full measure of their own patience with them, because it can take an extraordinarily long and unreasonable amount of time sometimes these days to deal with the bank. They all have their own particular rules they want to follow. They always feel compelled to check with their legal department. Legal department might not be in California and might not agree with what you're doing. So just make sure you advise your clients of those challenges. One of the hardest things is to know where the money is. So many people these days have electronic delivery of their bank statements. Everything is paperless, and you're not getting bank statements in the mail all the time. So you have to use other powers of investigation, looking through the decedent's papers, records, of course, checking with their accountant, getting a couple of years of previous tax returns will tell you where the decedent might bank. Obviously, you can check with family members and other people, but that's part of our modern age of doing business that made some of these things a little bit more difficult. A couple other things to keep in mind with bank accounts. CDs, which they ebb and flow with the interest rate. I've had times over the years where every single estate I had a certificate deposit. These days, not everybody does anymore. Make sure your client knows that if the decedent dies during the time period of the certificate and they go to close that account, that there is no penalty for the early withdrawal. Depending on who you're dealing with at the bank, they may or may not know that. And also advise your client. So many of us today, as per my previous comments, do things electronically. You don't want to close a bank account that is receiving a direct deposit of some kind of income or is being used to automatically pay bills, particularly important bills like mortgage, insurance, and taxes. So as soon as your client has overcome the initial hurdle and has someone at the bank to talk to, they'll be able to look at the history of the account and make sure that none of those things are happening. Stocks. If the decedent had stock that's in a managed account or a brokered account with a professional advisor, that makes life easier. You can request copies of previous statements and see what they've got there and get a date of death statement from the brokerage, and you'll have your information ready to put on your inventory. The more difficult ones are becoming less common, but are still a lot of fun when you come across an estate where the decedent had an actual real life paper stock certificate. It's not real common these days, but I have, and I still come across estates with some frequency where somebody will have an actual paper certificate. And I had an estate not too long ago where the decedent had a bunch of stock certificates from when Ma Bell broke up, and there were, across my desk, I had, a dozen, 10 or 12, little certificates from all these different telephone companies. So if that's the case, hopefully they'll be within the decedent's records. They might be in a safe deposit box, which is, Neil mentioned, that can kind of pose its own problem. But again, some of this is just investigative work to find out where the stuff is. You do have a duty to visit and inventory any kind of safe deposit box that you might come across. And again, you'll know that when you can look at the decedent's bank accounts, typically safe deposit boxes are paid for through an automatic withdrawal from the decedent's bank account. So you'll see that deduction there on the bank statements, and you'll know to ask the bank about a safe deposit box. When you find certificates, you need to make sure that you can tell how many shares they are. If it's something that's listed on the stock exchange, you can look up the CUSIP number. We'll talk about that a little bit more. Or you can get more information from just looking online with the name of the company. Insurance. So insurance is typically not an asset that is going to be subject to probate, because most typically people will designate a beneficiary who's going to receive that insurance automatically on their death. And the beneficiary receives that asset free of probate. Doesn't matter if the decedent had a will or not. It doesn't matter if there's a trust or not. It's going to pass automatically to the person who's named as beneficiary. However, there are a couple of exceptions to that. The most common one being where the person named as beneficiary has predeceased the decedent and there's no contingent beneficiary, or if there are contingent beneficiaries, they have also predeceased and the decedent has failed to update that information during their lifetime. At that point, the designation of the beneficiary fails, and if the value of the life insurance is over the statutory limit to avoid probate, then you're going to have to probate that. Finding the policies, as per my previous comments, same kind of information. You can look for premium withdrawals from bank account statements. If it's a type of policy that had an investment component to that, will probably be a 1099 they're getting. The other case that rises with some infrequency is where the decedent owned the policy on the life of another person. On the decedent's life, that's an asset of their estate, even if the beneficiary named is still living Those pose some interesting valuation questions. That comes up very rarely, but it does come up once in a while. In terms of the claim for the policy, that's up to the beneficiary if it's not in the probate. And so you just, when you find out that information, you need to get in touch with the beneficiary and tell them to contact the insurance company. And it's a pretty simple claim process for those. There is one question we've gotten about how to handle savings bonds. Savings bonds, again, they're sort of like the stock certificates. We used to have paper bonds all the time. And I've had a few estates where people have had lots and lots of bonds. A lot of those are now, though, online. And in fact, I think it's been years and years since the Treasury Department has even issued a paper bond. I think you, through Treasury Direct, they make you establish an online account. If you have paper bonds, you can take those to the bank, or your client can take those to the bank along with their letters and a death certificate, and they can cash them in there, right there at the bank. If it's an online process, your client's going to have to establish a Treasury Direct account in the name of the estate. And then Treasury has instructions, I think, for how to transfer them from the decedent into the estate account. Personal property, all the stuff, which can simultaneously be interesting and super aggravating to deal with. The personal property might be contained in the home. It might be contained in a storage unit, might be contained in a safe deposit box or boxes. For the most part, it's unusual to have an estate that has anything other than sort of run-of-the-mill contents of the home, used furniture, and the like. You will occasionally come across an estate that has a particular item that is a particular value, a piece of artwork or a collection of memorabilia or some artwork, but usually it's the stuff that you have to deal with. You do need to make sure that your client keeps it secure, keeps it safe, that it's available for distribution to the beneficiary. And there's an allowance in probate code section 10520, which allows the estate to make distribution of personal property prior to the closing of the estate under certain circumstances. So you can sometimes in fact to rid your estate of some of those items that might just be kind of a pain to hang around, but you've got to deal with them and get rid of them so you can sell your house. Some other more unusual assets that come up from time to time, unclaimed property. We try in our office as part of our regular checklist of things to do is to always make a practice of checking or telling our clients to check with the Office of Unclaimed Properties in the state of California. Check the decedent's name, check a couple of different names of spelling of the decedent's name, see if there's any assets there that are unclaimed. I have had a couple of a couple of estates where the only reason we're probating is because there was a very large unclaimed property fund sitting there in the name of the decedent. So we make a practice to check for those. Mineral assets, mineral oil fees, royalties, leases, these can be kind of challenging to deal with. They're frequently very small and can be handled through some of the estate alternative procedures. But if you have a probate that you're otherwise needing to do that happens to have a mineral asset, those need to be part of your estate. And lots of times they don't pop up until someone contacts your client because the oil company wants to build and want to take over those mineral rights. They want to buy them or have you transfer them to them. Intellectual property, copyright, and so forth, trademarks. Those are assets of the estate that come up with such infrequency. I don't really want to spend any time with them, but please keep in mind if your decedent was an artist, a musician. I have had a couple of estates of actors investors who, receiving royalties. So just keep that in mind, that kind of falls in the same category. Promissory notes, accounts receivable. So if you're decedent, loan someone money that wasn't paid back at the time of death, you'll collect information about that. That can also be part of the estate. Qualified retirement assets, again, they don't usually fall within the probate simply because in most times the beneficiary has, the designated beneficiary is around and your decedent has done a good job of naming a beneficiary or a backup beneficiary. But same rules apply as applied to an estate with an insurance policy that doesn't have a beneficiary. Those can end up in your probate, and that's really annoying, not only because probate could have been avoided, but it's also a really bad tax result to have those pass through the state. But it does happen from time to time. Business assets, if your decedent was a business owner or owned an interest in a company, if they were a member in an LLC or partnership, maybe a closely held corporation, stock, all of those things are going to be part of the assets of the estate to gather information about so that you can properly inventory those. In my outline, I have mentioned fairly briefly the issue of digital assets. This is not so much a question of an asset with value, but it's more kind of a bugaboo of how to access those digital assets. All of the decedent social media accounts, LinkedIn, all of those kinds of things. All of those platforms have different rules and different user agreements and license agreements that govern how you can gain access both during a person's lifetime as well as on death. It's not usually an issue, it's anything that's going to have to be inventoried. And I'm not going to talk about these intangible assets, NFTs, and those kinds of things. We just don't have the time, nor have I really had the experience with them either. So now that you kind of taken an inventory, literally and figuratively, and you helped your client wrap their arms around what's there, as you've been discovering the assets in the estate and dealing with them, at some point fairly soon into the probate, you're going to have to start putting these on the mandatory inventory and appraisal form, getting them appraised and filing it with the court. So I have about 15 minutes left in the time I thought. I'm going to walk you through how to prepare the inventory and talk about some information that should go on there, hopefully some little helpful hints and unique issues that might come up from time to time. So again, your client's required to file the inventory with the court. And the inventory has to list the assets and appraise them. The assets reported on the inventory fall into really two broad categories, and we refer to them as attachment 1 assets and attachment 2 assets because that's where they end up on the inventory. Attachment 1 assets are things that are basically cash or cash equivalent. Any kind of bank account, checking account, savings account, CD, cash money, the real thing. And then Neil had a story about, marshaling cash. I have my own as well, where I had a client whose mother had died and lived not too far here from my office, and they were getting ready to go out of town, so we were doing the paperwork real quickly so he could sign everything. I would file it after he left. He said his mom he had found some cash and he didn't want to take it home with him. He was flying back wherever he lived out of state, and could I hold it either in my safe or my trust account until the estate was open. And I fixed her, and he came walking in with a rolling carry-on suitcase. It was full of cash and traveler's tax. And that was fun, but it's also a little alarming. And the same issues that Neil mentioned we had to deal with, as well as this is about just a couple weeks after I got into my firm here, and I'm sure they were wondering what kind of a client that Kendall was bringing with her that was bringing in bonds and the cat, but it was fun. But that's basically the only thing that goes on attachment one. Attachment one assets are inventory or valued rather by the administrator. The court trusts our clients to know that the value of dollars is dollars. Anything beyond that is going to have to go onto attachment two, and is going to have to be formally appraised in some fashion. Now, ultimately, the valuation of your attachment two assets is going to come from the probate referee. However, the code does allow and common practice expects that there's going to be a number of assets on attachment two that are going to be the subject of a special third-party valuation that you can send to the probate referee, and the referee will then insert them onto attachment two. We just can't reasonably expect the probate referees to be experts at valuing every single thing. You have appraisers who are certified at valuing certain special things. So the code refers to them as unique, artistic, unusual, or special items of tangible personal property. Those are things like antiques, a vintage car, coin collection, specialty like jewelry, stamp collection, things like that. Books, antiques, firearms, anything like that. You can, as a client, go to an appraiser who is experienced in that, licensed in that particular appraisal specialty, get the appraisal, send that to the probate referee, and the probate referee is not going to question that. Probate referees are good at valuing real properties. They can do regular workaday cars, any kind of security, stock, bond, anything traded is appropriate, and the referee can do those. But anything that's unusual, we really can't expect them to do that. The probate referees are your friends. They are not there to do problems, and there's other areas of our practice in this general field that we have to rely on referees for outside of probate. So we have an estate with a small value, those kinds of things that need an inventory and appraisers, even though they're outside of probate. It's nice to establish a good working relationship with a couple of probate referees, even for things outside of probate at all. I have other cases where sometimes we just need an evaluation of something, piece of real property, and it's good to have a good working relationship with a referee who can do that. Types of inventory. Well, before I get that, let me just talk a little bit about the referees themselves. They're attorneys. They certify by appointment by the state controller in specific counties. If you have a very small county, you might just have one probate referee. If you have a very large county, you're going to have, many referees to choose from. Here in Ventura County, I think we have 3 that are regularly do our appraisals for us. They get paid based on the value of the assets that they appraise. It's a very modest fee, so they're not in it for the money. They're there to help us and turn around our inventories for us. So there are several different types of inventories that you should be familiar with. The INA initially, in the first instance, under the rules of the code, is due 4 months from the date your letters are issued. I will tell you, it can be extremely difficult, near impossible, to file a final complete inventory and appraisal of all the assets of the estate within that period of time, unless your estate has very finite assets that are super easy to deal with. A house, a car, and a couple of bank accounts. So that's easy. You can get that done quickly. Any of these other things that I'm talking about can take some time to get appraised. And you might not even know in 4 months exactly what's on hand in the estate. It takes some time for things to be discovered. You know, if we're waiting for mail to get forwarded, so you can figure out bank statements, things pop up all the time. So the law anticipates that, and it's why they allow for partial inventory. So your final inventory, at some point you'll get to your final inventory, which is going to be the one end all be all inventory of all the assets that were in the estate as of the date of death. You get there typically by filing partial inventory along the way, and each of those inventories will say partial inventory number 1, partial inventory number 2, etc. Until eventually you get to the final one. A supplemental inventory comes along after you've discovered an asset. You might have filed your final inventory, or you might have just later discovered another asset that was on hand at the date of death that you didn't know about before. I use and we use supplemental inventories a lot of times for things like situations where your decedent might have been the beneficiary of another probate that was going on, and they didn't survive to get their final distribution. So we'll report it on hand at the date of death at 0, but we know it's there, and then we'll file a supplement for when that first estate closes and it pours into your estate. They're also used in ancillary probates that we'll talk about later on. Either I or another speaker will talk about ancillary administration. A reappraisal for sale, you have real property in your estate that is not sold within the first year of the date of death. You're going to want to get a reappraisal for sale so that your appraisal is not stale, basically. And that can be used in estates both where the sale has to be confirmed by the court or not. So you just want to make sure your appraisal of real property is up to date enough so that you're not looking like you really suffered a great loss if the value has dropped, and that gain isn't unreasonably reported. Okay, so reporting the assets. I have given you a form of INA in the materials. All of these things are available online from the California Probate Referee's website. It's probatereferees.org. I haven't gone there for a while. It's probably not changed a whole heck of a lot. There's a lot of useful information in there as well. You can find referees in other counties if you have something that comes up and you need someone with expertise in that area. There's a lot of good information on there. So let's walk through in about the 10 or so minutes I have left, 9 minutes, I guess, at this point, how to report some of these things and how to communicate with your probate referee. So inventory and appraisal attachment number 1, again, those are our cash assets. Described as a bank account, whether it's a checking account, savings account, whatever type of it is, it's a financial institution, an account number, the value, if there's uncashed checks, refund checks coming in, you'll describe that. You'll total that up yourself, and that will carry over to page 1 of the INA. You can do that. That's just money. You and your client can do that. Attachment 2 is all of the probate referee appraised assets, and you want to give your referee as much information as is going to be helpful for them to get information so that they can do their valuation. So if it's a piece of real property, you're going to want to describe it with the address as well as a assessor parcel number or legal description. You can put that on a separate attachment if you want. If you don't want to bulk up the form itself, you can just refer them to the legal there, attach it. Vehicles, you're going to want to describe the year, the make, the model, the VIN number, the condition of the vehicle. Same with any other kind of vehicle, a boat, an RV, anything of that nature. Stock, security, or securities and so forth. You're going to want to describe the number of shares, the name of the company, and I mentioned the CPIC number, which is again easy to find online. Every listed security has a CPIC number, which is an acronym for something I can't remember. But if I use each company, you can find that as well as the ticker symbol. So that's helpful for the referee as well. The referee will be able to determine if there's any accrued interest or dividends on that security as of the date of death. They'll put that on there for you. There's a description of someone's asking about savings bonds, how you describe those. So the idea is to really give the referee as much information as possible. We want to make their job easier so that they can turn around our inventory and get it back to us in time so that we can file. It's a bad feeling to be standing there at a status report concerning or a hearing on the status of filing the INA and have to kind of throw your probate referee under the bus. Well, I haven't gotten it back from the referee yet. No, not because I didn't get it to him until a week ago. So, we want to be timely, as timely as we can, at least within the things that are within our own control. Once you gathered all the information you need to put on your INA, and you've got it there, you send it to the referee with all the tools that they need to do their valuation. I've given you a sample letter, which is something you can use to send to the referee. They're going to want to know if there's unique issues with a house or a car or anything that might affect the value at all. You're going to want to provide that to them. Last minutes I have, if there's any questions, I'm happy to take those. In my last 5 minutes, I'll talk just about a couple of unusual issues that occasionally come up with respect to assets, marshaling your assets and gathering your assets in the estate. You can request to be relieved of the duty to marshal assets. I'll tell you, it's very unusual. The court's going to want to know why your client wants to be relieved of that duty. And it's usually related to things that are out of their control that are going to raise other issues in their estate. For example, they're in the custody and possession of someone else, and of course, going to ask to go get them, and there's tools you have to do that. If you have a situation where there might be property that come within your client's custody, but is not in the estate, those can be tricky issues. I'm thinking of things like, for example, I have an estate I'm handling right now that has 2 storage units, possible. They were both in the decedent's name, and she was paying the rental fees for those during her lifetime. I know not all the stuff in there belongs to her, belongs to other family members, and even though it's not part of my estate that I'm truly going to be responsible for, we now have custody of it. So we're going to want to make sure that that's insured and secured, and we're going to want to encourage people to get their stuff out of there as quickly as possible. So you still have a duty to maintain it. It's sort of akin to the duty that a landlord has when someone vacated property and they left their stuff there. There's a little thread there that still connects. There are sections of the probate code that give your client the power to compel the return and compel the providing of information about aspects of the estate if they're in the custody of another person, or to determine really who do they belong to. Do they belong to the decedent, or do they belong to the person that's holding them? And now these are not discovery rules in the broader Civil Discovery Act sense. These are very finite probate code discovery statutes that deal only with that issue. You can serve interrogatories, certain type citations, basically all just geared so that your client can get the information they need to figure out what's in the estate. Out-of-state real property, I'll mention very briefly. It is not subject to administration in California. It is governed by the laws of the jurisdiction where the estate is. So we would be, if we have a decedent that was domiciled here in California, had piece of property, say in Washington State, Washington State is going to go through their own procedures to marshal those assets, inventory them, figure out whatever Washington does to administer those assets. Ultimately, once subject to those rules of administration, those assets will come into the California estate because ultimately, as a parent estate, your client is going to be responsible for reporting on those, distributing them to the beneficiaries. But our court doesn't have any jurisdiction over how those are administered there. So it might be your client that's handling that as a Washington administrator, or it might be somebody else up there. Again, refer to the handout to have more information and examples for you. I've got a minute or so left. I'm happy to answer a quick question or two that comes up. Otherwise, we can start your next section anytime it's ready to go. I think I'm out of time.
We'll continue our program with our next speaker. We have Sandy Isaac, and I'll turn it over to Sandy.
Thank you. It's still morning, so good morning, everybody. I'm very excited to be here with you talking about creditors' claims, right? So handling creditors' claims and debts within an estate administration. Not the most favorite part for a lot of practitioners and a lot of attorneys dealing with probates. I know that this is often the scary part of a probate for some attorneys that are not as comfortable handling the creditors' claims portion, but I'm here today to hopefully give you a little bit more insight and confidence and demystify this area of our probate for administration process. So briefly about me, I'm a certified specialist in trust and estates. I also teach in the area of trust and estates at USD. I represent a lot of creditors, private, professional, non-professional fiduciaries in the state administration and the state litigation. And I do spend a lot of my time handling the creditors portion of it. So in my practice, I'm often the individual that comes in and handles challenging probates or ones that went sideways, insolvent probates, those ones where our debts outweigh our assets, right? And creditors, right? Creditors come in and we need to initiate litigation. We need to foreclose on a property within the probate. I like a lot of those challenging parts of the administration process. About my firm, because we do represent a lot of financial institutions, inevitably I do get on the creditor side. So we have 400 attorneys throughout 12 offices, and we are a primarily business law firm. Of course, this is information that my firm requires us to say that this is not legal or professional advice. So our main sections that I hope to cover during our time together is how do we ensure that all our debts are handled properly and correctly? What are some best practices, some tips, some just basic starters of how to handle and marshal all the debts and liabilities, right? Some sample forms. In my material portion, I did include quite a few of our sample forms, blank forms for you. So when I'm referring to them during my time together, you can look at that sample blank form. Our timeline, so this section, creditors claims, is very technical. It's very time sensitive, right? We have a lot of deadlines. So I'll be talking about what those are. And then some of the nuance, right? What if we have late claims or amended claims, contested claims, right? And lastly, insolvent estates. Okay, so before I get into kind of the meat and potatoes, I want to take a step back for a minute, right? I want us to think of the overarching purpose of an estate administration, of a probate, right? Our 300,000 foot view, right? Our purpose of a probate, unlike what my clients think or beneficiaries think, right, is not to fast forward and give all the money to the heirs or the beneficiaries of an estate. That's secondary, right? The primary purpose of a probate administration is to wind up the life of the decedent, right? Is to make sure that we handle this decedent's life properly. And so that's number one. And then secondly, once we've dealt with the life of the decedent, right? Their creditors, their debts, their taxes, their liabilities, then whatever is left over, right? Step two of the probate is then distribute to our rightful heirs or beneficiaries. So many people want to fast forward to the part two, which is when do I get my money? When do I get my inheritance? But really that's secondary, right? Our primary purpose of an estate administration is deal with the life of the decedent. So when we're dealing with creditors and we're talking about creditors, I want to remind us that we're talking about the creditors of the decedent, right? Those from date of death before, right? Not post-mortem, not after date of death. And I remind us of this because a lot of people will want to add in administrative expenses or debts, like things that were incurred in the course of the administration. In other words, after death, those are not creditors' claims. So our creditors' claims are everything rising from the decedent from the date of death before that, right? So our beneficiaries in a probate, right? We need to make sure that they have title to the assets, right? Part of winding up the life of the decedent is making sure that we have established new legal owners of these assets, right? If it's property, real estate, tangible cash, whatever, right? So I know that we just wrapped up marshaling this asset, so this is appropriate. In that all those things that we have in a probate, all that decedent's assets, right? We have to establish who the new legal owners are, right? So our beneficiaries are our heirs at law. But we have to give our beneficiaries and heirs peace of mind to know that they have received legal ownership. And the only way to do that is make sure that our debts and liabilities are handled legally and properly, right? So our creditors' claim, right, is governed by our California Probate Code, also local rules of court, and every jurisdiction in our, 50 plus counties in California may have a couple of different ways to handle some creditors' claims. So always ensure that not only are you reviewing our California Probate Code, but also local rules as well. So who are creditors? Often when I'm having a conversation about the creditors of the decedent, I go through a long list. And I do that because we often forget creditors, right? A good place to start is pulling a credit report, right? Obtain a credit report to see if there's creditors that we missed. We didn't get the mail for that creditor. We didn't know mom or dad had these debts, right? So good place to start, but a little practice tip is obtain the credit report. There is a decedent procedure by all of the 3 credit bureaus for that. But creditors can be unsecured creditors, like our credit card companies. They can be our tax collecting agencies. So that may be Franchise Tax Board, IRS, medical facilities, right? Last illness, hospital, ambulance bills, any of those type of medical, and those bills may not be generated for many, many months after. But they were based on the life of the decedent, right? It could be funeral or burial services. Those are a little nuance of creditors' claims, so they're handled a little bit differently. And then service providers, right? We may have attorneys that represented the decedent. We may have accountants or CPAs, tax preparers, investment advisors, or plaintiffs in a tort case. So if we had any lawsuits or potential claims or credit or liabilities that would pass on to the decedent's estate, we must include those as well. So the personal representative in our probate estate, they must, in good faith, exercise whatever due diligence they can to ascertain the creditors of the decedent, right? So some basic ways to make sure that we do that. Forward all the mail, right? Make sure that we file mail forwarding so that there's no lost mail, especially if people are coming in or out, or we don't have control of the property. There's other people residing in the property. We want to make sure that we forward just the decedent's mail, right? Like I mentioned, obtain credit report, go through all their files, their paperwork, tax returns. Sometimes that will lead us to other potential creditors or liabilities that may exist. Another basic duty, right, is that personal representative. They are considered to have knowledge of these creditors if a creditor has demanded payment. And what that means is if they've sent notice, they've sent an invoice, they've sent something, right? The personal representative is imbued with that knowledge now and must include them as a creditor. Now, we cannot forward to be in a position to distribute the estate to the heirs or beneficiaries until those liabilities and creditors are settled. In other words, until we've dealt with maybe underlying litigation or it's the expiration of our creditor's claim period, the estate is not in a condition to be closed. So I'm going through this argument right now with some clients that are sole beneficiaries, and they don't understand why we can't forward to the petition for final distribution. And that's because we have to give that statutory creditor period waiting time. We need to make sure if anybody's coming out of the woodwork or our notice creditors, and I'll talk specifically about those timelines right now. So are required notices. So required notices, just like decedent's assets, vary in each estate administration. It varies because just like decedents have different assets, decedents have different liabilities and creditors. So often we provide specific notices to each creditors, but everyone gets our general publication. So our two main types of notice is the first one that we give when we file a petition for probate. So that is our publication, right? Our publication is notice to the world that this decedent has passed away, there's a probate proceeding, there's a case number, there's which court to file, and it gives the world, potential creditors, unascertained creditors, the ability to file their claims. So that's our first type of notice, which if you've already gotten this far and have an appointed administrator, this first notice is already complied with. So that's our publication in the newspaper where the decedent lived, right? The general circulation newspaper where the decedent lived. Our second type of notice to creditor is our notice to administer, and that's a judicial counsel form. I gave that to you as a sample. I believe it's our first sample, and it is our judicial counsel form DE 157. So this notice is given within either 4 months of appointment or 30 days after a personal representative learns of a creditor. So it must be essentially your probate administrator or personal representative, executor is appointed. Within the next 4 months, this second notice must be served. So that is our judicial counsel required notice of administration to known and reasonably ascertained creditors. Now, if we have an estate, which I often hear, oh, mom or dad didn't have any creditors, this decedent didn't have any creditors. So in those situations, we still have that those two requirements, right? We still have publication because that's already done, and we still have our notice of administration because there's at minimum 2 creditors that apply to really all decedents that we need to send. So even if they didn't owe American Express or they didn't have all these creditors, we still, it is best practice, I should say, to send the notice of administration to known creditors to the Department of Healthcare Services and the California Franchise Task Board, right? We then file our proof that we serve this required notice to those 2 agencies at minimum, and that's what starts the clock. Now, obviously, in the states where we have a lot more creditors, then we're going to have maybe a laundry list of other creditors. But the sooner we can send out that creditor's notice, right, the notice of administration, the sooner our clock starts ticking. So it does no one any good to wait to send that notice, right? Because from there, that is where the creditor is given their timeline that they must file a creditor's claim, right? So our job my job often as representative of an administrator is get that notice out right away, right? My job as counsel for a creditor is once I get that notice on the creditor side, I need to file my creditor's claim as soon as possible. So our creditors, right, who receive that notice, now, even if they're not properly noticed, right? So maybe a creditor didn't get on that list, right? Either the personal representative didn't know about that creditor, or they intentionally excluded, didn't think they should notice them, whatever the case may be, right? That creditor, if you believe you are a creditor, again, regardless if you were served notice or not, you must then make a demand for payment that the decedent incurred during their lifetime, right? And we do that through a specific judicial counsel creditor's claim form. Examples of different types of liabilities that arose during our decedent's lifetime. So they may be personal injury. I've had a few of those where my decedent allegedly caused the harm of our, plaintiffs in this case, right? The scenario is that the decedent got in a car accident and before their death, and there is this personal injury where the decedent was the named plaintiff, right? Or a wrongful death or property damage, right? Some type of claim that arose during the life of the decedent. Those are also potential creditors. Now, I always err on the side of over notice. So not everybody agrees with that perspective, and that's fine. We don't need to debate that. But I would rather over notice than someone say, you knew that we were a creditor, or either constructive notice or actual notice. You should have known, but you failed to provide notice, right? So I don't want any indications that my personal representative or executor did anything wrong. And when I have a choice to err on over notice, that is what I do. So even if creditors, are minimal, like say our electric company or our water company, it does not hurt to send them that required administrative notice, because then the burden is on them. So that's what's important, is now we're shifting the burden. We're shifting the burden to those creditors to file their claim timely. they do not file their claim timely, they are barred. So we want to make sure that we get those out. Forward here. So now when a creditor wants to file a claim, right? It can either be filed by the creditor specifically or an agent of the creditor. So maybe the creditor's American Express and they have some servicing agency handling it. Now, a lot of our large institutional creditors or financial institutions, they're going to have whole departments for handling this. But what gets really tricky and really messy is when we have family members, right? I just dealt with some creditor litigation within my probate, and it was the mother of the decedent. She had filed like 4 creditors' claim of money that she had allegedly loaned the decedent, right? My argument was that it was a gift. But sometimes when you don't think, well, I'm going to send a creditor's notice to the family, the parents of the decedent or the friend of the decedent. But if there's any indication that they believe that they loaned money to the decedent, like in this case, the mother had sent a letter, just a plain letter saying, my son borrowed all this money from me before he died. What are you going to do about it? Now, she was unrepresented. She didn't know there was a whole creditor's claim process, but I had reasonable knowledge that there's potential family member creditor. So we send the notice. And now the burden is on the creditor to file their creditor's claim, serve it on the representative, right? If there hasn't been a representative appointed, then, once that representative is appointed, now that claim, right, our creditor's claim that the creditor files is not properly filed. If it's not properly filed and served, then it can be deemed rejected, right? So that's a big deal, right? Rejecting a creditor's claim, and our personal representative wants to make sure that they investigate and they review that creditor's claim. Did they complete it correctly? Is it the right type of claim? What's the claim amount? So part of that representative duty is, if I get a creditor's claim from, say, a family member or a friend, and it just says, the decedent owed me $10,000, I'm going to say, okay, great, thank you for telling me that, but what supporting documents do you have to support this, right? So there's 2 approaches to that, right? So say you get a creditor's claim that's deficient in some manner, right? The one path would be respond to that creditor with a list of the information you need to support their claim, right? It's statements, it's canceled checks, it's a written contract, it's documents, whatever it is, right? Not just the filled out creditor's claim. Or second approach would be just reject the creditor's claim, right? Make them file a lawsuit and maybe you tell them why the claim is rejected, right? Or you don't, and they have that now they again have the burden to do something about your rejected claim. Maybe they call, they write and say, why'd you reject this claim? And you say, well, it's because give me the underlying agreement, give me the contract, right? Sometimes with credit, with like lenders or like cash advance places, those types, they don't send you a statement. They don't send you the period. They don't send you what interest is included. Because a little tip, right? If we have a credit card or any type of lender, cash advance, thing like that, they cannot include penalties and interest after the date of death of the decedent. So sometimes a creditor will file at 6 months and it's been accruing interest and late fees and penalties for all these months after the death of the decedent, and they include that in the claim, and those are not proper charges. So it's important for the personal representative to investigate, to request supporting documents before allowing or rejecting a claim. So the options that a personal representative has is allow or reject the claim. So absent supporting documents, reject the claim, right? Now, the personal representative, if the estate is clearly solvent and that there's enough money in the state to likely pay everyone, the representative has the option to allow that claim. So they would use that creditor's claim, they would check the allowance, they'd sign it, and then they would file their allowance, which is a separate judicial counsel form. I believe I gave that as a sample as well. I'm going to forward this. Here we go. Okay. Now, in a circumstance where we have a amended claim, right? We have a creditor that decided, you know what, that's not the correct amount. It's either more, it's less, or there's more claims. In my example that I gave with the decedent that had his mom file creditor's claim, mom actually filed 4 separate creditor's claims. She filed one for, for example, 10,000, another one for 5,000. I think she just kept going through her check registry or her bank account and realized, oh, I gave my son, 5,000 on this day, and then another 6,000 on this day. So she ended up filing 4 creditors' claims. Here's a little practice tip, right? If you have an individual creditor that files multiple claims, right? The court looks at those as 4 separate claims, right? Now, once this creditor figures it out and the total amount, for example, say the total amount is $50,000 of all those 4 claims, and then they file another amended claim that it's a consolidated claim. Sometimes I see those. The court sees that as another claim. So then fast forward when you're trying to settle the estate, you've dealt with this amended claim, you filed the satisfaction. The court's going to give you a defect or note to clear and say, what about those 4 other claims? And you say, well, Your Honor, that was handled through this amended claim or consolidated claim. They'll say, well, you should have rejected those 4 claims or required the creditor to withdraw those 4 claims. Because we always have to deal with a filed creditor's claim. It's either they withdraw it, it's satisfied because it's paid, right? A satisfaction, or it's rejected. So we have to do something with each claim that makes the docket. So we can't just say, well, that makes sense. They filed this amended claim. No, we still have to handle those other claims. Now, if we have a claim that's not timely filed, then it must be rejected. Okay, I already talked about our allowance and rejection. Okay, now if we have estates that are clearly solvent in that there is enough money, right? We know there's enough money to pay all the claims. Then the personal representative has the option to allow the creditor claims that they believe is proper, right? And these debts must be due. In other words, they're not contingent, they're not in dispute. They are claims that are rightful debts of the decedent. So our administrator in that situation, they can pay and allow those claims prior to the creditor's 1-year statute of limitation period, right? So a creditor has 1 year from date of death. Let me see if it's my next slide. Here we go. Okay. 1 year from date of death to file the creditor's claim, right? Right here. Claims must be filed within 1 year of a decedent's date of death. So if a creditor has filed, they got proper notice, or maybe they didn't, right? And it's been 1 year past the date of death of the decedent. Their claims are barred. Now, I went to a judicial, like an annual judicial update, and I still remember one of the attendees talking to the judges, really arguing to the judge and say, but how is this 1 year such a bright line rule where sometimes you don't even have a probate initiated for over a year, right? As in someone didn't know they needed to file probate of this decedent's estate. So even though you still have to send this notice of administration and you tell the creditors you have 30 days to file a claim or you have this and that, right? How are you as the administrator sending this notice telling the creditors you have so many days to file their claims when they are over the 1 year already? And the judge says, yeah, absolutely. That's what will happen, right? And I remember that attorney saying, well, couldn't you just have unscrupulous family members, unscrupulous personal representatives just wait to file a probate? Why doesn't everybody just wait to file after the 1 year so then these creditors are barred? And the judge answering that question said, well, because often we can't wait, right? There's timely things. We need to get access to the funds of the decedent. We need to deal with the real estate of the decedent. We need to collect and marshal the assets up. Not every estate, very few estates have the luxury of waiting, right? Often something has to be done with a decedent's estate, right? I'm dealing with a decedent's estate where my decedent just died, on a Tuesday. It was the last week. She died on a Tuesday. By Wednesday morning, I already have all the family member trying to initiate proceedings. I mean, talk about not waiting. I mean, sometimes you have the opposite. People won't even wait a full day from date of death to start proceedings. So we have a lot of timelines when it comes to dealing with creditors. So once a creditor receives the administrator's notice, they have to file their creditor's claim, right? They have to file it timely. If they file it timely within the 1 year and within the period that's stated on that notice and within the 1 year, then our administrator can allow it, can pay it in the normal course of business. Now, our time barred claim. Now what? What happens? And often this is where I step in on creditor situation. And I have some fake client that got a rejected creditor's claim, and now what, right? So if we have a time barred claim past the 1 year, we're SOL, right? Now we have different situations if we have secured creditors, and I do talk about that in my material. So our creditor who has a security interest as in collateral, right? A first deed of trust, something where they have collateral of the real property, they still have their foreclosure options. They still have their remedies under that deed of trust if they have power of sale and all of that. So, and that's some of our statutory exceptions as well. But creditors who fail to file a claim are forever barred, right? Now, if we have a situation where they had their claim rejected, then the creditor must initiate litigation. Now, if a personal representative fails to give notice, right? Oh my gosh, I didn't know that this creditor existed, right? I did all the things that you told me. I filed the creditors, I got all the mail, and I still didn't know that these creditors exist, right? Typically, the personal representatives are generally immune from liability, right? If they acted in good faith, if they can file a declaration of due diligence. I did all these things to find the creditors, right? They're generally immune. Those are our safeguards in place. But our personal representatives are not immune or will not be immune from liability if our creditor can establish that failure to give them notice was in bad faith. In other words, that personal representative knew that creditor existed and purposefully chose not to give them notice, right? They were acting in bad faith. If the creditor had no actual knowledge of the administration prior to the end of filing that creditor's claim period, And if they had filed it, they would have likely been paid timely. And the creditor has to petition for relief within 16 months after the letters are issued and gives notice. So if a creditor goes through these steps and these apply, then potentially the personal representative may be sanctioned, or potential grounds for removal. These would be up to the discretion of the court as to what would be the appropriate remedies if a creditor established that the personal representative acted in bad faith. Now, often, another whole section of creditors' claims is those that are disputed, right? Now, if a creditor provides supporting documents, and they're ordinary creditors like all of us have, right? Most of those are pretty straightforward. But sometimes, like in my example, I'll keep referring to the mom of the decedent, those were disputed claims, right? How do we know that those were loans? How do we not know they're gifts? Or that amount, I show records that the decedent made certain payments back to mom. So really, he should owe $20,000, not $50,000, right? So any claims are in dispute, right? And their claim has been rejected or deemed rejected, right? In other words, if it's not allowed, it's deemed rejected. Then that creditor now has the burden to file the lawsuit against the decedent's estate, the personal representative, to recover on that rejected claim. I often step in and handle some of these complaints on rejected creditors' claims, usually what we caption them. Maybe it's on an underlying breach of contract action or some other enforceable promise. So our creditor now must file the appropriate underlying litigation. So then I would get out of probate court, I'd step into civil court, and I would file my civil lawsuit, my complaint against the personal representative regarding the estate because of that rejected claim. A creditor.
Sandy, I don't want to interrupt you. I don't know if you got my message. I'm not sure if you got my message, but you have 10 minutes left.
Oh, thank you. Yes, thank you. Our creditor can't move forward with filing a lawsuit without that rejection. So that rejection, either the actual rejection or the deemed rejection, is a prerequisite of that creditor filing that lawsuit. So they can't just decide, well, we're going to litigate this anyways. No, they must have received the rejection or it deemed rejected because of expiration. Maybe the personal representative hasn't got around to things. So that is a requirement that the creditor must meet before they initiate their lawsuit. Okay, I fast forwarded to that already, actually. Okay, so our lawsuit on rejected claims, briefly talked about that. It is typically commenced, it can be commenced probate, and it could also be commenced in civil or any other appropriate court. Now, often, another kind of wrench that we get thrown in the creditor's portion of our probate proceeding is if we have an interested party that contests the personal representative action. So if a personal representative has allowed a claim and then someone contests it, right? So in other words, I allow the mom of the decedent's claim because I think they're valid after we went back and forth, and now I have the beneficiary heir of the estate contest that my personal representative's action that they allowed the claim. This is a possibility in the state as well. So an interested person does have the ability to contest a claim as well. It's not just the personal representative. So they are not the end all be all of the approval a interested party also has the ability to contest a claim if they don't believe it was allowed properly or approved properly. A very quick nuance on that. A personal representative does not have the ability to approve their own creditor's claim. If, say, the personal representative is the sister of the decedent, and the sister also was a creditor because she loaned her, brother $10,000, she can file her creditor's claim and set it for hearing, and the court will approve or reject it. A creditor that is also the personal representative cannot approve their own claim. Now, ending with some of our insolvent estates. So if we don't have enough money to pay everything, then our probate kind of operates like a bankruptcy. And now we have a priority system, right? Some creditors are favored over others. And we have our probate code that governs the payment of creditors in a specific order, right? I'm going to move forward from our insolvent estates. There's our priority here, right? Those owed to the state, administrative of the estate, like our personal representative and attorney fees, anything that's secured, then funeral, then family allowances, wage, and very, very last are our unsecured creditors, like our credit cards, things like that. Okay, I'm going to forward this one. Now, and when we deal with creditors, we want to make sure that we always review, again, our statutory rules, because we may have different ones for probate, local rules, and we have statutory. We always want to make sure that we give everything is timely, that you set deadlines, that you send reminders, because the creditor portion, again, is very, very time sensitive. We want to make sure that if we have creditors that have security interests, that we understand that they don't have to file creditors' claims the same way. So those in our states that have mortgages, California is a deed of trust state, they typically do not have to file the creditors' claim proceeding, because you have a trustee that sits in the power to foreclose, right? Those deeds of trust that have power of sale, they can step in and just start foreclosure proceedings. I've done a lot of those where I'm sitting on the creditor side foreclosing on property within a probate, and I don't care that my claim was rejected. Sometimes they don't file claims. I still have all my powers under the deed of trust to foreclose. So those are not escaped by the creditor's claim proceeding. When we have property that needs to be sold, we do need to make sure that we give the proper notices to any of the creditors within that property. Sometimes those notices are NOPAs, right? So I'd like to say, do we NOPA or not NOPA, right? Our Independent Administration of Estate Act tells us what we should send a NOPA, right? So if we have real estate or business with creditors, we may want to send those NOPAs out. And then certain acts are not required to send out NOPAs. So good
Notice of proposed action.
to go through the list that if an administrator has independent powers, what do they not have to send a NOPA for, and what are the required actions for NOPA? These are important in our creditors claim discussion, because a lot of our creditors are often have overlying issues with those things that NOPAs are required for, right? Selling business, selling property, encumbered estate property. And I don't need to go through our NOPA procedure. We can, you can review the sample that I gave you as well if you're not familiar with our notice of proposed action, our NOPAs. So in my couple of minutes that I have left, and I know I gave you a lot of information, this is a very dense subject, but don't shy away from it, right? I have a couple of attorneys in my office that they will handle very simple routine probate, But if one creditor is involved, they want to bow out, right? Because it can be intimidating our creditors claim process. But once you get the timelines, once you're organized, it really isn't as complicated as some like to make it out. So a couple of final thoughts I want to leave you with. It can be a challenging part, especially if you have all these creditors fighting over the estate. But if the personal representative and their counsel is organized, calendars, everything appropriate, it really is just routine, right? And just like our decedent's assets are unique, right? No two probates are the same, right? No two people are the same. They have different assets, and so do they have different creditors, right? I've yet to have two estates that have the same creditors, the same assets. So our creditors are also very unique, and often, even in my experience and comfort level navigating through this, I will still get a creditor once in a while that I'm like, I've never handled this before. Oh gosh, how do I handle this, right? So it is an area of probate that will keep people on their toes, because once in a while we get a weird creditor, but it's definitely not insurmountable, should not be a source of stress for our administrator or anyone in a probate. It is highly regulated, highly technical, and our court oversees that, right? So I hope that this is not an area that people shy away from, but embrace. I like a lot of rules, and I like that this area gives us a lot of rules within that. So I hope that you found my time with you today informative and my material informative. And I wish, all our viewers and our attendees today the best of luck as they, engage in some of these, maybe on the professional side. But that is what I have for you guys today. So thank you so much for MBI for having me. We'll now continue our program with our next speaker. We have Julian Lacasse, and I'll turn it over to Julian.
Thanks, Shanae. Am I still muted? No, I don't think so.
No,
Okay,
you're
cool.
good to go.
Sweet. Hi, everybody. Thanks for being here. I think it probably goes without saying that this segment has more material than I'll be able to cover in 45 minutes. We're talking about complex issues in estate administration. So that kind of tells you all you need to know already. One comment before we get started: you may hear my dog bark. Try to ignore her. Lots of stuff going on outside. So I am only licensed in California, which is good because we're only talking about California law and federal. And I currently work as a counsel to some attorneys in the area. I live in Oakland, but I work out of Palo Alto. I grew up surfing. I love to cook, and then I love to eat what I cook. So I'm hoping that these first few slides will be a review for everyone. But even if they are, I think it's worthwhile to go over this because a lot of the material that I'll be discussing today has to do with characterization of property and how does that affect the passage at death of that property in a probate. And I do a lot of trust administrations as well, so I will touch here and there on trusts, especially if there's some overlap. So be aware of that. One last note that I've just remembered: I got rid of most of the statutory references in the slides because space. If you are looking for the statute, please go to the written materials, and all the citations should be there, with the exception of some especially onerous ones like U.S. savings bonds, treasury regulations, that kind of stuff. But if you need that, let me know, and I will do my best to find it. So first things first, community property versus separate property. Community property is all property acquired during the existence of the community. That means while the spouses are married. Separate property is anything acquired prior to marriage, after dissolution, or by gift or inheritance. You're welcome to borrow those definitions. I simplify the statutory definitions because I think that they are unnecessarily complicated, but so is so much of what we do. That's relevant because our first topic today is jointly held assets. The main issue with the jointly held asset is with whom is it held? If you are dealing with assets jointly held by spouses, then you are going to be dealing with community versus separate property. If you are dealing with jointly held assets with non-spouses, that could be any third party or any friend, family member, whatever, then of course there are different rules. Community versus separate property character is not necessarily relevant unless there's also a spouse in the picture. And you will be looking to form a title, among other things, for how that property will succeed at that. So first thing to look at, second thing, title. Evidence Code 662 says that the whatever form title is in is presumed to be the true titling of the property. It's a little bit circuitous, but that's the case. So if you have clear title on an asset, for example, joint tenancy, then that's going to pass to the other joint tenant at the one joint tenant step by operation of law. Outside of probate, outside of a trust administration, doesn't matter. That's what happens on that. So there, you can think of this as multiple levels because you can be tenants in common, but it could also be community property if we're talking about real property. So those two things may be in conflict and they may not. The main conflict in terms of title and character that I come across is joint tenancy property versus community property. And we'll get into a couple of examples of that in just a few moments. So if community property, the surviving spouse retains her interest, the decedent's interest probably passes to the spouse. If there's no effective testamentary disposition, i.e. no will, then the decedent's 1/2 passes to the surviving spouse. Separate property may go to the spouse by will, but because it's separate property, it could also go to any other person. When we are talking about administering an estate, do we need to formally probate the assets in order to distribute them to whomever they go? Here are the things you should think of. What's the character, real or personal property? Is it all in California? What's the form of title? Evidence Code 662. Beneficiary designations, those pass without formal probate. And the value of the assets vis-a-vis statutory limitations. And here I'm specifically referring to, although there are others, the small estate procedures in Probate Code 13100 and following. The first thing that you always want to do, and this is I'm going to try to keep my presentation geared toward practical tips versus what the lawyery interpretation is, because when you are administering a estate or doing anything as an attorney, at least this has been my experience, there is what does the law say, and then there is how practically do I handle this situation. So I think you can go look in the probate code if you want what the law says, but hearing from someone like me is valuable because I can tell you what in practice is relevant to the situation, what you should be considering, and how to go about it. So information collecting is key, always, always. That is true without regard to type of asset, character, titling, whatever. You just want to know. You need to know everything you can about the asset. So your client, who is probably the personal rep, will be able to, hopefully, provide for you deeds or account statements if we're talking about any type of financial institution holding. Prior tax filings can be useful, especially for business interests or assets that the ownership or the character of it in the way it distributes cash or distributed to the decedent are a little bit more complicated. So always keep in mind that that can be helpful. If there's any official correspondence, and here I'm talking about mainly real property, the county sends all of these letters, which I hope you're familiar with, to your clients saying, what's going on? We got this filing. This is unclear. Call us back. And so this is just editorializing. If you work on those type of issues, specifically reassessment of properties, keep a list in the recorder of the people who are contacting you from the assessor's office and their phone numbers. That will be helpful. So community property and quasi-community property, I've lumped them in together. Oh, and I've also lumped in spouses and registered domestic partners. Under California law, they get the same benefits with regard to jointly held assets. Under federal law, they are treated differently. And you should keep that in mind. So typically when we're talking about federal law and the difference between spouses and registered domestic partners, it's specifically talking about tax. So anytime you have a tax related issue, and the tax areas we're worried about are income, estate, and property, then you should be thinking, is this registered domestic partnership? And if so, do I need to worry about a difference from how I would treat this were it spouses? There are two ways to divide community property among a surviving spouse and a decedent. The first is item theory. That divides assets based on the idea that each spouse owns one half of each asset. So you're taking everything, lining it up, and cutting it down the middle. Aggregate theory, however, is the allocation of certain assets such that each of the 50% interests of the spouses equals the same amount. So you get a little bit greater freedom with aggregate theory, and you should feel free to divide however you're most comfortable. I think that that is something that you can decide with your client. If there are certain assets that you want allocated specifically to certain people or places or purposes, that's something to keep in mind. Just know that you can do it as long as you have enough assets on the other side to equalize the shares, or use something a little bit crafty like a promissory note. Something to stay aware of, issue spotting when you're dividing community property. If it's non-equal and the difference is made up with separate property, the IRS may consider it a sale or exchange, i.e. a gift of the separate property that was used to equalize the shares, triggering tax. So if there could be an income tax consequence, which is taxable gain is the difference between the fair market value of the portion at the time it was sold or exchanged and the community's adjusted basis in the assets, what the value was when it was acquired versus now. That's the adjusted basis. And it could also trigger gift tax liability. So you may be filing a 7M. Something to stay aware of. You should also keep a list of good CPAs or tax preparers that you know who are capable of filing those kind of returns, because you can do it yourself, but you need a special certification. And frankly, it's just boring work that takes forever. Oh, here I know, yeah, RDPs and RDCs stepped up basis because that's federal income tax law. Feel free to ask me any questions about that if you have them. When you have joint tenants, the surviving joint tenant or joint tenants take the decedent's interest by operation of law. So it may be 3, it goes to 2 because your decedent is dead. The remaining 2 now each own an undivided 1/2, sort of, but it's in joint tenancy. So on the second of the 3 people's death, it will go to the 1 survivor. This is something that trips people up. The titling language itself does not need to include a reference to right of survivorship. The right of survivorship is implied in any joint tenancy property. That is, per California law, it's well established. So don't get freaked out if it doesn't say with right of survivorship. Here are the joint tenancy scenarios I was talking about where you have a conflict between the character and the title. The third party and the decedent are joint tenants on title, but the surviving spouse claims an interest. And that surviving spouse would be saying, wait a minute, that was community property. I should own one half. If they succeed, the joint tenancy is severed, becomes a tenancy in common, and the one half, or I guess 1/3 community interest would go to the surviving spouse, and then the decedent and the third party each take their share as well. Where you have a surviving spouse and decedent held property as joint tenants, the third party claims that the property was CP, was community property, and that third party is a devisee under a will. So now we're in probate land, trust or other state planning document. That's confusing because it seems like whose claim is, sorry, I'm getting distracted by this question. A trust always will, okay, so here's the question. When could a trust override probate code 100 division? When the trust provisions say so, basically. So a trust is an agreement, it's a contract between two parties, and typically each spouse can devise his or her community property interest, but if they're spouses, then the deceased spouse's interest goes to the surviving spouse to take advantage of the unlimited marital exemption. And then on the second death, that property will be distributed or divided to whomever. If we're talking about irrevocable trusts, that is more complicated and I think a topic for another day, since we're doing estate administration. But good question. So the answer to this number 2 scenario I have here is, under current law, the joint tenancy property will pass to the surviving spouse unless there is a written agreement transmuting it to community property. Transmutations are their own issue. They have their own requirements. I encourage you to look them up. But if you do think about doing transmutations, then you should be aware of the ethical issues that lie therein. With regard to you're representing one party and both parties have to be represented, so you may want to shop them out to family law counsel anyway. So determination of the character of community property of the joint tenancy is usually sought by petition to determine title to property. That is what we commonly call a Hegstead petition. Some counties you can file a petition for instructions to determine that, or petition to determine entitlement distribution of the estate. That's deep in the probate code, 11700, 11705. Those, I have never filed one of those petitions. I've never had to. So always check the local rules or ask someone who knows. That could be your paralegal. That could be someone at the court. That's the most direct way to get an answer to a question, is ask somebody who knows. So if we're talking about trust assets, they pass according to the trust provisions. If your assets that you're dealing with have beneficiary designations and the beneficiaries are living, this is an assumption that I'm going to operate under, then those assets will pass to those beneficiaries because that was how they were designated to. If you are dealing with retirement assets or tax deferred accounts, especially if the decedent's intent was to transfer those assets to charity on death, you are going to want to get cozy with the Secure Act. And it is so voluminous and it's counterintuitive. So anyway, take a look. Hopefully you are good at searching for the sections that you need, because it can be hard to figure out where you need to be. Some issues arise from pre-deceased beneficiary. As I mentioned, the asset can become part of the estate if there's no secondary beneficiary named, or if it's designated to beneficiaries 50% each. Where does that 50% go? Right. So there's a million ways that this can become more complicated. A life estate is another form of jointly held property. the holder of the life estate will beneficial title, but the reversion interest remains with the real title holder. There's a name for it that I'm blanking on. Typically, you would file an affidavit with the county recorder to retitle to or from the life estate holder, and it would just use that language as to a life estate or for her lifetime or something like that. That will give you the effect of granting a life estate to whoever is the holder. On the decedent life tenant's death, possession goes back to the grantor or to the grantor's successors. So it may be that I have a case that the wife died, but her home was separate property. Husband gets to live there for his lifetime, but on his death, it's going to get split between her two children who are not his kids. So that was done via trust. So that trust administration is going to be going on for a long time. And I encourage you to get comfortable with those type of scenarios. Often it's helpful to create a timeline where you can say, okay, so here's what we need to reserve for this amount of time. Here's how long we imagine this administration may continue. So this is the same if you're in a probate scenario where a life estate is granted. All issues to be aware of. So the life estate sounds subject to administration in the decedent's estate, but record title must be cleared. And so that's what I was saying. You do that with an affidavit. You file that with the county recorder. All right, moving. U.S. savings bonds. This is a little bit of a funny issue. I don't know. None of my clients own U.S. savings bonds, but it seems like they do get mentioned a lot. So the things you should know are if the bonds are owned in co-ownership form, that's joint tenancy, or beneficiary form, that's payable on death, POD, same as you can have a bank account or anything else, if the bank lets you. Then the client will need to go to the local branch of the Fed or a typically large commercial bank with the ability to redeem or reissue the securities to the beneficiary. Redeem is cash out, reissue is same as with a stock certificate. They will give you new bonds in place of the old ones. So Treasury regs, take a look at those. The small state procedure 3100 is done via affidavit. That is some of the technical stuff, procedural. We'll skip it because I'm noticing that I only have like 30 more minutes. No, not even. Okay, so yeah, 13100. Number 2, spousal claims. So like in those joint tenancy versus community property scenarios that I outlined, what is a spouse able to claim? What is his or her interest? Those are all the issues for this section. The biggest issue that I have run into in terms of contest is whether there was consent to make a gift during life. There are all of these statutes dealing with consent. What if it was revoked? What if it was modified? So we'll go through a couple of those. Here's your issue. If the transfer of typically marital property was to someone other than the surviving spouse, then the surviving spouse can object and claim an interest in that property. If the decedent is already dead, then they have to either submit evidence or deal with it. If it's not a decedent, if your spouse is still living, then there may be a little bit more wiggle room. So here's your example: third-party recipients, a former spouse. So second marriage, spouse of the first marriage, claims rights in decedent's property based on a marital settlement agreement. If community property is involved in the transfer, the surviving spouse may have a right to recover the community property interest. So in that scenario, you'll be doing some tracing. You will be looking at what another timeline issue where that could be helpful, where you'll say, when was the existence of the community? When was the asset acquired? What source were the funds from to acquire the asset? And keep going down that road until you have an answer, or you settle. Consent and waiver. I encourage you to look through all of this. I don't know that I have time to review all of these slides. This is pretty intuitive. Consent is revocable during marriage or on termination by legal separation. It is revocable on termination by dissolution if the transfer is not determined under statute 5040. So if it survives a dissolution, written consent becomes irrevocable on the death of either spouse. That seems obvious. You can't come back to take away the consent you've already given if you're dead. We have another question here. Does community property transferred to a trust remain community property after this first spouse dies? Sort of. If we're talking about a third-party claim to that property, you will have to characterize it. Strictly speaking, because there's no more community, there is no community property. Depending on the trust provision, so always read the contract and read the statute. Those are the two things you do in every case. Then it may pass differently. So it depends on the circumstances of your case, but sometimes yes, sometimes no. Spousal claims, what if there's no consent? Can't do it, can't make the gift, I mean. Here are some specific cases talking about what kind of claims a spouse might make. Transfer to a former spouse, that was the scenario we were just discussing. Well, I was talking at you about. General rule is transfers to former spouses fail if the decedent and the former spouse were not married at the decedent's date of death. Why? Because they're no longer a spouse. They don't have an interest in the property. And the law says you are more likely to give your assets to a current spouse than to a former spouse. So the sections you'll need to review are 5040 to 5048. Non-probate transfers to a former spouse will not fail if the transfer is not revocable by the transferor at the time of death, or clear and convincing evidence that the transferor intended to preserve the transfer to the former spouse. Clear and convincing evidence in that case would be shown by, for example, marital settlement agreement, any other notes or emails, or, there's a plethora of evidence that could sway a court in your favor on that issue, but that's the standard. Allowances is one of the topics that was specifically carved out in the outline, so I will review it now. The purpose of a court-ordered allowance is to ease the economic hardship suffered by those whom D either had a duty to support or actually did while administration of the estate is ongoing. Probate Code Section 6540 mandates that the court order family allowance for some people and may order a family allowance for some other people. I'll talk about that in more detail in just a moment. The right to claim a family allowance depends on the right to support and the existence of a statutorily specified relationship between the claimant and the decedent. It has nothing to do with the decedent's intent. Whether the decedent intended to continue providing for this person or not is what I mean by that. The court is basically, well, like I said, mandated in some cases with regard to some relationships, and in others, permissively can award the allowance. The potential downsides of an allowance are you may eat up the estate with the allowance payments, or the decedent's will can contain a provision requiring the surviving spouse to elect his or her requests via the will, or in their stead to take a family allowance. That is uncommon, especially since if you have taken the time to make a will in California, hopefully you've taken the time to establish a trust, and so that will not be an issue. So you can use a spousal property petition to outline what the assets were, explain that they were acquired during marriage, give a little bit of backstory about the couple's lives, and that is a non-probate transfer vehicle, spousal property petition. So it will, those assets that would be subject to allowance payments are no longer part of the decedent's estate. To do so, you need to include both spouses' interests in the spousal property petition, not just the undivided 50% belonging to the decedent, because that removes all the assets from the estate, as I mentioned. Termination of the payment amount. Need is not an explicit factor. Similarly, I think conceptually to the fact that you don't need to worry about the decedent's intent when we're talking about allowance. The nature and extent of the recipients of the property is relevant. And one note here procedurally, if the decedent was obligated to pay child support, disclose that in the petition because the court will take that amount into account when it's deciding the allowance award. You don't want to double dip or be forced to double pay, depending on your who you're representing. And yeah, words to the wise. The procedure, you need to petition generally. The court will order allowance for mandatory parties and may order it paid to those non-mandatory parties. So the court will order the first payment. That's how you know you have to start paying or you are entitled to receive payment. As well as, so you need to repetition for this, the first payment for a period commencing more than 12 months after the date of death. And if you want to increase the amount of the allowance payment. Now, depending on your perspective, and by that I mean who you're representing, you'll want to make sure that you are 15 minutes, well, you are keeping in mind the size of the estate and how much are you going to be eating up. So I guess we are still on number 2 of 6. Let's let's go forward. Unmarried couples and stepchildren. This is really a practical consideration, I think, more than a legal one. If you are in the planning phase, there are some clear ways to handle unmarried couples and stepchildren. If you're already in the administration phase, you're going to look at 2 things. Is it easy case or is it a non-easy case? If there's beneficiary designations designating stepchildren or unmarried couples, the other member of the couple, then the assets pass to those people. If the assets are jointly held, then we're talking again about joint tenancy. Even if the couple is unmarried, the surviving tenant will take the decedent's interest. Operation of law, not as easy as intestate succession. All of those rules are weird and have a lot of fractions in them, 1/3 to somebody, 1/3 to somebody else. I would urge you to take a look at them if you are dealing with this situation. But like I said, it's really more about the practical aspect than it is about figuring out what the law says. Will contest and trust and estate disputes. This has some overlap with the spousal claims section. So who are the parties? Any interested person typically can petition the court to contest a will or trust. Defined, heir, devisee, child, spouse, creditor, anyone with a property right or claim against the estate that might be affected, anyone that's good, not anyone, but like pretty close. Generally, the attorney to the estate plan that is being challenged may not represent a party because there's a conflict, and he or she may be called as a witness. You have to bring the contest within 120 days of filing the petition for probate. Practical considerations. If you are filing a contest and the client, your client who is the filer, is not already alienated from their family, this may do that for There is a lot of fact finding required. So hourly billing can run up a client's tab quickly. Fees are paid by the estate. So if the contestant ends up paying most of the share, she or he wins via the contest to you for your attorney fees, then you don't really win. So these are good things to discuss with a client before you get into it. 3 methods, those are discussed in the written materials. Take a look at them. Statutory grounds. Here's your issue. Lack of due execution, right? We're talking about will formalities. Lack of testamentary intent or capacity. That's a very common one. Forgery, undue influence, mistake, or revocation. So those I think are fairly self-explanatory. The proponent of the will has the burden of proof to show the will was duly executed. The contestant has the burden of proof to show everything else. So this is a little bit unusual. If you're defending the will, you just have to show that everything was done properly. And then basically it's a threshold issue, then the contest can start. That's not necessarily an automatic loss if you don't show that, because there are all kinds of other ways that a will could be admitted. But something to keep. Settlement agreements. When you settle, if you settle, as 90 whatever percent of cases do now, you should consider having the settlement agreement confirmed by the court. Why? Because the agreement then becomes a court order and it's enforceable as the third parties. That can be helpful if we're talking about anything having to do with creditors. It's a relatively simple procedure to do so. And so I would urge you to do that. Consider the need for guardian ad litem to approve on minors' behalfs. Guardian ad litem is appointed to represent the interests of a minor beneficiary or other interested person who, of course, doesn't have legal capacity to consent or challenge something on her or his own. That's a good, so in many counties in California, it's now required that you appoint a California licensed attorney to be your guardian ad litem. So send your friends some business. Business interests, how do they pass in an administration? The first question to ask is, who is your client? Is it the personal representative? Are you representing the business itself? Are you representing a beneficiary? You need to make sure that if it's more than one of those parties, that you obtain an informed written consent to any conflicts. So that is easily done by including a conflict waiver and a fee agreement. If your fee agreement does not have an easily plug-inable conflict waiver section, you should add one. If more, make clear the information. So anytime you're sharing information, and this I hope is clear to you from your everyday practice, with more than one party or someone you represent and someone you do not, your client is effectively waiving the privilege of confidentiality, attorney-client privilege. So you should be aware of that every time. Okay. What are the personal representative's duties? So if your client is a personal representative, you need to tell your client that she has a primary duty of reasonable care to preserve the value of the estate assets. And this is especially relevant in business interests because you are charting revenue and expenses on an ongoing basis. So if you are worried about preserving assets, then you need to make sure that the business is doing whatever it was doing prior to the student's death. Because if it's not, you're no longer making money, assuming the business paid money. It doesn't always, as we know. So there are some license-related issues, operational issues, and employees and customers, right? So it needs to be continue doing what it was doing prior. Retaining or disposing. So when you get to the point where it's time to begin distributing assets, do you want to liquidate the business's assets do you want to distribute interests in kind, meaning membership interests of an LLC, shares of a corporation, et cetera, et cetera. The easy, not so easy cases, easy, the will or a business agreement pertaining to the business. So that would be a operating agreement, shareholders agreement, the bylaws, a buy-sell, any number of other documents. A lot of stuff that you'll find out when you're collecting information, as I advised you to do earlier. That's key in every case. Not so easy, no dispositive document exists. So you don't know where the interest is supposed to go. You don't know if the estate is supposed to retain the interest or not. Or, whether it's an interest in an entire business or a piece of a business. Those things all typically are laid out in contracts that have to do with the business. So look there first. If there's nothing, continue looking elsewhere. Considerations if there is no document. Is your client, the personal representative, willing and qualified to continue operating the business? Oftentimes, people think they are, but aren't. Or someone will say, I've never dealt with anything like this. I really don't want to do it at all. But maybe you have beneficiaries who say, wait a minute, that was mom's baby, and we have to continue the business because XYZ, blah, blah, blah. She would have wanted it. I don't mean to be dismissive about that. That's a serious consideration and one that you should be aware of from a practical standpoint. I only say blah, blah, blah because, I'm not going to give you all the circumstances. Your option, if the personal representative is not equipped to continue running the business, appoint a professional fiduciary. You should, speaking of lists of people, also have a list of professional fiduciaries with whom you have a relationship and you trust. That's always a good idea. You'll need them in many cases, especially this kind of stuff where you're dealing with assets that are a little bit more complex and your client is not so much involved. You need someone who is capable of handling that on their behalf. So here's the information that you want to collect. Those agreements I was talking about, as well as articles, partnership agreements. Do you have access to stock certificates and the ledger? If you are talking about reissuing stock, so that's a distribution in kind to a beneficiary, then you will need to go through the procedure of canceling the certificate that originally issued that stock, reissuing that stock via a new certificate, and you'll need a signature on behalf of the business to do so, typically the president and the secretary. Just one case that, for whatever reason, seems to come up a lot. Meeting minutes can be helpful in that regard as well, just to give you some insight into the inner workings of business. Again, talk to the beneficiaries if they're, or their counsel, if they're represented, and decide with your client, who I'm assuming is a personal representative, whether it's feasible to continue the business. Is there an assignment? So many times a person will set up a business and then set up an estate plan, and they can assign, especially to a trust, their interest in that business or their shares or their partnership interest, whatever the interest is. So that's something to be aware of, because that will supplant the other succession of the business, because assignment to a trust will allow the interest to pass according to the trust provisions. That's the point of assignment. Buy-sell agreements or analogous provisions. So many times you'll have buy-sell provisions in an operating agreement for an LLC. So keep a close eye on those. Right of first refusal, valuation method, those are generally included in buy-sell agreements. So what if the shareholder who was going to buy out the decedent's interest can no longer do so, whether insolvency or due to some other reason? Read the contract carefully on all cases. It gives you a lot of the answers that you will be looking for when you're dealing with business interests. If receipts, the successors and interest are included in the contract, oftentimes contracts have provisions that say, this is binding on my successors, heirs, devisees, assigns, blah, blah, blah. If that clause is there, then you can proceed accordingly. So that can simplify things for you a little bit. So other duties of personal rep, insurance coverage, you need to continue professional licenses. That's a little bit deeper into the weeds. When you dissolve, if you want to liquidate the business, you'll have to file BOE 100B and a certificate of dissolution. You will liquidate the business assets. In some cases, that may be physical assets, tractors and warehouses. In other cases, it may be electronic or IP or whatever. And if you need to associate with co-counsel to figure out what the liquidation procedure or to find a broker or a buyer, then I encourage you to do that as well. Pay the business debts and distribute the remaining assets, however it says in the agreement for that business, to the surviving partners or members or shareholders or whoever it is. Okay, I have 1 more minute. I guess I should use it to say, as I predicted, I didn't get through everything. That's to be expected. There's just so much to cover. Please take a look through the remaining slides and through the written materials, which are extensive. And if you have questions on anything I mentioned in either, feel free to get in touch with me via email, and if necessary, we can set up a phone call. But I thank you so much for your attention. I hope that you learned something or it set off a little review light bulb in your brain, and I appreciate your time. Have a great day.
We'll now continue our program with our next speaker. We have Dan Lively, and I will pass it over to Dan.
All right, thank you, Shanae. I appreciate it. As you can see, especially from the last presentation, there's just a lot of information that you need to know regarding estate administration. And the good news is that once you know the vast quantity of information, it typically doesn't change that much over the years. There's some things, but you can learn those fairly quickly once you have the substance of what's going on. This is not necessarily true in the estate tax area, which is what we're going to go over next. It's interesting that Congress likes to mess around with this area. It has a lot of political implications and not necessarily a lot of fundraising implications, because the estate tax only represents 0.6% of the total revenue that's raised from taxation. And compare that to individual taxes, which raises about 45% of our revenue. It's a minor area, but as you'll see in the whole taxation area, at least over the years, it's been more designed to influence behavior rather than to raise money. And that's even true on the individual tax side. And that may be why when we always hear a lot about a flat tax, that we don't actually ever get one. And the code seems to get just more and more complex, even with simplification tax statutes that are issued. And the whole reason originally for the estate tax was to prevent dynasty building, so that you wouldn't have certain individuals that could keep passing their wealth along and not have that taxed in some way to redistribute that money. And you can see, especially in today's environment where you have mega billionaires, that this could be a problem over just 1 or 2 generations. So that is the background. Let's start to get into estate administration issues. This is a little bit about me. I won't get too much into this, but I am a board certified tax specialist with the California State Bar. I also have an LLM in taxation, and I've practiced in the tax area now for probably about 35 years. And it has always had this changing aspect to it that we have to keep track of. And you'll want to know that in your own practices, because even though you may not specialize in taxation and you have estate planning as your practice area, your clients are going to ask you a lot about the tax area, because a lot of this tends to be tax driven in terms of the way we structure things and what happens at the end, which is the distribution of money. And all your clients are going to be very concerned about how much money they're getting, not gross, but net of tax. And is this tax? Is that not tax? What do I have to do here? How can I save tax? So you want to have a good working vocabulary, a good working knowledge of the tax areas so that you can answer those questions. You won't be expected to know all the answers, and you should probably work with tax professionals as an estate administrator that take and carry on the heavy lifting in that area. But who do you use? Well, typically, you'll try and use the accountant or the attorney that was working with the estate prior to the decedent's death. They're going to be the individual or firm that has the most knowledge about the client, and probably even done some planning along the way and know why certain things are structured the way they are. So even if you don't hire them ultimately as your tax professional in the administration, you're still going to want to make contact with them so that you can gain that knowledge. And you may have somebody also that you work with regularly that you're comfortable with that can help you through that process. And it's important to get that going early on in the estate, because there are elections and things that are time sensitive in the tax area that need to be done that you could lose out on if you don't do it right away after the decedent's death.
They're what? Like suicide. It's just
Okay, let's start off with some fairly, I want to call it easy material, but things you may see. These are forms in the tax area that you're probably going to see a lot of if you do it the state administration. So we might as well figure out and know what they're used for and why they're out there. You'll hear about the Form 1041. That's the U.S. income tax return for estates and trusts. And we use this in certain circumstances, like almost always when we're doing an administration, we'll set up what's called an administrative trust. The administrative trust is sort of an interim trust that we use to collect all the funds and collect all the expenses in one place, so that prior to doing distributions or doing sub-trusts, that we can keep managing and moving forward with the estate administration. And this is usually set up right away. And one of the first things that you do in establishing this is to get a tax ID number for the estate. And those are fairly easy to get these days. It used to take a lot more effort, but these days you can go to www.irs.gov, which is an excellent source for forms and other things by the IRS. They have a fairly decent website that they put out there, but you can go in and you can actually get the tax ID number online immediately. It takes probably about 10 minutes or less once you have experience with it to fill out the form. And then you get the tax ID number and the letter back from the IRS with the tax ID number on it online. You can print it out right away. You want to always make sure you hold on to those forms. And the reason I say that is because the IRS only issues it once. If you ever lose the form and someone needs to see that for some reason, like a bank, they sometimes want to see the original form, you have to go to the IRS and ask for a facsimile of it, which looks different. Sometimes the banks aren't used to seeing them, and it takes a little longer to get. So I always say, give one of those to your clients so they have it, keep one in your files, and keep track of them and know the number and write it down somewhere in the file as well. Important thing to know. The other reason that we may need a Form 1041 is because of trust. There may be irrevocable trusts that are established inside this estate plan. trusts become irrevocable at death, and there are also other trusts that may have been prepared. There may be an irrevocable life insurance trust, for example, that needs an annual tax return. There may be irrevocable children's trust. There may be different kinds of irrevocable trust. They may be more complicated. You may have GRATs or CRUTs, other things you may have learned about today that also need these tax returns done. So the 1041, if you have a working knowledge of what it's for, you probably aren't, unless you're well versed in taxation, going to actually fill one of these out yourself. It tends to be a fairly complicated area of taxation that, again, you probably want a working knowledge of, unless you want to go more in depth into this area. There's really no need to if you have your professional who's actually going to prepare it, but then you can look at it and review it once it's prepared and make sure that it makes sense to you. And these returns can be due for many years after the decedent's death, because these irrevocable trusts can go on for years. An administrative trust can go on for several years before it's actually closed out during the administration. So if that's the case, you will also need to file a 541, which is the state of California equivalent of the 1041. And it's pretty much done the same. So if you know about a 1041, you know about a 541, but have the knowledge have to be done. Now, let's take a look at Form 706. This is the United States Estate and Generation Skipping Transfer Tax return. If the 1041 is difficult, this one's on steroids. And the reason being, you have to have a lot of background knowledge to be able to complete one of these. You need to know the estate tax laws. You need to know tax laws. You need to know how the structure of your client works. And this return is sort of the granddaddy of tax returns for estate planning. The good news is that they aren't done that often anymore unless you have a sizable estate, because it used to be maybe 20 years ago that the estate exclusion was only $640,000. So if anyone even owned a piece of real estate, they were pretty much falling into the category of having to prepare one of these returns. Well, today, as we can see in 23, it's $12.92 million for the estate exclusion. And if you're married, you can double that up to $25.84 million. So you have to have an estate that's over $25.84 million before you even think about preparing one of these forms, except in some special circumstances that we're going to discuss. Now, these returns calculate what's called the inheritance tax. And this is an asset-based return. It's not based on how much income the estate's making. You're going to pick that up on the one we talked about just a few minutes ago, the 1041. This one is a tax on the assets of the estate. So we're going to figure out when we're doing this what the gross estate is. We're also going to know when the estate tax returns due. We're going to get into due dates later. And we need to know what these exclusions are and what happens when you're married and you're able to double them up. This return is due within 9 months of date of death, which is fairly quick. So California, fortunately, though, does not have this return. They don't have an estate or death tax in California. So we only have to worry about this return on the federal level if it needs to be done. One of the reasons that you will complete a 706, even though you're under the exclusion amount, is because of the deceased spouse's unused election. So your spouse also, or the spouse of the decedent, I should say, also has a $12.92 million exclusion. And you may not use all that up after they pass away. So the surviving spouse can carry that forward, that unused portion of the unused election, but it can't be carried forward unless the estate files this Form 706 and makes an election to carry it forward, the unused election. I'm going to talk a little bit later towards the end of the program about how we might miss that. And there's been a gift given to us by the IRS that allows us to make a late election if that's missed. And part of the reasoning for that is this was happening quite a bit because an estate administration professional would look at it and say, wait, we're under the exclusion amount, so we don't need to file a Form 706, forgetting that the unused election requires the 706 to be prepared. As a result of that, they were missing it, and there was no way to get it back. And the IRS gave us a way to do that that extends the time period out. And I will again show you how that's done and what you need to do to make that election late. That means after the 9-month filing date. So let's look at some different considerations. We need to update this slide a little bit. We talked about earlier what the exclusion is, but that's another area where this has been constantly changing. So the estate and lifetime exclusion now is this, the doubling up. The middle one is 25.84 million, and individually it's 12.92 million now. So realize that that's changing every year. And you also need to realize one thing that's coming up is in 2026, this whole provision for the lifetime exclusion sunsets back to where we were before this tax act, which was basically $5 million. However, that's also adjusted for inflation. So by rough calculations, that would be about $6.4 million today. So on January 1st, 2026, without an act of Congress, which looks like that may not happen, there's no talk of it currently, that looks substantial and will happen. So if that's the case, this $12.6 million exclusion that we had in 22, which is now this 12.92 and $23 million, will sunset back to $6.4 million. That's a substantial difference and will cause a lot of states that were previously not taxable to now become taxable, which will require the estate to prepare a 706 return and also most likely pay taxes that they would not have paid prior to the sunsetting of the provision. The max rate's 40% for the lifetime, for the amount you exceed the lifetime exclusion by. And again, the exclusion is now portable, which isn't the way it used to be. We used to have to do it differently with AB trust that now doesn't need to be done anymore. So I'm not going to get into what used to happen and waste our time on that. So let's look a little more deeply at the estate tax. And it really is what I mentioned before. It's a right to transfer property at death. And if you exceed the exclusions that are provided by the government and by Congress, it could cause estate tax. One of the things I always like to say is the good thing about estate tax is it can be 100% planned away with proper estate planning. So there's really no need if an estate doesn't want to pay tax to pay it, but there are things you have to do. And that's part of the program today. But usually when you get into estate administration, those things are already set. And now we're just administering through it. It's not setting those things up after the death of the decedent. So one of the things that has to happen when somebody dies is that there has to be an accounting of everything they own or have certain interests in at the date of their death. The fair market value of these items is used and not necessarily what they originally paid for the items. And then we can take this valuation at two different times. The first time that we can do it is at the date of death. However, we can make an election for tax purposes to choose what we call an alternate valuation date. And that's a date that's 6 months after the decedent's date of death. And this is what we call an all or nothing election. What does that mean? That means that you can't take some of the assets of the estate where it'd be favorable to have a different valuation date 6 months later, and then have others at the date of death. It means that you either take all the assets at the 6 month alternate valuation date, or you take all the assets at the date of death. There's no in between. And you have to look at it and see what makes the most sense, because there are some negatives to both ways. And the best thing I can tell you is that you need to run the numbers. You need to put the estate assets on a spreadsheet, put all the debts on a spreadsheet, determine what the net assets are, determine what would happen if you picked the alternate valuation date as far as a taxation issue, determine what would happen if you pick the date of death, and then see which one's better. But there are also other considerations, because as we'll talk about in this program, when you pick the alternate valuation date, you also affect the tax basis of the assets, because the basis of the assets that are inherited step up to fair market value at date of death. The question is, which value are you going to use? You can use the date of death value, or you can use the alternate valuation date. If the alternate valuation date is lower, and that's the only way you can make an election, by the way, to pick the alternate valuation date, is that it actually benefits the estate. So when you take that alternate valuation date, the actual tax basis becomes that fair market value, which would then, just by operation, be lower than the valuation at the date of death. So your clients that are inheriting the property get it at a lower tax basis, which could cause them greater capital gains if and when they sell those assets. So there are going to be people that may have different goals in mind when you're doing the estate administration. You may have some people who really want to use the alternate valuation date, and you may have some that are negatively affected by that based on the assets they inherit that don't. So there has to be a consensus reached as to which method's going to be used. So again, once the gross estate is accounted for and we have all the assets, then we're going to take deductions, just like we would on an individual tax return. We're going to take deductions to arrive at what we call the taxable estate. These deductions may include mortgages and debts of the estate, administration expenses of the estate, property that passes to surviving spouses and qualified charities. These are all things that come off to get us that taxable estate. And then once we get to that number, we apply the tax rate to it, and then we apply any exclusion that we may have left. And we'll have to remember that this is a gift and estate exclusion. So if your client has given gifts during their lifetime, it's possible they've used a substantial amount of their lifetime exclusion, or maybe all of it, so that you don't have any more available at the time of the 706 return. So you have to look at that, and that's a good thing to have your tax professional involved in, to make sure that you've accounted for all the gifts prior, and that you also are using the right current lifetime exclusion that's available to the decedent. And then once you do that, you can see if any estate taxes due, and if there's any kind of planning post-mortem that you can do to lower that rate, and how that's going to affect the different errors that are involved in the estate. And then you'll also want to look at the estate planning documents to see what the guidance is that's provided in that document for elections that are to be made at the time of the tax return. Again, just to recap a little bit, we're valuing the estate at either the date of death value or alternate valuation date. There may be some positives and negatives to either one. You want to look at that, run the numbers, and see what works best, and then see if there are any consequences to the other heirs in the estate once some elections are made, and how that may affect them and how you're going to handle that. When someone dies, as we talked about, the asset steps up to fair market value at the date of death. And this is different from when an asset's gifted to someone. If someone receives a gift prior to the death of the decedent, they're going to get a carryover basis, which means their basis is equal to the basis that was in the hands of the decedent when they had the property. Why is that important? Because there could be a situation where somebody benefits greatly from a stepped up in basis number, as opposed to picking that ultimate valuation date and having a lower basis. And they may get the assets that are appreciated. That would be a good thing for them. But other people who don't have that going for them may not want the ultimate valuation date. So the step up is a big deal. And you want to, again, run the numbers, calculate things, and see how that works out. When somebody comes to you, like for instance, we'll have people that come near death and they want to say, hey, do I want to make some gifts now instead of waiting for people to inherit? That's where this discussion is going to come in. You need to talk to them about the valuations and the step up in basis issues. And the consideration becomes, well, if you gift that property to them now, which has a very low basis, for example, they're gonna, if they sell it tomorrow, they're gonna be paying taxes on all that built-in capital gain that you're giving to them as a gift before you die. Whereas if you wait until you're in a situation after death, they're going to get that step up in basis, and the same asset that they would sell the next day would have no capital gain. And then you have to bring into the calculus for this how that affects the actual estate tax calculation. Is this person in a taxable estate, or are they not in a taxable estate? If they're not in a taxable estate, usually you want to get the highest basis you can. If they're in a taxable estate, then this basis issue crops up, and you'll want to make that consideration. Okay, let's spend a little bit more time on the step up to fair market value and alternate valuation date. Again, super important issues, and you need to know the difference between what happens prior to death in stepped up basis and what happens after death. And then you need to know how that affects the other heirs and how that affects the estate if you're in this taxable estate situation. So the unintended consequence of choosing the alternate valuation date is that it can cause a reduction in the step up basis, since a lower valuation will be selected. And this could cause higher capital gains tax for the beneficiaries. So as long as you have that cataloged away and you know that issue, you should do quite well with questions from your clients in this area. So let's look at this. I mean, it's something that you may not think about when you have a estate situation, but an individual tax return will be due. The decedent has to file an individual tax return from January until January 1st, until the date they die. And all the income that they've acquired during that period gets included in that return, and it's filed. After the date of death, it goes to that 1041 return where we pick up all the income from that point forward, and then the beneficiaries of the estate or the estate itself will pay the taxes on that. So again, you need to know the income tax and basis adjustments for the decedent's assets, real property considerations, and the filing, the final individual income tax return of the decedent, and what those cutoff issues are. Again, this is something that the tax professional you're working with can be of great assistance on, especially now. You should have a working knowledge again in this, knowing these basis issues, real property considerations, what's deductible, what's not, that kind of thing, how rental properties are handled, other investment properties are handled, second residences, what are the tax basis in those assets so you can calculate gains and step ups. And then also having a working knowledge of Prop 13 and Prop 19, which are the property tax statutes, and what happens on transfers, which is substantially changed recently. So again, in the individual side, the same issue crops up with the valuation at the date of death or the alternate valuation date. So you'll have to work with that in terms of how that tax return gets prepared. And then there are trustees' actions, who the person who's administering the trust that will have consequences on taxation issues. One of the things that you have to have a working knowledge of, and again, these 1041 returns can get complicated, but that doesn't mean you can't have a working knowledge of how this all goes together. One of the issues that always is concern is distributed and undistributed income. When you have an estate, if you distribute the income that's generated during the accounting period, which is the tax return accounting period, so it's annual, during that annual period, if you distribute the income that trust makes to the beneficiaries, then the beneficiaries pay the tax. If you don't distribute the income and you hold on to it, then the trust pays the tax on it. And why is that important? Because when you look at a trust, the trust has a much faster graduated tax rate. It gets up to the maximum tax rate very quickly. And you will pay, or the estate will pay, more taxes if the income is not distributed than the heirs would have paid if they paid the income tax themselves based on what was distributed. And you can see where this would cause a lot of problems and issues with the heirs if that is the case. They're going to want to know why that income wasn't distributed and why they're paying more income tax. There are reasons why that could happen. There could be working capital that that's necessary for a business. It could be setting aside funds for needed repairs on rental properties. There could be a number of reasons, but you want to have answers if you're asked that why it wasn't distributed, because normally we want to try and distribute as much of the income as we can to keep from creating this higher tax that's paid at trust level. And trusts pay income taxes based on what we call distributable net income. A trust is a lot like partnership tax return, if you're familiar with those at all, where a K-1 is issued. So each beneficiary is going to receive a K-1 from the Form 1041, which is their distributable portion of income and expenses that the estate had. And the deductions and the way income's picked up in trust is a lot like individual returns. So it's this hybrid where you have a lot of characteristics of an individual return and you have the characteristics of a partnership return, and the trust only pays tax on what we call distributable net income. So that's the income that the trust picks up, less all the deductions that it has, not necessarily what it actually distributed. It's like a lot like a partnership, where a partnership may go out and take out a loan, and then they distribute the proceeds from the loan. Well, that's not taxable income. That wasn't income that was generated by the partnership, just like it wouldn't be income that's generated by the trust. And when it's distributed, you don't pay tax on that unless you get, for instance, distributions in excess of basis, or you have a distribution whereby maybe you did take out a loan and you didn't pay the loan back, and then that creates income at that point. But as long as we have that balance with, we have a loan and we have it being paid back, then there's no income from taking out a loan. We went through this, so we'll move on. Okay, so this is another interesting area that you can get involved in with regard to estates. And sometimes this is all that practitioners do with regards to estates. In recent years, our firm has evolved into where this is a primary area for us in all areas of taxation, resolving disputes with taxing authorities. And this can be a very interesting and very lucrative practice area for you if this is something that you're interested in. And always, when you're going to represent a client before the IRS, the Franchise Tax Board, the EDB, outside state agencies, one of the first things you'll want to get is a power of attorney. And each of these agencies have their own form that you use. And again, you can get that on www.irs.gov. They're there, and you can pick up those forms, and you can actually type and fill them out online and print them out, and then have your client sign them. So first, you get a power of attorney from the executor. The decedent's gone, executor represents the estate, and that allows you to have the power to discuss tax issues with the tax authority on behalf of the estate or your client. You'll need to know the issues in dispute. One of the things about being a specialist in resolving tax issues is that you're going to get tax issues from all over the place. So it usually requires you to do a little bit of research. You're never going to know every single issue at the top of your head, but once you're good at tax research and you're good at assessing the overall problem, that's not a big deal. You'll go and do your research. You'll document your position in a memorandum, put it in your file, and now at that point you're ready to discuss the issue with the tax authority and see what their position is and how you might be able to resolve that or argue your position to get the taxing authority to change their position. So once you go through that process, it can take time. I mean, some of these tax audits can take years. I mean, I'm talking like 2-3 years sometimes. So we'll some simpler issues, maybe less. But currently, the IRS is very backed up with audits, and they're shorthanded, and they don't have as many experienced staff as they used to. One of the fortunate things about a 706 return is they have a high potential for being audited. I would say like over 50%, and they're always audited by the state attorneys at the IRS who are very experienced and are good to work with in that respect. The 1041 returns, you'll usually get more experienced auditors as well. 1040 returns, it's a grab bag. You know, you could get someone very experienced or someone very new. One of the issues we see a lot of in recent years is switching agents throughout the process because a lot of the agents go on special assignment, and when they do, the case typically gets reassigned to another agent, and you have to pick up and start over again with them. Sometimes that gives you an advantage because you're very familiar with the case and they aren't, but it's also very frustrating at the same time. But just be aware that that's just the nature of the beast in this practice area. So let's look at some frequently asked questions that we get regarding fiduciary returns, the Form 1041 again. And a fiduciary return is typically required when the estate or the irrevocable trust you're working with has 600 or more in annual gross income. And that's $600. It's a very low threshold. Be aware that the decedent and the estate are separate taxable entities, and that 1041 return, again, you're going to have a separate tax ID number for it, and you will need to apply for that. Again, the IRS website's a good place to go. There are other programs that you can get that also help you prepare those forms, but something cheap and easy is the IRS website. And the forms are, again, always up to date there, where some other programs I found don't keep them up to date as much. Again, the graduated tax rate for a fiduciary return is much steeper than that of an individual return. That's why we want to try and avoid being taxed at the trust level and prefer to push that through to the individual level. And again, not all estates have to file a 1041. If you have a very simple estate, it's not getting the $600 or more in income, you may not have to file a 1041 at all. And again, just quickly, don't want to spend a lot of time on this because we already talked about it, but the estate tax returns are very similar in a hybrid way to individual tax returns and to partnership returns. And this is probably a return that I would say you want to have a professional working with you on because they can get fairly complicated. A generation skipping transfer tax. This is what I call a hole plugging statute by the Congress, because if you transfer assets to a generation, like for instance, parents don't transfer to their kids, but they transfer to their grandchildren, that would be a classic skipping of generations. And when that happens, the government is going to, on average, get their money a lot further out because the grandchildren are younger and they're not going to pass until maybe 20, 30 years later than the person who would have got it if it were their parents. So that being the case, this generation skipping transfer tax was introduced to capture that tax that the government would have otherwise received. And it's the same as the estate tax rate, 40%, and it has the same exclusion, $12.92 million before it has to be paid. So it's not as big a consideration in some areas as it was before because the exclusion's so big. But remember, this is also sunsetting in January 26. So let's quickly go through the deadlines for the tax returns. 1040s, just like we're all used to, April 15th. Sometimes that changes depending on weekends and other holidays in Washington, D.C. that can come up. If someone dies early in the year, you have to wait until the end of the year when the tax forms are actually out, which usually is in late January, to prepare that return. So if someone died early in the year, you may have to wait an entire year before you can actually do their 1040. 1041s, same due date, 706, like we talked about, 9 months. And the state deadlines are the same as the federal no state requirement, again, for the 706 return. Returns are extendable. There's a 6-month automatic extension that you have to file for. Forms available on the IRS website. 1041s, same thing, they're extendable. forms are on the IRS website. And then 706 has to be filed within 9 months. There is no same as federal, no equivalent for Form 706. And remember, when you file a tax return extension, it's an extension of time to file. It is not an extension of time to pay. A lot of people make that mistake. So when you file the extension for a return, you have to estimate what the tax amount is that's going to be due when the return's actually filed and pay that at the time the extension is filed. Otherwise, there could be substantial penalties. Now, last thing I wanted to talk about, and we have about a minute, is this extension for portability. Portability is extendable, but if you miss the date, an executor can elect to transfer this deceased spouse's unused election to the surviving spouse on Form 706. Executors that didn't file on time within that 9 months can now make an election, and you write at the top of the form that the extension is under Rev Proc 217-34, 217-26, IRB 1282. That's the language you need to put at the top to show you're making this election under this revenue procedure that the IRS introduced to allow for late elections. And that will cover you on a late election. If an executor chooses to elect this, make sure it's put at the top of the form. So that's really all the time that we have. Sales of real property, go through this on your own. You can always send me questions if you have it, but it's a lot of the same things: the alternate valuation debt issue, the step up in basis issue, and the property tax issues under Prop 13 and 19. That will wrap up this portion of the program on taxation for today. Thank you very much, and I appreciate it.
We will continue our program. We're back with Kendall, and I'll turn it over to Kendall.
Thank you, Shanae. All right, good morning, or nope, good afternoon, everyone. I'm glad to be back. I know it's a long day, and you probably feel like you're drinking from the proverbial fire hose. We're almost done, only one section after me, and then you'll have completed this. And congratulations, because you are now finished with the probate. You've successfully gotten your client appointed in the right fiduciary capacity. You have gathered your assets, filed your inventory and appraisal. You've dealt with creditor claims, hopefully successfully fielded any claims that have come in, any litigation that might have arisen. You've dealt with tax issues, fended off questions from beneficiaries, and now you can file your petition to close and you get to get paid and beneficiaries get their money. So this is a moment to cherish. So let's get into what's involved in getting the estate wrapped up and distributed. I'm going to preface my remarks by, again, kind of underscoring what I said in my comments this morning, that probate really appeals to someone that appreciates a sense of order and has appreciation for detail, because those things are ever present in an accounting. A lot of, there's sort of this, it's kind of anti-math trope that goes around in the legal community. Well, I became a lawyer because I'm not any good at math. And so people kind of cringe when they start talking about accountings and numbers and fiduciary accountings and so forth. You don't have to be good at math to do a good accounting. You do have to be detail oriented, you have to be diligent, and you have to have an appreciation for what an accounting can do for you, both if you're representing the fiduciary who's rendering the accounting, or you're representing a beneficiary who's receiving it. And we'll dive into that and I'll explain why I say that as we get along. So the first question you should ask yourself is, do you need to do an accounting? And as most things in probate go, the answer is yes, but, it's worded as a mandate. And so the code requires the representative to file an accounting in particular circumstances, unless there's generally been a waiver. There is an exception if the representative has reserved appropriate funds, suitable funds for distribution. But that really only pertains to small gifts that are flat amounts of money and that are easily satisfied anyway, and it doesn't pertain in most cases. So basically, yes, you have to do an accounting unless you can get a waiver, and you get a waiver from the people that are entitled to receive the accounting. Now, just because you might not be required to render an accounting doesn't mean there might not be a good idea there might not be good reason to do one anyway, even though it's not required. That comes up most commonly when you're filing a status report where you're not otherwise required to account, but it's good to do one anyway so that the beneficiaries know what's going on in the estate. Without rendering an accounting and presenting the beneficiaries with that information, there is no statute that runs against your client for times in which beneficiaries can file claims. So, in a state that might linger on for a while, and some of them do, there really is no good reason not to do an accounting on an interim basis. And indeed, if a lot of time has gone by when you haven't voluntarily done one, it's not out of the realm of possibility for an heir beneficiary to come and ask for one. So just because you don't have to doesn't mean you shouldn't. So if you want to get a waiver, which is a very common situation, the accounting, as much as I might enjoy them and get a real sense of satisfaction from them, they can be time consuming and it can cause delay depending on the records that you have and how long it takes your client to give you what you need to put the accounting together. So people will commonly be willing to waive receipt of an accounting. And as I said, the waiver can come from the person who got the standing to receive the accounting, who's entitled to receive it. So then you kind of have to ask yourself, okay, well, who are my beneficiaries? What do they look like? What are their categories? If they're individuals and they are competent adults, you invite them to sign a waiver they can sign. That's usually the case. Is your distributee or heir a minor? In that case, you may be able to get the waiver from the parent or guardian. And I use guardian in an informal sense. Depending on how the beneficiary is situated, there might be legal guardianship in place, in which case it would come from a court-appointed guardian. If you're dealing with perhaps an incapacitated distributee, somebody who's under conservatorship of the court, the waiver would be signed by the conservatee. And then you might have another entity who's a beneficiary. You might be probating a pour-over will. You might be dealing with a situation where one of your heirs or beneficiaries has failed to survive the probate. They have an estate of their own, so you'll be seeking a waiver from who's ever in charge of that entity. Now, the accounting itself, I could speak for 3 hours or more about how to prepare a good, solid, statutorily compliant accounting. We obviously don't have the luxury of that time. There are programs that are devoted entirely to preparation of a fiduciary accounting. There was several years ago a series of articles in the Trust and Estate newsletter, the Trust and Estate section of the bar, over the course of, I think, 3 months. They did a really good description of how to prepare an accounting. There's a lot to them. I am only going to be able to sort of hit the highlights and point out the most important things for you. And then we'll go over in your materials. I did provide you with sample petitions, one petition that's on waiver of account, one petition that is on an accounting. And so we'll go through those as well. Again, feel free to ask questions. I'm happy to answer them. If some of this stuff gets a little bit too dense, we can talk off program later about it as well. This quote I love from a appellate court case that dealt with an accounting. One of the counsels, a close friend and colleague of mine, Mark Lester. In probate court, nothing speaks more eloquently or provides more insight into factual and legal issues than an accounting. And far be it from me to disagree with the appellate court. I might modify that a bit to just say you only get the insight and the eloquence that it's designed to provide if your accounting is complete and statutorily compliant. The accounting is rich with information about everything that has occurred in your estate. And if you know how to prepare a good accounting, you'll know how to pick apart a bad one as well. And the tools that you learn and use to put together an accounting in the probate of a decedent's estate apply across the board in all fiduciary matters. So it's the same statutory rules that apply to accounting in a guardianship, conservatorship, or a court supervised trust. There, with an asterisk, there are a little bit of differences there when you get into trust accounting, but the basics are all the same. It is wholly a creature of statute, and that's, a little gremlin getting angry and a little happy gremlin, because you take the good with the bad. There is something in the probate code to address every element of an accounting, and that's good. And the bad news is there's something in the probate code that addresses every single element of the accounting. You've got to comply with statute. And if you present an accounting fiduciary account to the court that is out of compliance, it will not be approved. And depending on the county and the probate attorney or the reviewing panel, whatever is used in different countings, it can be really frustrating when you get sent back to fix things that seem so inane. But the devil is always in the details. So you've got to know the statutes, you've got to know what's included, and so how you can comply with everything. The goal is to get your probate done with, over and out as soon as possible. And it's frustrating, certainly for beneficiaries. It's frustrating for me when something gets delayed because of, an error that we have made, particularly in an accounting. So the accounting is, I describe it to my clients as a sort of supercharged cash flow statement. You've got a schedule of what's on hand at the beginning, which you're going to take from your inventory and appraisal. All of your supplemental, partial, whatever you've got a complete INA there of what was on hand at the date of decedent's death. That's the schedule, your schedule of opening assets for your estate. On the plus side, you've got stuff coming in. Receipts, which are income, not true income. We're talking fiduciary accounting income. We're not talking tax accounting income. So they're inflows, they're receipts, interest, dividends, rent, capital gains receipts, etc. Also on the plus side, you've got gains that you've realized from the sales of any kind of asset, gain on the sale of a house or security. And then any income from a trade or business, which is separately delineated in the statute, but it's on the plus side. On the minus side, the credit side, so those are your schedule of charges. On the credit side, it's any outflows, anything that has left your estate during the period of account. Disbursements for expenses that you paid of any sort, mortgage payments, insurance premiums, repairs, accounting fees, anyone you might have had to write a check to or dispersed. That's in your schedule of disbursement. Again, any loss associated with a business, losses on sales. If you've not realized the gain, you've realized some losses, that goes on your credit side. And then balancing out the credit side is what's on hand at the end. So you've got stuff at the beginning, stuff come in, stuff left. You've got property on hand there at the end. And those need to balance. The total of your charges have to total the balance of your credit. It's the very, very first thing the probate attorney is going to look at when they look at your accounting. It's the very, very first thing I look at when I'm reviewing an accounting that comes into my office, if I'm representing a beneficiary or an heir. And it's the first thing I look at when my staff has prepared an accounting. Are we at least in balance there? Now, as we said, the devil is always in the details. So you can't just say, I earned, we'll go back to this slide. I earned $10,000, 2022 interest, $10,000, 2022 dividend, $2,500. It's not that simple. We don't get off that easy. All of these things have to be detailed. And the code section is there. I encourage you, if you haven't done an accounting yet, look at the statute, what's required to be in each schedule. So, for example, on the receipts, you've got to say for each transaction, the date, the source, where it came from, what is it, and what was it for. So you'll see in the accounting, it'll say January 1, 2022, Bank of America, interest, $5. You have to do that for every single month. You have to do it for every single rent payment that was made or dividend earned or anything of that nature. If you're calculating gains or losses on sales, you've got to show what the appraised value of the asset was, what it sold for, and then you get your gain. Same thing on the credit side. You have to give the date, who your disbursement was made to, what it was for, and how much it was for. And as you can see, these things can be extraordinarily time-consuming and seemingly arcane. But if you don't have all that information, how do you know what's happened? You have no way of knowing what's happened, and you have no way of knowing that what has happened has been accurate. So you've got to be, really devoted to getting all the details correct. So that's the accounting. There are additional schedules that are outside of the schedules of that we just went over, that I misspoke, that are still part of the accounting, but they're not necessarily part of what's going to give you that balance between your charges and your credit. Those things are set out in Probate Code 1063. The first thing I've listed there is the fair market value at the end of the accounting. And if it's a subsequent accounting, you have to have a schedule of fair market value at the opening date of your accounting. Now that's important because as you're working your way through the account period and through subsequent periods, you're going to be continuing to report your assets that have not been sold at the initial opening value. what's called a carry value in the fiduciary accounting world. So if you have, for example, a decedent who died in 2010 and owned a piece of real property, and it's still on hand as we sit here 13 years later, and every annual accounting is going to report that house, it's going to report it at the appraised value at the date of the decedent's death, even though surely as we sit here today, the fair market value has changed. So the accounting is designed to report what occurred, but also to give the beneficiaries a really fair idea of what's still going on. And so you have to have a schedule of fair market value for each of the assets in the accounting. And some of those, like we talked about, money is money, that's not going to change. But the values of any of your attachment to assets are going to change. So you'll have to get a schedule of fair market value for those things. A schedule of changes in form of assets or investments. This is the content of this schedule is most typically comprised of assets that might still be on hand, but have had activity that has changed their form. The most common kind of thing I'm talking about is a security with a dividend reinvestment, and that has grown because dividends earned have been put back into the security, so back into a mutual fund. So remember, your carry value of that mutual fund is going to stay the same as it was at the beginning. You're going to show in your receipt all the dividends that have been earned on that. That's income, right? That's going to be on your schedule of receipts. But what you've done with those dividends is you've purchased more shares of that mutual fund. And so you're going to show those new acquisitions in your schedule of changes. And at the end of the accounting, you're going to show the new number of shares that are on hand for that investment. Those schedules can carry on for pages and pages and pages and pages. If you have a heavily managed brokerage account, and some of the mutual funds will pay out dividends monthly, some are quarterly, some are twice a year. You've got to show every single one of those. And I think that the sample accounting I gave you reflects that. Special reporting for specifically divided property and income interest. So if you have, say you have a will that you're probating where the testator left a specific piece of income producing property to somebody, the person entitled to that asset is of course entitled to the asset, but they're also entitled to all of the income that's been earned on that asset during the period of administration. You need to separately account for that so that your beneficiaries can see what's going on. Proposed distributions, if it's a report where you're asking for final distribution, you have to give a schedule of that. I will sometimes, if it's super easy, you've got a single heir or a couple of heirs that are taking equally, it's easy, half of everything to each of them. Lots of times they're not that simple, and so I will frequently do a separate schedule entirely on Excel that shows the value of the assets on hand, how it's going to be divided between everybody. We talked about early in the program today. You can get some really funky structures of intestate estate distribution structures, just because when you apply the laws of intestate succession, some of these things get really fractionalized, so it's helpful to do that. You do need to report in a schedule of liabilities, any liabilities that are on hand at the end of the account period, so that the court can see, have we provided appropriately for all those liabilities. Ideally, you won't have any other than what is owed to yourself, to your client. So, your schedule of liabilities might show up in an interim accounting. You really don't want any of it spend on your final distribution. foreign real property, foreign being not only out of the country, but if it's just located in another jurisdiction of the United States. Again, like we talked about this morning, it's not subject to administration in California, but the court needs to see that. So you'll want to do a separate schedule if you have an ancillary probate or anything like that in your estate. All right. Now, you've got your accounting, which is typically, but not always, but is most typically incorporated into a report on the administration of the estate. And your report is, where you kind of sort of tell the story of what's happened in your probate and give the court everything it needs to make a determination that you've done your job, your client's done his or her job, and the estate can be closed and distributed, and your client off the hook, basically. Now, it doesn't have to be incorporated into the report. You can just file your accounting and slap a cover sheet on it, and that technically fulfills the requirement of the statute, because there's a code section that says the filing of the account is deemed to include a petition requesting its approval. So you really, you just file your accounting, get it set for hearing, and if that's the only thing that you're asking for, it's all built in there. It's not common to do that. I've only done that a few times where my client has been on the receiving end of a petition to compel an accounting. Someone's come in because they've not done what they're supposed to do, and they've ended up on the wrong side of a petition like that, and you don't really know what else might be going on in the estate and what they might have done. So we'll make sure that the account is good and solid and have a lot of integrity. We'll deal with all the other stuff later. But in most cases and in most probates that we handle, it's part of a report to approve the whole, your client's entire period of administration. If you are filing the petition to include the account, you have to remember that there's a couple of other things to report on. So there is the bare bones. You can just file the accounting, may include additional petitions. However, in addition to the accounting, you have to alert the court to a couple of other things. And they're things that aren't easily intuited from the accounting itself. So if there's any kinds of transactions that are not readily understandable from the schedules or anything unusual in the account. Our local probate judge a couple of years ago gave us a really good continuing education program on accounting after he's been on the bench for 2 years. Things he saw repetitively that were problems. Things, people making mistakes, the same mistakes he was doing. So he put together a program for us. And his comment was, there's always something unusual. Don't ever file the accounting that says there are no unusual items to report in the account. So if there's anything that is outside of your plain vanilla receipt and disbursement, you're going to want to explain that. That would be something like a payment to something you wouldn't ordinarily expect to see in a decedent's estate. Why is the estate paying for lodging and travel? Why is there disbursement to Chuck E. Cheese? Those kinds of things. Explain that. If you have an estate, which happens with some frequency where the estate is not the owner of 100% of an asset, you might be in joint ownership, maybe with another estate or with another person, you're going to want to make sure you explain that and let the court know this is, hey, we're only doing this estate 1/2 interest. in these things. So anything that looks, that you would pick up and say, well, I wonder what that is. Those are your unusual items. Statement of compensation paid from the estate, which has been addressed today, it should be 0, but if the court has previously approved some statutory fees or extraordinary fees, or if you've been given authority to pay another attorney during the course of administration, if you've had to hire other counsel for whatever reason, you're going to want to make an affirmative remark about that in the narrative of your report. Disclosure of family or affiliate relationships. This can trip you up because it's not something that occurs to us to ask. It recently tripped me up. I have a client again who was on the receiving end of a petition to compel, who hadn't hired an attorney, handling his mom's trust. 3 siblings, my client and his brother and his sister. And fairly simple trust administration. Pretty much single asset was just a house that was sold. They got in a quarrel about my client's fees, which he had not paid himself any fees yet, but in ignorance of the rules that applied, he had represented that he was going to pay himself what would have been completely unreasonable fees. They objected to that. And they also objected to fees that he wanted to pay himself for services he provided to mom before she died. So those were the issues they were fighting about. He hadn't done an accounting at all, even though he had given them information and he'd given them statements. So when he came to me, we put together the accounting and I filed a response, and we represented the house is sold. I got a copy of the escrow statement. What my client failed to tell me is that he was the agent that sold the home, and of course had gotten a share of the broker commission. So when that came back in the response, that already gotten paid, I thought, oh my gosh, I don't. It's not top of my mind to ask every client, did you sell the house? But if those things come up, you've got to disclose it. And a statement, some of these things that the probate code makes you say you're doing anyway because it's the law and it's mandatory, but they want you to say so. So this is one of these things, is a statement that all cash has been invested in interest-bearing accounts, except for the amount of money that's reasonably necessary for administration. Your client has a duty to make the estate productive, right? So money is going to be earning income, interest, dividends, it's going to be invested, but you're allowed to keep a certain amount of money aside in a very low or non-interest-bearing account that you need to pay bills with, right? So, but they want you to pay so. I want to encourage you to ask any questions that might come up. I'm throwing a lot of information at you, so feel free at any point. All right, so continuing on with the report on administration. So up to this point, going back in my slides, we're talking, this is all in the petition to approve your accounting. If you are also now filing your report on administration, these are things that you need to be aware of that must be alleged. The probate court is the probate code is sort of a patchwork of things all over the place. And so I tried to put together for you some of the things that, hopefully all of the things that should be good, that should be contained in a good accounting and report on administration, even though it's, it's not neatly bundled in one place in the probate code. So if we're working now on our report on administration, we have to allege that notice has been given to creditors. We have a whole section on dealing with creditors, creditor claims. You'll make an allegation that notice has been given, how it's been given, And if you have any claims, how they've been dealt with. Did they result in litigation? Were they allowed as filed? Were they withdrawn? Whatever it might be, you have to detail each one if there have been claims. And you also have to allege what actions, if any, there surely will be some that have been taken under your, that your client rather has taken under IAEA authority. So if you sold assets, if you rented any property, have you paid taxes, and anything that you might have done with those independent powers has to be alleged. And how have you done it? Was it something that you needed to do with court approval? Did you do it without court approval? Did you have to file a NOPA? That all needs to be alleged as well. So we have our accounting, we have the report on the status of the estate, and now we want to distribute it. So this is a separate petition that will be part of your package. It's all in one thing, but a separate petition to distribute is one of the finite things that you'll be requesting there. And again, where there is a mandate, even in an estate that has full IAEA authority, there are certain things that you cannot do without court permission, like pay fees and distribute the asset. So that's always got to be something you're going to request. In doing so, you have to make some mandatory allegations. Again, that all the debts are satisfied, they've either been taken care of, or you have you've appropriately accommodated for those. So we always put a section in our petitions that speak to that, particularly income taxes, property taxes, estate taxes, if it's an issue. Many times, if it's an estate where there's say a single heir or it's probate of a poor will, you can say those are being satisfied from resources outside the estate because your client might have taken care of those individually out of their own pocket, or it's going to be taken care of once it goes to the trust, and the trustee will handle those. But you do need to make that allegation, and again, that's going to prompt you to talk to your client about it, right? Hopefully those are things that you've had communications with them on throughout the administration of the state, but you'd be surprised, and people, these things don't occur to people, and you can't close your estate until that's taken care of. You have to allege that all those expenses and those costs, or those hard costs of the estate have been satisfied, that you've paid your publication fees, your bond premiums, all the court fees, probate referee fees, that those have all been paid. You don't want the estate to close and then, 6 months later you get a bill for a bond premium if you haven't paid. Again, a proposed distribution and a description of who's getting the asset so that the court knows that you're adhering either to the terms of the will or that the estate's being distributed according to the laws of intestate succession appropriately. Compensation, we'll talk about that in a little bit. Your statutory fees, extraordinary fees that you need to do in order to get paid, and then watch for any local rules. Some counties, LA has some particular things that they really want to see in their petitions for distribution. How much is on hand in cash. They want that in the narrative report. Other counties don't have that. So just take a look at the local rules and see. And then here's this poor guy. Oh my gosh. They all waive in accounting, but I still have to do all this stuff. But yes, we do. You've gotten out of the burden of preparing this detailed accounting because everyone is waived. But in your report on the status, if it's a report based on waivers, the rules of court still require you to disclose all of these things, some of which we've already talked about in the same, some of which are not. Again, the creditor claims, you have to allege if there's been any sales, purchases, or exchanges of assets. The court wants to know that, and they're not going to know it unless you tell it in the report. You don't have an accounting, it's going to report it. Same in the changes in forms of assets, same with the assets on hand. They want to know that the estate is solvent. So these are all things that we can't know without an accounting. And so the court wants your client to swear under penalty of perjury that all these things have been complied with appropriately. Now, you don't need, if you're going in on a waiver of account and you're asking to be paid, and you're going to rely solely on the inventory and appraisal value as your fee base for calculating fees, you don't need to do any schedule of receipts or disbursement. If you want your fee base to be larger and include those receipts and gains, then you've got to do those schedules. And so you might as well just do the blanket accounting, right? And so it's really a matter of how big the estate is, how big is the statutory fee going to be. A simple one and done estate, a single heir, and all there is a house. I don't care if there's a little gain on it. You probably don't have a lot of time in that case. So let's just, we'll get waivers of account. I'll just base my fees on the value of the house. Every case is different. That's a determination you'll have to make as a business decision. Cost of administration, if you're requesting reimbursement, we'll talk about the base, the fee base, how that's calculated, how the fee base is calculated, and then how the fees are calculated based on that fee base. Let's get into that. I've got about 15 minutes left, it looks like. So I don't want to get into too many details here. Compensation in probate estate is broadly divided into two different categories. You get compensation for your ordinary fees and compensation for anything, or rather, let me put it this way. You get fees for ordinary services that have been provided, and you can get additional fees if you've done extraordinary service. Ordinary compensation is based on a percentage of the value of the estate. Extraordinary compensation is paid on an hourly basis. Ordinary compensation, absent some good reason, is awarded as a matter of right. You're automatically entitled to your ordinary fees. It doesn't matter how long those ordinary services have taken, you get your statutory fees. You spend an hour or 2 hours, or you spend 100. That's your statutory fee. Same for your client. It's the same fee base and the same calculation. It gets paid to the representative as gets paid to the attorney for ordinary services. There's an absolute right. There's the probate code section that is cited there. The exception is if there has been some inexcusable delay. And the definition of that is there on the slide. Basically, you've taken way too long to administer the state, and the delay was in your control, and it's been detrimental to the heir. Now, other speakers have talked about the time that we're supposed to wrap these estates up in. I spoke this morning about how difficult it is even sometimes to get your INA filed in time. The courts understand that things can sometimes delay. If you're a little bit late, it's okay. If you're going to be a lot late, you better file a status report and explain why. It is very rare for the court to punish a representative court counsel by reducing their ordinary fees. However, it can occur, and it has occurred, and You just want to keep people informed and you don't want the delay to be your fault. So that's ordinary compensation. Fees for ordinary compensation are based on your fee base, the estate accounted for. So you take your inventory value of all assets, that's off your final INA, add any gains on sale, add any receipts that have come in, deduct any losses on sale. You don't deduct your disbursements. Regular ordinary disbursements aren't going to reduce your fee base, only losses on sale. And what you end up with is your estate accounted for. That's the base on which we calculate ordinary fees. And here's the schedule. So you can kind of do the math yourself. It's around $7,000 for a $200,000 estate, which we're approaching, not even needing to probate those, because we're already around over 180. That'll be a small estate now. 2% above that, up to $1 million. 1% above that, up to $10 million estate. And then 1/2 of 1%. I've never gotten into this rarefied air up here, but that's the math. That's how it works for ordinary. Ordinary compensation is a different animal and is wholly up to the discretion of the court. There is no absolute right to extraordinary fees like there is to ordinary fees. And they make you jump through some hoops to get them. You have to do more than just allege in your petition. I had to deal with this creditor's claim, and we had a tough sale of property, and it's worth an extra $2,500. The rules of court have 7.703, a very detailed description of what you need to do in order to get your extraordinary fees paid. So there's an example of that in your materials. I don't know that we'll get a lot of time to talk about it in the 10 minutes I have left here, but that's an important part of this, and it is something that can really give you headaches and has been a topic of conversation in a probate bar about, the very high bar that we have to reach to get paid. Okay, so you're done, but you're not done, right? You filed your petition, it's come on calendar, it's going to be approved. You've got all your allegations in there, your counting looks good, your fees are calculated correctly. The judge will make an order. You will, or your client rather, will make distributions. The order for distribution has to spell out each distributee and what they're getting. So you can only really avoid that if you've got a finite set of heirs, maybe one heir or two heirs. So you just say everything goes to this guy or everything goes to these two guys. Otherwise, you're gonna have to break down how much each person is getting. We always include what's called an omnibus clause in the order, which basically says we are distributing the assets this way now, and there might be things out there that we don't know are part of this estate. And so if we discover those later, they're going to go this way too. So that handles after discovered properties that you're not aware of. Once that's done, the judge signs the order. Your client is going to make distributions of the property. How those distributions are made depends on the assets. So if you've still got your property on hand in an estate that hasn't been sold, and it's going to be distributed in kind to the beneficiaries, that's going to be done by a deed, by a personal representative deed. If there are securities that are still on hand and the beneficiaries want to keep those in kind, there's going to be some securities transfers that your client will have to do. Most typically, people want money, right? People want cash. So usually everything has been liquidated and the client is going to write checks to everyone, including you. You're a recipient from assets of the estate. The court's going to approve your fees. The distributions will be made and you're gonna make sure that you get assigned receipts from every beneficiary who's receiving something that acknowledges what they've got and they are expecting to receive. And those receipts will get bundled up and filed with your ex parte petition in order for discharge, which is a judicial counsel form that is included in your materials. Now I've got about 5 or 6 minutes left. Are there any questions about anything? Happy to answer those. If not, I can quickly review some of the materials that are in your the packet. I would probably direct you first to the accounting, which is showing up on page 203 of your materials.
Kendall, you do have one question.
Okay.
Do you see it or should I read it for you?
I do see it. If your beneficiaries have agreed to a distribution that differs from what the will or intestate succession would be, can you simply attach a consent to proposed distribution showing that they're agreeing to that? The right way to handle that would be to file a petition either during the period of administration or incorporated into the end as part of your final report, where you ask the court to give your client permission to distribute the assets in accordance with that. It might be a petition to determine entitlement to distribution. If it's an estate, it might have to be done by assignment. But in any event, you're going to want the court to approve that. These things often come as the end of litigation. And so sometimes there's a petition to approve a settlement agreement. The court will approve, kind of bless whatever everyone's agreed to. So your accounting there starts on page 203. Your schedule of opening assets, there's your charges and there's your credits that balance. You can see 0. I will 0 meaning that there's no difference between the total charges and total credits. This one, if you talk to different probate attorneys, they'll have different opinions on how the accounting can be prepared in terms of software. This is obviously just a simple Excel spreadsheet. We now use specialized software in our office, and I think a lot of attorneys do as well. There's some good programs out there. So if you do a lot of it, it's well worth the investment to use the software. Here's your schedule of opening assets. Everything is detailed there. This is going to come right from your inventory and appraisal, and there's the fair market value. And you can see at the beginning, your carry value is the same as the fair market value because it's the date of death, nothing has changed. Detailed schedule of receipts, so you can see each form of asset is detailed in terms of what kind of thing was earned, when it was earned, and how much was earned. That transfer column is there because it's showing the court that the item of income was earned on a particular asset, but then it was transferred into another asset of the estate. This doesn't, it doesn't affect your charges and your credits, and you don't have to show it. When we used to do our accounting through Excel, we kind of had to make it work and balance. There were no gains on sales in this estate. And then a detailed schedule of distributions, and you can see, the dates of everything that occurred, what it was for mortgage, was it for entertainment, those kinds of things. So what account paid it out from, where was it dispersed from. We did have a preliminary distribution, order for preliminary distribution, so that's one of the schedule that is included here. Rather, schedule of property on hand, and this was all cash or assets that hadn't changed in fair market value. We still had the house on hand, and nothing much had changed, so it was the same. This has a very simple schedule of changes in assets that you can see. That's where the dividend reinvestment came from. So that's how those get reported. There is an order here for you to look at as well. I have also included an accounting, or pardon me, rather a report on waiver of accounts. So you can see all those things that you're required to allege in the report on a waiver when you don't have an accounting. And those are all listed there from page 225. So we go and we refer specifically to the code section and just kind of spit out the information. Both of these reports have a computation of the fees, how we got to the fee base, and how the fees are calculated. And then finally, towards the end of my material, there's a simple receipt, and there's your ex parte petition and order for final discharge. So that's a lot that I've thrown at you. I hope it's been helpful. I hope that you guys have enjoyed the program and that you've gotten something out of it. And I thank you for having me.
We'll now move on to our final speaker in our ethics portion of the program. We have Christine Barado, and I'll turn it over to Christine.
Hello, do I have my speakers on my computer so that everybody can hear me? My former computer died, so I'm getting used to this one. It's lovely, but okay. I'm going to speak on ethics. I think it's because I went to a Catholic primary school. I often am asked to speak on ethics. And the first topic today is breach of fiduciary duty. And in a probate situation, depending, of course, on who your client is, but particularly if you have been asked to represent a person who's petitioning to be the personal representative of the estate, then both you and your client have fiduciary duties of a variety of kinds. The client, well, first let's talk a little bit, the elements of a breach of fiduciary duty for any fiduciary are, first of all, the existence of a fiduciary relationship. Second, an act or omission by the fiduciary that's considered to be in breach of that duty. And if you were going to have a lawsuit, you would need damages. In a situation where we're not necessarily looking for a lawsuit or hoping for a lawsuit, you don't need necessarily to have damages. The person probably will be damaged or hurt in some way by whether it was the attorney who did the breach of fiduciary duty or the personal representative. And one of the things is that as an attorney, you owe the fiduciary duty to your client. And there are a variety of sort of sub-duties, as I think of them, that come under the umbrella of this duty and duties that we owe to our clients. You have to be competent, you have to be loyal, you have to keep things confidential. And one of the ways, if you are representing the personal representative, that you are going to fulfill your duty to her is by making sure that when she acts and goes about her duties in the administration of this estate, that she understands enough and is able to and does fulfill her fiduciary duties to both the estate and the beneficiary. A lot of the time, the person who's the personal representative, whether it's executor, administrator, either of those things, your client is probably going to be a lay person. Not always. There are more, I see more people who use private professional fiduciaries these days in their estate planning, which means you have a person, if you are working with that person, they're going to have a lot more knowledge of what they're supposed to do. But I'm giving this lecture based on the fact that we're working with a lay person, not that lay people are bad, but they simply don't know as much. They're not attorneys, they're not an accountant, they're probably not going to be familiar with what a fiduciary is, what the duties of a fiduciary entail, and the obligations and duties that the personal representative has to perform in a probate might well seem pretty overwhelming to them. You want to make sure at the initial interview that your client understands everything that the job is going to entail. They need to understand that it's more than just, I'm the queen of the probate. I get to tell my brothers and sisters what to do, how it goes, and then at the end I get paid extra. Woohoo! I've had those situations and had to have heart-to-heart talks with my clients explaining, no, honey, you're not a princess. You don't get to order people around. This is actual work. That's why you got paid extra for it. And a good place I found to start with my clients, rather than try and teach them so much that they could be an attorney and give courses to other people on fiduciary duties, is to sit them down with Judicial Council Form 47, which is the one that you have to fill out at the beginning before you can get the letters and file it with the court. It's called the duties and liabilities of the personal representative. And it has a lot of the stuff, well, most of the things that the personal representative as a fiduciary is going to have to do. And it gives them, it doesn't go into super detail, but it gives them enough detail, and I think a fairly good overview. It's certainly a good jumping off point. I find it's helpful to sit down with that form with my clients, or to scan it and email it to them if they're not able to come down to my office, to go over with them the basics that are on the form, see what questions they have, and elaborate. Because one of the things sometimes people don't understand is that you can't, and it's a thing that is common. I've seen it done commonly. So I've talked to people a lot about it at the first date, is you can't commingle the money. I can't take the money, mom's money from the estate, and just put it in my bank account, even if I'm not planning on stealing it from my brothers and sisters. I'm a perfectly honest person, and I'm going to keep records on it and stuff. The law says no. We have to keep it. I'm a fiduciary. I'm the personal representative. I have to keep it separated from my personal stuff and open an account for the estate. And during the interview, one of the things you want to do is get an idea of, is this a person who's going to be okay with following the rules they're going to have to follow? Are they going to be too overwhelmed? And sometimes people aren't bad, they just are so overwhelmed. You may have to spend a lot more time, do a lot more hand-holding to make sure they know what's happening. And I find it's good to have a checklist of stuff and periodically check in with them and see, how are you coming along on gathering up the assets of the estate? Obviously, if there are things like mom's house, that's pretty easy to gather. Sometimes it can be a little harder to find other things, accounts that are hither and yon, and a variety of stuff that might be, if mom didn't do her paperwork well, it can be a little harder. And I'm just fine checking in with my personal representative periodically about all the different things that they have to do. At the beginning, I also try and give them a timeline, an idea of, these are the steps that are going to happen during the state administration, so that they know, and I know you can get a sense beginning, is this somebody who's going to need more hand-holding or less hand-holding? My favorite one recently was a friend of mine who worked as the office administrator for an attorney who was a friend. She was great. She didn't do any probate stuff, but she understood all the legal concepts, and she also did all this bookkeeping, so it was like, she had the skills that I wish every personal representative would have. It made my job much easier. You, as the attorney, also owe a fiduciary duty to your client, as we said before. And in some cases, the clients who are the personal representative have this duty to the estate and to the beneficiaries. They can't say, well, I want more. They can't favor themselves as a beneficiary over the other people, clearly a conflict of interest. They can't say, I like this sibling better than that sibling and favor the one beneficiary over the other. Because one of the big things that the scope of the fiduciary duty includes is the duty to avoid conflicts of interest regarding the estate and regarding its beneficiaries. Both the client, if the client knows that they have and realizes they have some kind of conflict of interest, you need to speak to them and say, is this going to mean it's going to be difficult or nigh unto impossible for them to do their job? In many cases, it's the kind of thing, just like an attorney doing joint representation, where if the person discloses it and lets everybody know and makes provisions not to do something wrong because of this conflict of interest, they'll be able to do their duty appropriately. Things that the attorney owes the client under the fiduciary duty, sort of a list of a lot of the things that we must do as attorneys and the rules of professional conduct towards our clients. We do owe our client, and this comes under that umbrella of fiduciary duty, a duty of confidentiality, a duty of loyalty, and the duty of loyalty includes or involves, among other things, avoiding conflicts of interest, or, like we talked about for the administrator, the personal representative, you must do if there is a conflict of interest and you believe it's one that under the statute is waived, under the rules is waivable, you have to do proper disclosure and consent. And you must act with confidence. A breach of fiduciary duty is not only a violation of our rules for which we can be disciplined, but it also could be the basis for a lawsuit for fraud, for breach of fiduciary duty. Usually, these kinds of rules are enforced by the state bar court. But like I said, it can be, and depending on the nature of your conflict or the nature of the breach, it can be the basis for a lawsuit. According to the professional rules of conduct, they were not intended to create new civil causes of action. However, because basically violation of almost any one of these rules is considered a violation or breach of your fiduciary duty, violation of the rules can support a lawsuit. So something to think about, why we want to keep the rule, why we want to know the rules, and why we want to follow them. So we not only so we don't get in trouble, so it doesn't cost us money, and you're just representing, especially in the areas of competence in some of the conflicts. I think we're doing a better job of representing our client, which is what we're supposed to be doing. And then they pay us for it. That's nice too. But duty number one is to be competent and represent your client in an appropriate way. It's interesting. An attorney, while you do not have an attorney-client duty towards the beneficiaries, we are considered to have a certain amount of a fiduciary duty towards the beneficiaries. And we certainly cannot help our clients do something inappropriate. Like I said, usually the rules are enforced by the state bar, but violation of the rules are also, and the California Supreme Court has ruled that violation of any ethical rule is a violation of the attorney's fiduciary duty. And for the person who was just hired, I was just doing what my boss told me to do, is not considered a defense. There are cases on that. Your personal representative, because of her fiduciary duty, has a duty to use ordinary care and diligence in the management and control of the estate. This is the standard set by Probate Code 9600. What constitutes ordinary care and diligence, obviously, is going to depend on all the circumstances of a particular estate. It's basically, I think of it as a case-by-case kind of thing. Whether or not fiduciary duty has been breached is a real fact-intensive kind of question. And this standard about all the circumstances is under Probate Code Section 9600A. And even when a breach is shown where the personal representative acted recently, rephrase that, I think the timing of that was wrong. A personal representative can actually have a situation where they breached their fiduciary duty. However, if they acted in good faith under the circumstances, the court may, in the furtherance of equity, excuse the fiduciary from liability. This is Probate Code Section 9601B. So it's really important that the client, this is why I think it's really important that the clients understand from the get-go what their duties are and that we try and help them act in the right way. If they are doing all the stuff they're supposed to do, or at least they're trying to do the stuff they're supposed to do, and something bad happens under this standard, the court may forgive them, which is a good thing in my book. Also, an attorney who helps a fiduciary breach their duty may themselves be subject to lawsuit, as well as the client. Hypothetical, a personal representative in an estate. The estate suffers losses on the sales of security, even though the personal representative consulted a financial advisor or broker after carefully vetting people like that in her community. Will Polly, the personal representative, be liable for breach of fiduciary duty? No. Under the case of estate of Barbacus, the personal representative is not liable for losses to the estate by loss or destruction without his fault. And if the person has done what they're supposed to do, I'm thinking lots of people probably got dinged who invested in things right before the crash back 15 years ago, and I'm guessing a lot of them were forgiven. I myself had a client who the family home, just the timing of it went down. They were not dinged as a breach of fiduciary duty for that loss. Who knew? You can't control when people die. You can't control what the market and the economy is going to do. If the attorney Polly hires, this one is probably more obvious, steals from the estate, Polly is not going to be found in breach, assuming that she also vetted the lawyer. If you're trying to find somebody who's good, trying to do the right thing, you're generally not going to get dinged. There are exceptions to this as to every rule. And so much for breach of fiduciary duty. And I apologize, I know some of this stuff is dry and boring. I feel like I'm always speaking on dry and boring, and now we come to avoiding conflicts of interest. This was back under fiduciary duty, one of those duties, umbrella of duties. It's pretty important in terms of acting as a fiduciary is to avoid conflicts of interest. Because you have a duty to your client, and if you're busy with conflicting duties and conflicting interests, you can't do right by your client, or you often can't do right by your client. When you represent the person, you want to make sure that you generally know what is going to be the scope of representation for your client. And that means you need to know, in order to avoid the conflict of interest and know the scope of representation, you also need to know who the client is. When you're representing the personal representative, it's especially important to understand this and to talk about it with your client, because a lot of attorneys don't do a written contract for the fee agreement because you don't need to do that for statutory fees. California Evidence Code Section 951 defines a client as an individual who consults a lawyer for legal services or advice. California case law expands this, of course it does, saying that you need to look to the totality of the circumstances and the reasonable expectation of the person in the possible client's position and the conduct between the attorney and this person. And this means that unless you're careful, I mean, even sometimes if you are, but unless you are careful, an informal lawyer-client relationship can come into being, even though there isn't any formal contract, there isn't any payment. This is what I think of and call the cocktail party client, where somebody comes to you're at a Christmas party or whatever, Christmas party, birthday party, etc. Somebody comes over, oh, Jim, you're a lawyer now, aren't you? Well, I just had this question about blah, 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 blah. And what you want to say to Jim is, Jim, it is so great to see you. Here's my card. If you want to talk about that, if you want me to answer your questions and talk about blah, 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 why don't you call me at my office next week or whenever? This lets Jim know that you're not, lets Jim know a couple of things. No, I'm not standing here drinking eggnog and you're drinking eggnog and giving out free legal advice. This is actually what I do for a living. Plus, it's not a really good at a party. It's not really the greatest situation. A lot of people are drinking. Who knows what they're going to remember, what they're thinking. It also helps prevent, if you do have a little line that you do every single time. If it comes up at some future date, you can say, no, it was my common practice, habit, or custom to always give people in informal situations like this my card and explain to them, no, I'm not going to answer this now, but what if you want to talk about that, why don't you call me at my office next week and we can talk about it then. And this should hopefully help you avoid the cocktail party client, because it can prevent malpractice claims, it prevents discipline, it prevents unhappy clients who aren't really clients, or you didn't really think they were clients. That was not what you were contemplating. And another important consideration in determining who your client is from the beginning is that avoiding conflicts of interest. If you are representing the personal representative or other people in an estate, a lot of the time there's a whole, sometimes there will just be one person, but a lot of the time families involve more than one people, more than one person, more than one sibling who's going to be coming to. One person might be sibling or child might be coming to you. They're named to be the first choice of executor in mom's estate. You may know the other people, the other siblings. You want to make sure that if you suppose you wrote mom's will, suppose you represented mom and dad and they had a business. You want to make sure that if any of these things happened in the past or are currently happening, because you knew everybody in the family, you did stuff for Polly, the personal representative's brothers and sisters, you may still be doing stuff for them. You want to make sure that right from the get-go, if Polly is going to be your client, you need to explain to Polly about the potential conflicts of interest. And you also need to probably, often, you will need to get not only informed written consent and waiver of the conflict, but from Polly, but you will probably and often need to get it from the other siblings for whom you might have done something. If there's a continuing business, you might need to get it from whoever is the representative or the controller or the current owner of the business. And the rule under the updated as of 2018 rules of professional conduct is professional rule 1.7, conflicts of interest, current clients. It's very long. I will not, it is in the materials. I won't read all of it to you, except it says basically that if you're going to represent somebody and there might be a conflict with a current or former client, that you need to get informed written consent. You also need to be careful to make sure that, and this is a quote from the rule, the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. Probably in a probate estate, this is not going to happen, at least at the beginning. Down the road a piece, if things get ugly, hey, everybody might be suing everybody else. But generally it's not going to be happening at the beginning in that kind of a situation. And I also have, there's several pages where I have the rule and the comments. I also want to, and I have, if when you do this, the informed written consent and waiver with the current client, the one who's coming to you, any current clients, any former clients, you'll do it at the beginning so that your representation of the personal representative is all legal and good and ethically done. The rules also note that if there is a material change in the circumstances relevant to application of this rule, that you might need to make new disclosures, and you might need extra written consents. In some cases, if it gets really ugly, you might have a situation where you might need to withdraw, although, knock on wood, I haven't had that happen. Well, I used to do a lot of criminal defense. I had it happen in weird criminal cases, but you know, generally the people who come to me for probate don't want to put on perjured testimony. So it hasn't been an issue. In other cases, the attorney may have, like I said, you may have represented a variety of people for whom there may be a potential conflict of interest with the personal representative. You might have an issue where you are asked to represent somebody other than the personal representative, and you have a conflict with other people in the probate estate or with the probate, with the personal representative, your client. So you want to do the informed written consent there. I have in the materials a sample waiver of conflict of interest, and it talks about, you know, most of my clients, a lot of them are like, oh, but we're all family, this won't happen, blah, 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 blah. And I explain to them, I have to do this. This is one of those crazy little attorney rules that I'm required to do. And in case anything happens, I'm protected, you're protected, everything is good. And we never know what's going to happen down the road. It explains in here, and you want to be sure that you explain it to the client, because it's not just written consent or waiver. It has to be informed written consent. And I think this means that the client has to actually read it, which is why after each thing, like duty of loyalty, which then flips on to the next page, understanding this, we give up and waive our right to this duty of loyalty as to each other with respect to the above described matters. their little initial places, duty of confidentiality, and I explained to them what this means. One of the things that I try and do, because sometimes it seems very serious and kind of dry as dust, I explain with the duty of confidentiality that if either one of you comes to me and you want me to keep something silent that pertains to mom's estate, I'm not going to be able to do that. If you come and say, oh, I know mom had this extra money or jewelry or whatever, and only I know about it, I can't keep that from the other people. On the other hand, if you come in and you tell me, yeah, several years ago when I was drunk in college at a party, I accidentally killed somebody, and you want me to keep that confidential. Your murder, I can keep confidential. Mom's jewelry, with respect to the estate hidden jewelry, no, I can't keep that confidential. I'm sorry. So I go over each thing with the people and give them an example and explain to them what it means and what they're giving up. Because I figure unless I talk with them about it a little bit and make sure they have read it, I'm not sure that they actually understand. And then I ask them if they have questions. Some people do. A lot of the time they're just looking at it like, gosh, this is so boring and stupid, and I'm sure this is never going to come up. Oh, well, it is a thing we as attorneys are required to do. So I like to do it. Excuse me. So, okay. Now, the next one is attorney-client privilege. One of the things, and this is one of the parts of our fiduciary duties, it's another duty under that umbrella of fiduciary duty, is attorney-client confidentiality. California Evidence Code sections 912 to 920 deal with a variety of privileges, waivers of privilege, and various other matters relating to statutory privilege. The attorney-client privilege is laid out and dealt with more specifically in Evidence Code sections 950 to 962. Under Evidence Code section, and this is in the materials, 953 and 954, the attorney-client privilege of a natural person, interestingly, or maybe not, transfers to the personal representative after the client's death. It also excuse me, allergies, sorry. The evidence code specifies, and there's also some case law interpreting this, that the privilege survives the client's death as long as there is a personal representative or other similar person to claim it, and as long as the estate is being probated or their claims brought by or against the estate that are being adjudicated or negotiated in some way. Now, the personal representative has the right to assert, because it survives as long as they're doing something about the dead person's estate, that privilege that survives the personal representative and or the attorney. The attorney can and usually has a duty to assert the privilege unless the client has already waived it for some reason, or unless you're specifically directed to do so by a court. The personal representative has it as long, like I said, as long as the estate is being administered. Once the estate is no longer there, most courts in California has decided that the estate administration is done, there aren't actions happening, the personal representative has been discharged, it no longer exists. Basically, there's no longer a need for it. California Business and Professions Code goes beyond the concept of privilege, and the B&P Code requires even some matters that might not be considered to be privileged to be kept confidential. Business and Professions Code 6068, and it is the duty of the attorney to maintain inviolate confidence. I love this, at every peril to himself or herself, to preserve the secrets of his or her client. I've had people try and bribe me occasionally for stuff. I've actually never had anybody threaten me, so I don't know how common that is. That at every peril. The B&P code and the rule of professional conduct 1.6 talks about confidential information of a client. And once again says a lawyer shall not reveal information protected from disclosure by the B&P code 6068, subdivision C1, unless the client gives informed consent or the disclosure is permitted by paragraph B of this rule. And that rule, the paragraph B, and a bunch of stuff surrounding it is basically the attorney equivalent of what we call the Tarasoff liability. I don't know. I think that is something that comes up more in criminal cases or family law cases. I don't know. It could come up, I suppose, in a probate case, although it doesn't seem very likely to me. That's where if you have a reasonable belief that someone is going to do great bodily harm or kill someone, and you really, really believe it's going to, you have reasonable basis for your belief, it's more or less imminent. The rules say that you should try and dissuade the person. But if you believe you can't dissuade them, or you try and you can't dissuade them, then you can disclose confidential information, but only as much as needs to be disclosed to prevent the harm from occurring. Now, okay, hold on. If a personal representative, a lot of the court cases have talked about, and there are situations where you have one personal representative and that person has to resign or gets removed. They're no longer the personal representative for one reason or another. And you have a successor personal representative. When, if ever, is the successor personal representative covered by the attorney-client privilege? Say poly representative consults you about several matters relating to the estate of her mother who's passed away, and who your firm represented in drafting her estate planning and her will. Holly wanted advice about several matters. She's named in the mother's will as the executor, and she discussed this with you. She also had several other matters relating mostly to her mother's probate that she needed your advice about, but some were of an entirely personal nature. So Holly hires you for all these matters. And obviously, she's going to have a very difficult time. Well, let me jump ahead. Holly has hired you for all these matters. If it becomes an issue at some point and Holly's health, saying, mandates that she resigned, the question is, will sister successor be able to invoke dead mom's privilege for matters that Holly discussed with you? Yes, but to those matters entirely related to the probate, yes, definitely. As the successor personal representative, maybe to matters that were partially related to the probate. Maybe Holly consulted you about what she's supposed to do in her dual roles as personal representative and beneficiary. And it wasn't just me, beneficiary. It was something about, how should I act? How should I conduct myself? What should I do? And you explained to her about, you have to be, there are other beneficiaries, you have to be impartial, you can't give yourself more. That probably is going to get protected. she asked you about matters, or she had also consulted you about matters that were entirely personal and just somehow tangential to this whole thing. No, the matters that were entirely personal, the sister successor is not going to be able to claim the privilege of dead mom as to those. And the case is Mueller versus Superior Court. The court held that a successor fiduciary may continue to hold the privilege, but the limitation on this is if the prior fiduciary consulted the attorney for personal matters as well as other estate matters, the successor only holds and can only claim the privilege for the estate matters, not for the personal consultation matters, which basically makes sense. But at least to me, it makes sense. Okay. Now, excuse me. Do apologize, allergies. Lovely other attorney in my office came in and she had a lovely client who had perfume that makes me cough and sneeze. So now, and this is one where I always find it very interesting. And the young lady before me talked about this a bit because she was doing the closing petitions for the estate. This is usually everybody's favorite. How do we get paid? What are the rules? What's the amount? Stuff like that. Fees and fee agreements. As she explained, the basic statutory fees for probate, unlike a lot of other situations, most of the time, because of the amount for which you're going to have, you don't need to have a probate if the fees, every time you're going to have to, your fees are, the amount of the estate is big enough to cause the folks to have to go into probate, your fees are going to be well over $1,000. Normally, under Business and Professions Code 6148, you would have to do a written fee agreement. There are certain exceptions to that. And one of them is basic statutory fees for a probate. No written fee is required, even though, like I've said, even the smallest estate, you're going to be, at least 3,000 plus in terms of what your statutory fees are going to be, which normally would kick in that $1,000 requirement, but no. And there's a case on this, the case of Wong versus Bressler, 2012, 207 Cal 4th, 366. The court opined that no, it's statutory fees. You get it. You don't have to do any kind of a written fee agreement. I think it's often a good idea for a number of reasons to do a written agreement, even if you just anticipate that all you're going to be doing is just the statutory ordinary fee. One of the things that you can do with a written agreement is you can delineate the scope of representation. In other words, you want to make sure that your client doesn't have some idea that you are going to do more work than you are anticipating. In other words, go way beyond the closure of the estate and the discharge of the personal representative. Some people have an idea. I'm not sure where they get it from. I'm guessing TV or the internet. We can blame all these silly ideas nowadays on the internet. It used to be just TV, now it's the internet. But people have this idea that you are going to do all kinds of other stuff that you aren't necessarily going to do, that the description of what our duties are in these kinds of situations don't require us to do. But people have this idea that it's going to go way beyond. Some people figure, oh, you're doing this, you're my attorney. Not forever, just for this. And by doing a written agreement, you can specifically outline, I'm going to do this, it starts here, it ends here. so that people don't have this idea that it's going to be more than it really is going to, than more than you're expecting or intending to do. You can also, in addition to limited, if they want you to do something above and beyond, that's going to be after the probate is closed and the discharge is done, you can either limit it and say, you can explain to them, no, I'm just going to do this. And if you want me to do other stuff, then you're going to have a separate fee agreement for that. And that's a separate representation. So that is clear. So we don't have any unhappy clients floating around. It also gives you the chance, and I think because a lot of people are surprised by the amount of the statutory fee, it gives you a chance to let the client know what's covered by the basic statutory fee so that they can see all the different things you are going to do. And it also lets them know what the amount of the statutory fee is going to be. No surprises. I do not like surprised clients, that at least, well, I like clients who are surprised because I've done such a great job. Because I worked out all kinds of problems, because I made all the warring siblings and beneficiaries get along, come together, hold hands and sing Kumbaya and save the estate time and money. I like that kind of surprises. I don't like it when clients are surprised and saying, but I don't want to pay you that. You didn't do anything. Thank you. Just the liability that you take on in an estate, even a relatively simple one. We're taking on a lot of liability. If something goes wrong, and the client gets angry, we are going to have to defend what we did. In this respect, be sure you keep lots of notes and documentation. There are also circumstances where a written fee agreement is needed, even in the context of going into probate for some kind of matter. Two areas. One is if you're going to get asked for extraordinary fees in addition to the statutory fees. For example, if you're doing litigation during the course of the probate and you either want and need a contingency fee, or it's not something that you do, but you want to make arrangements with the best PI person in town, and she always wants a contingency fee agreement, and you need to do that in writing. And that's step number one, written agreement must be drawn, plus you must get the court's approval before you do it of that agreement and fees. If the will, good thing to know, if the will, and some of them do, limit the attorney's fees or the personal representative's fees, well, you can only make $500. I want you to hire your brother Jimmy as the attorney, Susie, and you can only pay Jimmy $500. Probably Jimmy and Susie are like going to be going, no, this is a horrible mess. I'm not doing it for $500. However, you can go into the court and petition to have these limitations removed. So, other things to note, how do you get your fees? As the other attorney said, generally it happens in that big long petition for distribution, accounting, report of personal representative, the whole kit and caboodle. It generally is part of that petition to the court. You can only get your fees for the attorney and the personal representative, but you can only get your fees by court order. I always cringe when someone tells me, oh, but I borrowed, they're friends. I borrowed some, and I was like, what? I'm probably just silly, but it is a law. It is a rule of professional conduct. It's now it also specifically states we only get it by court order. In some instances, you and the personal representative, there are instances where you can petition the court to get fees before the final distribution. There are generally a bunch of other requirements that have to be met. Usually you'll have to have the inventory and appraisal in. You'll have to show that the estate is not going to be insolvent, different things. Not that you don't get paid your fees if the estate is insolvent. Happily, our fees, the fees and costs of administration, are priority debt and cost against the estate. I thought that was nice of them to do that. They're not making us work for nothing. But in some instances, you and your personal representative can petition the court and receive an order for what they call extraordinary fees. So it is good in this respect, and I will speak a bit more of what some of these things involve, but it is good because you're going to have to prove a bunch of stuff to the court. It's not just like you can petition an extra little paragraph. Me and my personal representative did really a lot of extra stuff because we had to sell a house and we had to do all this stuff. They're going to want documentation and explanations. So you want to keep some kind of a record of what you do for the client and the hours you spend from the beginning. Maybe not super detailed, although I find it can help me get an idea of what kind of cases are profitable, and just how am I spending my time? Am I allotting it well? Am I spending too much time on this? I tend to get a little off into researching stuff, which, it's interesting. It may not be the best use of my time in terms of profitability, but it is interesting. But you want to keep some kind of, or at least a basic kind of record of what you're doing for the estate and something of the hours you spend, or have some way that you can denote it. Because down the road, if you realize, oh, my paws and whiskers, I had to do this, I had to do that, I had to do the other, there was all this really complicated extra stuff, me and my personal representative should get extraordinary fees. The court is going to want documentation, and some people, because of the way they do stuff in the electronics they have, I can document a lot of my phone things with my phone. Thank you, smartphones. I'm so old, dinosaurs roamed when I first practiced law, and we didn't have this, and you had to keep really detailed records. Not always my favorite thing to do. I like research. I enjoy practicing law. I don't enjoy the business part. But for ordinary compensation, it's most lovely. It is Probate Code Section 10810 for the ordinary fees. One of the things you need to know, you can only get one statutory attorney's fees and one statutory personal representative fee. The reason I say this is if there are two attorneys working on an estate, or if there's one attorney and then the other attorney for whatever reason, you're not going to get paid twice. You will not get two fees, just one. So you have to divide that up however you want with the other attorney. Unless you get special permission from the court, under Probate Code Section 10804, now in my mind, a similar kind of thing. You can either be the personal representative and get a fee for that, or you can be the attorney for the personal representative in the estate and get a fee for that. Unless you do a special petition and get permission from the court, you cannot get paid for both. And considering that, I always consider it a nice fee, but I know a lot of people who are better business people than I am, and richer people consider these small fees. But Section 10810 talks about how we calculate our fees. And it has a bunch of stuff. 4% on the first 100,000, 3% on the next 100,000, 2% on the next $800,000. So basically, that is 4 and 3 is 7 and 16. So the first $1 million of the estate gives you a fee of $23,000. The next $9 million, next $9 million is only 1%. However, I believe That's a pretty decent fee because I calculated that if your estate is $2 million, your fees will be, if it's 1 million, it's 23,000, $1.5 million, 28,000, and I guess lots of houses where I live in Silicon Valley are $1.5 million. If it's 2 million, lots of houses here are now $2 million. I don't know how anybody buys a house. Your fee will be $33,000. So that's how you calculate the statutory fee. And the section of the probate code that has it. If you want to get extraordinary fees or ordinary compensation, like I said, it seems pretty good to me, but there are situations. I did one relatively recently where I probably should have asked for and gotten extraordinary compensation, but it was just one of those situations where I didn't. Ordinary services, get your ordinary compensation. Ordinary services, the kinds of things that are considered included in ordinary services. And it's identical, the fee is identical for the personal representative and the attorney, interestingly. This compensation is for performance of what they call the ordinary duties of collection, care, and preservation of estate property during the entire administration. They don't really have any really great statute on what they are. However, I will get to stuff about other things that they're kind of not in a way. It is also intended to cover incidental expenses such as photocopies, local telephone calls, postage, computer research, local travel and mileage, and secretarial or clerical services. The personal representative can petition the court for reimbursement of additional expenses such as travel to attend to a state business. And you might have a long way to go or something, unusual things. And generally, ordinary services include services performed in locating and assembling estate assets, paying claims, collecting rents, leasing property, accounting and making payments necessary to complete the administration. If your personal representative chooses to employ somebody else to perform the services that usually he would do, the fees for those services are going to be charged against his compensation. In other words, he's not going to be able to say, well, I'm going to sign on the dotted line, but I'm going to hire other people to do all this stuff. Pay me and pay them too. No. For example, this is a good example, I think preparing the final accounting is considered part of the representative's duties. So if the representative hires an accountant to prepare the accounting, the accountant's fees are going to be paid from the representative's ordinary compensation. This was a ruling under the estate of Billings. There are some stuff, there's not really great statutes about ordinary services. There are some cases, this is one of them. Some of the ordinary services for the attorney, meeting with the client to review the paperwork, the will, the assets, liabilities and duties, beneficiaries notices, preparing the petition for special letters, as long as it's not super complicated. You can get extraordinary fees if it's shown to be beneficial to the estate, if it's contested, if it's somehow extremely complicated and time-consuming. Preparing the petition for probate, related papers for the appointment of the personal representative. The things that you always do, like ordering the publication, serving a notice of the petition to administer the estate. Extraordinary. I don't want to go too much over the time. Extraordinary compensation is in the discretion of the court. You look at California Rule of Professional California Rules of Court. I'm sorry. I'm back here with the rules of professional conduct, California rules of court, a rule is a rule, right? 7.703 talks about extraordinary compensation. And it is in the discretion of the court, whether or not your personal representative or the attorney gets this. Some of the things the court will consider are the amount of statutory compensation when determining compensation for extraordinary services. And they do in this list, and that's why I said they don't tell you exactly what they are, but they tell you in a way that they're not, because they give in this rule of court examples of extraordinary services by the personal representative and also examples of extraordinary services by the attorney. And they say it's a non-exclusive list of activities for which extraordinary compensation can be awarded to the attorney for the personal rep. Legal services in connection with the sale of property held in the estate. Services to secure a loan to pay estate debts. Litigation undertaken to benefit the estate or to protect its interests. That sometimes, if you're doing that, can be really a lot of work. Defense of the personal representative's account, defense of a will contested after its admission to probate, successful defense of a will contested before its admission to probate, successful defense of a personal representative in a removal proceeding, extraordinary efforts that were needed and used to locate estate assets, and just a variety of stuff. And they talk about contingency fee agreement for extraordinary legal services, that the attorney may agree to perform extraordinary services on a contingency fee basis, but like I said before, it has to comply with section 6147 of the BNP code. The court must approve the agreement in the manner provided in probate code section 1011C, based on findings that the compensation under the agreement is just and reasonable, that the agreement is to the advantage of the estate, and that the agreement is in the best interest of the persons interested in the estate, and the absence of an emergency or other unusual circumstances, the personal representative has to get the court's okay before they do it. Most of the ones that I have seen involving litigation where there was a reason to sue someone on behalf of the state in a way, in a kind of case where usually there were contingency fee agreements, and generally were in the best interest of the estate, because usually you were suing for something where you were going to get a nice extra pot of money for the estate. In my world, that's definitely a thing I consider for the benefit of the estate. If you use paralegals in the performance of extraordinary services, they talk about, they describe the qualifications of the paralegals. So the description must state that the paralegal acted under the direction and supervision of the attorney, satisfies the minimum qualifications in P&P Code section 6450C, and also that the total amount, you have to demonstrate that the total amount requested for extraordinary services of the attorney and paralegal does not exceed the amount appropriate if the attorney had performed the services without the paralegal's assistance. If you're doing extraordinary stuff, I'm guessing most of the time the paralegal is probably going to be saving the estate money. So some of the situations in which you will definitely want to be doing a written fee agreement that are not for the statutory fees are when you're not representing the personal representative. You are representing someone who's maybe a beneficiary and they have some interest. They want to make sure they're protected. So maybe you do an hourly agreement with them. They might not be wanting to fight anybody. They just want to know. They want to know, what's this all about? What are the duties of Holly, my sister, who's the personal representative? I want you to look over the will, blah, 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 blah. you may do a flat fee, you may do an hourly, but you probably are going to want to do a written agreement with them. Sometimes you also, if you're doing a spousal property petition, if you're doing a Hagstead petition, if you're doing a petition to determine succession to real property, all these things, sometimes it's going to be an hourly fee, sometimes a flat fee. Almost always, if it's going to be something where you're going into court, you are going to be needing to do a written fee agreement, because 6148A of the B&P code says if it's going to be $1,000 or more, it must be in writing. And that includes not just your fees, but the fees and the costs and the charges. And nowadays, you're looking at well over $400 and sometimes close to $500. 435 filing fee. In some counties, there's an extra little fee tacked on. Plus, in my county and with my e-filer, we have mandatory e-filing now. To that 435, we add on an extra $15, so that's $450 right there. Then at some point in time, you are probably going to be wanting to get a certified copy of the order. I know if I'm doing something spousal property petition and it involves real property, I'm going to need a certified copy of the order, because I'm going to need to record that in the recorder's office. So that's going to be at least $25 and probably more like $35, because the basic fee is $25, and then there are these little added fees for pages and copies and different things. So that's what we had, $450, and 35 is $485, and then you're going to want to go record it at the recorder's office, even though generally speaking, you're not going to have that extra little $75 that they have for the Housing and Jobs Act, because usually in a spousal property petition, it's the spouse who's also the homeowner living in the home. She can fill out that declaration. I don't have to pay the $75 because this is transferring it to the resident homeowner. The recording fee in my county is generally somewhere between $38 and $45. So now right there, you're over 500. If your fees are like not very much, 15 hour, you're over 1,000. So, okay.
Christine?
Did I go over my time? I'm sorry.
Yeah, so we're 5 minutes over. So if you could just share some final thoughts, that would be awesome.
Well, my thought is you want to put most stuff in writing. I started it for a long time because the law did not require it. I didn't put the statutory fee stuff in writing, but I decided I wanted to make sure that my client understood the scope of representation. And I also thought about the fact that it gave me a reason to not have them surprised at the end. I hate ugly surprises. And that's basically it. Do people have questions? Oh, could you give them could I give them my email? Where I'm not sure how to manipulate this thing to write down my email for them. If they have some specific question they want to email me about.
Oh, it's not. Oh, boy.